least they're laughing.
So we've been able to say that outside. I was wondering.
Did you go to Process?
Sí.
It was 3 years old.
Cheque cortas.
I'm trying to control for that too. That's one of the ones that as a panelist?
Go ahead and accept the panelists.
Pensé si veníamos juntos, pero igual.
Yo también, pues, o sea, nunca me contrataron.
Claro, yo igual.
It does say that panelists can sit.
Miami a la tarde.
These are the ones.
Y ayer, ¿a qué hora salía?
9 de la noche.
Muy 8:40, pero después estábamos
You're seeing something else and ladies, congratulations to you. And I'll put on my shirt.
Claro, yo igual viernes en la tarde noche.
Well, welcome everyone. I wish I could be greeting you on a beautiful sunny day. But I'm afraid we're going to be working for the whole day, so that's okay. And then tomorrow, it'll be sunny and we can go outside. So that. I'm Sherry Diamond from Western University Law School and the American Bar Foundation. And my colleague here is Valerie Hans from Cornell University. We are also have online almost 200 people who have signed up, registered to listen to what's going on here. So we're really excited about that. We're lucky to have two sponsors for this event. One is the American Bar Foundation, and that is where we will be having the reception at the end of the day. And at the reception, the director, Mark Suchman, will be there to welcome you, give you a formal welcome at this time. But for now, I'm deputized to welcome you today. But we are fortunate to have this morning with us the Dean of the Law School here, the other sponsor of our event. And so I'm delighted to introduce Dean Harry Osofsky, who is the Dean at Northwestern.
Thank you so much, Professor Diamond. Good morning. I could not be more thrilled to welcome all of you to Juries in the Americas Variation and Change Conference here at Northwestern Pritzker School of Law. Es un honor y placer. Bienvenidos a este simposio. And just so wonderful to see you all here today. I'd like to acknowledge and thank the many people who made this event possible. I know that Professor Diamond is doing the more extensive thank yous, but I at least wanted us to acknowledge the conference organizers, Sherry Diamond, the Howard J. Trenitz Professor of Law at Northwestern Pritzker Law, and Valerie Hans, the Charles F. Reichland Professor of Law at Cornell Law School, for their tremendous organizing work. I also wanted to give a big thank you to Mark Suchman and the American Bar Foundation, and also the incredible team represented by such wonderful leaders here from our law school who's been supporting the event. As I said, I promised Sherry I'd let her do all the individual thank yous. But Northwestern Pritzker Law could not be more excited to present this conference in partnership with the American Bar Foundation. Because it truly could not be more timely. Juries are a core part of a democratic legal system. And the work that you're doing today is critically important to that, right? I mean, I as I look at the topics that you are going to be talking about in this conference, right? Choosing a jury system, choosing jurors, the construction of a jury trial, reaching and reviewing verdicts, and beyond the verdict, from a much needed comparative perspective, right? These are the topics that are absolutely critically at the heart of this process. And so I really am incredibly grateful for this comparative dialogue that is so critically needed. The empirical research being done today, being shared today to evaluate changes as courts consider new systems such as the new jury systems in Argentina, and we're lucky enough, it sounds like, to have one of the key people who's helped to think about how to do that, right? And new procedures such as the elimination of peremptory challenges in Canada and Arizona. This kind of thinking is even more critical at this moment in society. I don't need to tell anyone in this room that this is a moment of tremendous challenge for our entire legal system and for higher education. And law schools and lawyers have, I think, a crucial role to play, an ethical role to play in addressing the important societal challenges through collaborations like this one, and more broadly in supporting the rule of law, particularly as the challenges continue to accelerate. In addition to this important law conference, we're partnering with law schools around the country and world to address the rule of law. In early April, I reached out to US and foreign law deans to explore how we could work together to make a difference, and we're now at over 150 law schools from 6 continents collaborating on a nonpartisan rule of law global academic partnership. I believe some of your schools may be involved, and we're moving forward with research, teaching, programming, and public education on the critical topics of judicial independence and separation of powers, the role of lawyers in legal representation, the role of universities in academic freedom and due process. And you know, it's wonderful to see faculty from around the world beginning to get involved in thinking about how do we actually do something constructive in this moment. We're really proud of this law school. We're proud of this law school to prepare future lawyers and judges and legal professionals who serve society. We're really proud to support the kind of cutting-edge interdisciplinary research that Professor Diamond embodies in her work and in the way she's collaborated between our law school and ABF, and this just absolutely groundbreaking work that she's done in this field, as you know. We could not be more honored and thrilled, particularly at this moment, to be able to co-sponsor this conference. So I'm grateful to each of you for taking the time to participate and to share your insights in these crucial issues, and to really make sure that we're learning from the comparative insights. And I really hope that you enjoyed today's sessions. Thank you so much.
Thank you very much. And as promised, here are the deep thanks that should go to the important people at the ABF and at Northwestern who made this conference possible. It truly takes a village. From the ABF, Sophie Kaufman, who, by the way, happens to have to be in Argentina today. So though you've corresponded with her, she will not be available in person. Melinda Kennedy, and Ann Pikus, who I think is right back there. There she is, with help from Alexander Kosher, who they masterfully handled all of the logistics. I had no idea what was involved as we began this process. Fortunately, they did. The logistics, the communications, and the program materials, and they saw that all of your questions were answered. Truly an amazing team. We are very grateful. On the Northwestern side, Sebastian, who seems to have disappeared but was at the door a little while ago, is everywhere. He is the masterful man in charge, not only of the food that you will be enjoying, but also the signage that helped you find this difficult room to find. And he has been working with IT to make the live streaming possible. So many thanks to all of them, and I wish all of you to have such a wonderful team to work with if you ever have to put on something that needs a lot of help. My colleague Valerie Hans and I spent much of our early careers studying the American jury. But in recent years, we've learned a great deal from widening our horizons by studying in juries in other countries. The jury is not a monolith, quite the contrary. Although it always includes laypersons as decision makers, The jury can take many forms. Indeed, the characteristics of juries and jury systems have varied significantly over time and across nations. Moreover, these are particularly dynamic times for the jury, with changes occurring in established jury systems, as in the US and Canada, and new jury systems, including innovative features, as in Argentina. So it's an opportune time to seize the moment and look at the different forms taken by the jury across the Americas, and to consider how cultural and legal contexts and history have influenced these jury systems. The participants to the conference will discuss how the jury has changed and is changing over time and across nations, and what has driven and is driving these changes. We are excited to bring together first-rate scholars from across the Americas, including Argentina, Brazil, Canada, Chile, the United States, and Uruguay, to take a very close look at the systems in each of their countries and to evaluate the impact of the different choices that have been made. We hope that, and I just want to say something, we invited 24 people to participate in this conference. And one person couldn't come. So the 23 people here who are presenting are absolute top first choice presenters, and we are so glad that they were able to join us. It's really remarkable on all sides. Well, we hope that this cross-national and approach will inform and energize jury systems in all of these countries. Our goal is also to identify missing pieces of evidence that need some further investigation, and that's what our last session of the day will be devoted to. Just one more thing, which is for the people who are here in person, I have arranged for court tours tomorrow, and we do have a list, but it's a security list. So please check the list and make sure your name's on it if you are planning on going. I'll have that outside. Now, Valerie.
Welcome, everyone. In 2004, I was sitting at my computer, and that's 21 years ago. I got an unexpected invitation in my inbox. I was invited to give an all-expenses-paid series of lectures on trial by jury in Argentina. Of course, I thought it was spam, but it was not. It was what turned out to be momentous for me, invitation to do a lecture trip in Argentina. And that was my introduction to the ongoing debate in Argentina over whether or not to introduce trial by jury in the nation's courts. As you will see in the presentations today, many Argentina provinces have embraced the challenge debated decades ago of adopting trial by jury. And ongoing research by many of the people in this room is shedding light on what impact it is having on juries themselves and also the broader system of justice. These early successes have also stimulated discussions in other Latin American countries about their prospects for change, and has also led those of us in North America, countries with many long-standing systems of trial by jury, to reflect on our own institutional design choices. So I see it as an absolutely perfect time to explore juries in the Americas. So let us begin. We are going to start today with a presentation by Sonia Kutenjak-Ivkovic, who will be giving us a global picture of trial by jury in the world. I'm gonna share screen, and it's like yeah. Slideshow. Take it away, Sonia.
Thank you. Good morning, and thank you for inviting me to be a part of this wonderful conference. I'm Sanja Kutnikivkovic, and I'm here to present a paper on juries across the world. I co-authored this paper with Valerie Hans. So this is a picture that many of you will recognize. It's a painting by John Morgan that shows members of a traditional English jury. 12 men who are deciding factual issues while the judge decides the legal issues and ultimately determines the punishment. The traditional English jury spread out by the British Empire through the colonies, and you can see here that it affected many different continents, from Africa, Asia, and the Caribbean. While South America was not as affected by the British colonization, North America was indeed affected. You can see it on the slide. So skipping to a different country. In 1748, Charles de Montesquieu, a French judge whose works actually inspired the writings of our own constitution, wrote a comparative book about European legal systems. And in the book called The Spirit of the Law, he argued for the traditional English jury system. And he said that judicial power should be exercised by persons taken from the body of people at certain times of the year and consistently with the form and manner prescribed by the law, in order to erect a tribunal that should last only as long as necessity requires. Consequently, this idea of the English jury as a standard has been used during the French Revolution. So, post-French Revolution in the 19th century, many continental European countries included the jury. And here we can talk about Austria, Hungary, Greece, Norway, Portugal, Russia, and Spain. And interestingly, in Germany, which is bastion of mixed courts, we can actually have the jury happening for more serious cases. So the next step in this globalization of the jury across the world is through two different types of colonization. The first one is the Portuguese colonization that did not affect North America as much as it did affect South America, as well as the Spanish colonization that affected both North and South America. So here we are at the end of the beginning of the 20th century, and this is a period during which we have the situation that many of these colonial empires are collapsing or not as strong, and countries are gaining independence. At the same time, we have the growth of different authoritarian regimes leading toward modification of the jury systems or even abolishment of the jury systems. So fast forward several decades into the future, the end of the 20th century, remember that period, and beginning of the 21st century, we have some countries that have now reintroduced the juries or introduced the juries for the first time. So we're talking here about Argentina, Georgia, Russia, Spain, and South Korea. Okay? So in this paper, we try to explore juries on a global perspective. Okay? And rather than relying on the nominal normative definition, in other words, how the country's laws call these lay participants, we actually use a functional definition of the jury. And we say the jury is a group of citizens who decide factual issues and ultimately defendant's guilt independently from the professional judge. So in our paper, we address three different things. First, we want to see what the prevalence of juries is across the world. Secondly, is the relationship between different measures of countries' legal, political, and social environment and the presence of the jury? And thirdly, are there any similarities or potential differences across juries when you look globally? So our work is based on the global lay participation database that we previously collected. And we describe this in our 2021 book chapter. So I'm not going to bother with all of the details, I'll just give you the key things. So our idea was that we should collect the data about 193 countries across the world and 2 different territories. And for that, we used 3 different approaches. First, we followed what prior scholars have done, which is we've done a number of expert surveys. So between 2007 and 2019, We've done a number of those, eventually got responses from about 200 people covering 98 countries. Then we used existing surveys, in other words, surveys by John Jackson and Nikolai Kovalev, Neil Widmer, and eventually Stefan Boyd, so that we can complete the data for additional 52 countries. And for the remaining 60 countries or so, I spent long hours in the library trying to dig through and find answers about their jury systems. Because this paper is primarily based on discussing juries, we've also done some additional research in order to provide more information about the juries. And the passage of time from the 2010s, when we collected most of the data, until today, means several things. First of all, some countries have abolished the juries. Right? Things have changed. Secondly, more information is now becoming available. You can find criminal codes, criminal procedure codes for many countries in the world. And thirdly, the power of artificial intelligence. We can now easily translate documents from almost any language into English in like 2 minutes, which is remarkable, okay? So let's now look at our results. So what is the prevalence of the juries these days, okay? And we found that juries are involved in 46 countries, or put differently, 1 out of 4 countries in the world use juries, okay? The percent is somewhat smaller than what we reported in the book chapter I mentioned from 2021 for several reasons. As I mentioned before, some countries have abolished the juries, and also we now use this functional definition which eliminates juries from the countries you can see on the slide because they're not really making these independent decisions. Okay? And as the next slide shows, you can see that juries can be found on any continent across the world. In North America, it seems that most of these juries are located. And because the theme is the juries in North and South America, when you compare these two continents, you can see indeed that there are more countries with juries in North America than in South America. Okay, you can say that all continents do not have the same number of countries. So we all actually done additional analysis and compared what happens within each continent. So this is the slide, and you can see again that in North America, about 2/3 of the countries use juries. When you compare that with South America, only about 1/4 of the countries in South America use juries. So you can see the influence of the historical heritage here. Countries in North America that have mostly been colonized by the British mostly use juries. Countries in South America that have mostly been colonized by the Spanish or the Portuguese do not mostly use juries. Okay? So now we are going to talk about the legal tradition, and you can see on the slide that countries that have juries typically have common law as their legal tradition, whereas countries that do not have juries do not have this legal tradition. And this and go directly into democratization. So here you can see, using our Freedom House classification for each country, that there is a very strong link between having a jury and country being classified as free, in other words, protecting civil rights and human liberties, for countries that have juries, which is not the case for countries that do not have juries. We use a different measure of democratization, the polity score, that contains a measure of the country's regime. And again, you can see a remarkable trend here that countries with juries are mostly classified as strong democracies, which is not the case for most of the countries that do not have the juries. Okay? And now, a few differences. So what kind of jury systems do countries have? Most of them has just jury of one size. Typically, it's 12 people. If there is second choice, it's most likely 9 people. So in conclusion, we've seen that juries exist in most of the common law countries with a Commonwealth background. And again, there is a clear link with the British and the historical British jury. And despite the fact there has been a convergence between the adversarial procedure used in common law countries and the inquisitorial procedure used in civil law countries, we know the introduction of the jury in the civil law system creates a Trojan horse, and as our friends from Argentina demonstrate. The second point is that for the understanding of the jury, you need to really look at the legal, political, and social context. And here, we've demonstrated the juries are closely associated with democratization. And in one of our prior works, published in 2024, we've concluded that the link between democratization and jury is much stronger than the link between democratization and mixed courts. The key issue is this independent decision-making. And the moment you introduce lawyers into the deliberation rooms, be it in the form of professional judge for mixed courts or law clerks for juries, the dynamic changes and you suddenly have this control of a professional over what lay people are doing. Okay? And I'm going to end this with a thanks to our sponsors.
Thank you so much, Sonia, for that overview, which sets the stage for the rest of the day. Richard Jolly of Southwestern Law School will be speaking next.
I don't have these slides.
Good morning. This is such a fantastic event, and I'm so privileged to be here with all of you today. And thank you to the organizers for putting on such an amazing collection of essays and bringing us all together now. What I want to talk about is the United States' approach to the jury, but I want to situate it within the comparative approach that we're engaging in today. What I really want to emphasize is that while we look, and this is the way that I'm thinking about it, as we look at the jury, say in the United States or in any other country, and the different forms that it takes, those forms, those procedures can be divided into whether or not they advance the jury's judicial role, that is its role in deciding cases impartially, accurately, or if those procedures are in place to enhance the jury's political role, that is to push back, to act as a bulwark against abuses of state power, or even against the judicial power, against that role. And that juxtaposition between a judicial role and a political role can help us make sense of some of the peculiar features, or what may be thought of as peculiar features, of the United States' jury system. When you look around the world, you see countries choosing to emphasize one of those roles over the other at times. In mixed courts, I would argue the court is more interested in providing legitimacy, democratic legitimacy, to the judicial rulings than it is in sort of implementing a political institution. The United States is precisely the opposite, at least it was at the founding. The idea here in the United States was to ensure a political role for the jury. And because of that, some of the procedures that we have that might look strange or might be unique comparatively start to make a little more sense. Well, many of you are already familiar with the common law history of the jury and its role in the United States. I think a brief review is helpful to really emphasize just how seriously the political nature of the jury is in the United States. By the 17th century, when the jury was emerging, when the United States was emerging in the colonies, the jury was one of the only rights that was secured in most of the charters by name of all 13 colonies. And was the disagreements between the colonies, let's say, and the crown became more heated, the jury became a prime battleground over which the colonists could push back against abuses of the crown. The crown responded with the Stamp Act and a host of other legislation, collectively referred to as the Intolerable Acts. What these acts did was largely remove juries from the dispute resolution. They redirected these types of disputes to juryless tribunals, and this was very upsetting. In fact, it prompted the first Congress of what would become the United States, called the Stamp Act Congress, in which the colonists wrote that these acts were the Stamp Act and several other acts, by extending the jurisdiction of the courts of admiralty beyond its ancient limits, have a manifest tendency to subvert the rights and liberties of the colonists. That language is almost exactly repeated in the Declaration of Independence, where the colonists wrote that the crown had deprived the colonists in many cases of the benefits of trial by jury. It's no small statement to say that deprivation of trial by jury helped motivate the creation of the United States. What is more, following the Revolution and the short-lived Articles of Confederation, again, the jury was at the forefront over debates over the Constitution's ratification, with the most common complaint against that instrument being its initial lack of civil jury protections. Again, we see this idea of the jury not being a deliberative judicial body because it makes better decisions, but a political body deliberately meant to push back against abuses, in this context of the federal government. I think Thomas Jefferson might have put it quite well when he said that judges may be swayed by a spirit of party, a devotion to the executive. This is not the case with juries, though. And for this reason, they have the power to judge the law as well as the facts. And if I were called upon to ask whether or not the people be excluded from the legislative department or the judicial department, I'd say it is better to leave them out of the legislative department. The enforcement of the laws is more important than the making of them. I think that statement captures, in a way, a quite poignant way about how the United States views the jury. Now, because of this political foundation, we might look at how that has manifested in some of the procedures that the United States has adopted governing the jury. I named 3 in the contribution that I added here. That is the fair cross-section requirement, jury unanimity, and jury secrecy. At first, the thought of the fair cross-section requirement as advancing the political power may not seem to be immediately apparent. One of the reasons why the United States' Supreme Court has decided that the jury must be comprised of a fair cross-section of the community is not, I think this is really important, not because diversity necessarily leads to accurate verdicts. It may. It is true that diverse juries and diverse bodies may lead to more accurate dispute outcomes, but that's not why it's constitutionally required. It's constitutionally required because without that diversity, the Supreme Court has told us, would be to leave out a flavor, a distinct quality if those voices are left out. That flavor, as the Supreme Court said, matters not for accuracy, but for the democratic purpose of the institution. The idea here is that the more voices we have, the more democratically powerful the institution will be, not necessarily accurate. And I think that idea of privileging democracy over accuracy bleeds into 2 other aspects, that being the unanimity requirement and the secrecy requirement. With respect to unanimity, this does not necessarily lead to more accurate verdicts. Sure, through deliberation, we see the types of discussions that can take place that make sure that a majority doesn't run roughshod over minority voices. But that's not what we're concerned with. What we're more concerned with is that idea of ensuring the type of reflection and giving voices to the potential dissent in securing unanimity. The price paid may be hung juries, it may be mistrials. That type of inefficiency does not undercut what we're trying to advance. Again, the political power, not the accuracy. And I think secrecy then is the third that I'd like to mention here. Some of you in this room in the United States may be familiar with the Tanner case, Tanner v. United States. For those of you not familiar with this case, I think it speaks so loudly to how we value secrecy in jury deliberations in the United States. In Tanner v. United States, the jurors there were engaged in alcohol drinking, cannabis smoking, napping. There were actual drug deals taking place during in the course of the trial. And you can imagine that the convicted criminal defendant there was none too pleased to have learned all of these things, and he appealed saying he was denied an impartial jury. The Supreme Court said, no, you were not denied an impartial jury. Once we have a verdict, the jury no impeachment rule is in place, and you can't go back and impeach that verdict with evidence drawn from within the jury deliberation room. You can literally have jurors on drugs, and we say the importance of that secrecy, this idea of jury independence is so severe, it's taken so seriously that we will privilege that over the accuracy of judicial verdicts. I have just a minute left, but I wanna finish by saying this privileging of democratic role of the jury does cause some problems, as the United States has entered a modern era over the last 200 years. We can see pushbacks against this idea of how much we want to privilege the jury in two ways. We have a few different ways. One, we've seen the Supreme Court formally revoke the jury's law-finding power. We see this take place at the opening of the 20th century, such that jurors now may still maintain the power, but do not have the legitimate authority to disrespect the law. This is a huge shift in how we think about the jury. So we've seen pushbacks there. We've also seen procedural changes that have dramatically curtailed the use of juries, to the point that this political power of the body may be maintained, but it's exercised so sparingly given the procedural changes that have been implemented. So I think that sort of begs the final question. If you look around the world and you're trying to ask which aspect of the jury we want to privilege, that judicial version or that political version, we might also ask what the effects of so privileging one aspect of it over the other might be. The United States may have more jury trials if we were to implement procedures that might restrict some of that political power. And making that decision can really set the stage. In the United States, we chose political. We chose the political. It was written in our history, and that continues to motivate the institution today. But as we look around the world, different countries can take that different approaches.
Thank you so much, Richard, for that. The next presentation will be by one of the architects, I would say, of the jury in Argentina, Aldana Romano from INICET.
Okay, they are having some little troubles, but they are going to figure it out, as we say in Argentina, always. Don't worry, here we are. So, okay, shall I start?
Yes,
Yeah,
please.
all right. Well, first, let me thank you, Northwestern University and the American Bar Foundation for organizing this amazing activity. Your support was really fundamental for me to be here with all of you. Many thanks, Sherry and Valerie, for giving me a chance again to learn from you and to share our ideas with these incredible people. So, I think that many of you will probably already know that Argentina has experienced a resurgence of trial by jury over the last 14 years. To date, 13 provinces, yes, we just added La Rioja last week, believe me, have passed the jury. Not all of them have held trials yet. Some are implementing the new system, as you can see on the map on the left of the screen. As Argentina is a federal country, these are different criminal procedures in each province, so their impact in the definition of the jury system. The second map shows the three kind of stages of implementing the adversarial system. The darker the color of a province, the more developed is its adversarial system. Well, today we are not going to discuss why Argentina decided to implement trial by jury. Today, my purpose is try to answer two main questions. First, why did Argentine provinces decide to make jury trials mandatory for certain offenses? And second, what type of cases were deemed eligible to be tried by a jury? To answer these questions, we study, of course, the laws of the provinces, we review the parliamentary debates, and we conduct 8 in-depth interviews with key actors involved in drafting or passing their jury laws. Well, to understand why most Argentine provinces decided to make jury trials mandatory for certain offenses, we definitely need to review our constitution. As you can see, the constitution refers to trial by jury in 3 opportunities. The constitutional definition of jury has been the subject of an extensive debate regarding its scope. Does the Constitution understand the jury primary as a guarantee of the accused, protecting the right to be judged by their peers, and therefore allowing its waiver as an individual right? Or by establishing that all criminal trials will be judged by juries, does the Constitution define an organizational structure for the authorities who exercise jurisdictional power and make the use of juries a mandatory procedural requirement? The scholars have had this similar interpretation of the constitutional mandate. Edmundo Hendler has argued that the jury is, above all, a guarantee to protect the accused's right to be judged by his peers. In this sense, the jury system is viewed as an individual prerogative, one that the accused can waive. On the other side of the debate, there were other voices, such as Magariños, Bovino, Anito, and others, that considered the jury as a mandatory organizational form of the justice system. These authors argue that the inclusion of the jury into the organic section of the Constitution also characterizes it as a political right. In 2019, the Supreme Court of Justice ruled on Canales, a case from Neuquén. Canales determined the constitutionality of the mandatory nature of the jury. However, in the Canales decision, the Supreme Court did not determine which is the constitutional model, nor did it rule, outside the vote of the Minister Rosario, of course, on the constitutionality of the waiver. And this analysis shows a preliminary regarding of the Constitution can be used to support both interpretations. And in the absence of the federal regulation, the provinces have taken the initiative to implement jury trials autonomously and defining the characteristics of their systems. Until now, we can identify, we can say, 3 big models. The first one, the mandatory jury adopted by most provinces, as you can see, the waivable jury, where the defendant can opt out, and we can add a third model, the jury as a tool of the public prosecutor office. To understand the mandatory jury, the decision was argued by 2 main reasons. The first one was that the interpretation of the Constitution mandates jury trials, at least for felonies. However, neither the Constitution nor the criminal legislation contains a provision that distinguishes between felonies and misdemeanor. Thus, each jurisdiction defines what constitutes a criminal offence eligible for jury trials based on the nature of the act and or the applicable punishment. And the second argue was the evaluation of the jury as a society right to judge. As you can see on the screen, this was a present idea in the parliamentary debates. Buenos Aires, our most populous province, ought to establish a waiver jury. In this system, the accused may waive the jury until the moment of the prosecutor request, in which case he or she will be tried in a bench court. The public reason to opt a waiver jury were justified as part of judicial tradition in England and in United States. But in private, we can identify some other reasons related to some fears about the implementation. We have 3 provinces where the trial by jury is conditioned on the decision of the public prosecutor office. In Neuquén, jury trials are mandatory only when the prosecutor requests a sentence of over 15 years for some crimes. Rio Negro defines that all cases in which the prosecution requests a prison sentence exceeding 12 must be tried by a jury. Neuquén and Rio Negro are the 2 only provinces that passed their jury laws with a comprehensive reform of the criminal procedure and with the implementation of the accusatorial model. So the new requirements and the special challenges they pose for the prosecutors may help us to understand why the law's powers gives prosecutors to decide which cases it will bring to a jury. In Santa Fe, the defendant can request the waiver of the jury if it is accepted by the prosecution. So the decision was taken with the framework of a broader provincial debate to give the prosecutor office more tools to guide the criminal prosecution policy in a context marked by drug violence. As you can see, all provinces choose to design their jury model for serious offenses. 4 provinces opted for certain types of felonies such as homicides, serious injuries, and sexual assault. 7 established jurisdiction based on the length of the potential punishment, and 2 choose the requirements of punishment asked by the prosecutor. Well, some final remarks to try to conclude my ideas. In the decision of the province, political considerations shape the characteristics of the Argentina jury system. I think that the main goal was to guarantee that a jury can become reality in our country. This is why they opt for the mandatory jury system rather than leaving the decision to implement it in the hands of the parties. While different arguments were used to select cases, similar concerns we can recognize. First, public discourse emphasized the need to reserve jury trials for heinous felonies with high social impact. In some debates, it is proposed as a starting point in the framework of a sort of gradualism to evaluate its operation, ensure its proper development, and prevent justice system from collapsing. A review of the parliamentary debate shows that in at least 7 provinces, there were political sectors that openly demanded the introduction of corruption offenses. They did so on the understanding, of course, that the crisis of legitimacy demanded greater transparency and impartiality in the trial of these cases, and that the jury could provide it. However, except from Chubut, which finally incorporated corruption offenses under a mixed court system as its constitution order, none of the provinces decided to expand jurisdiction to include them. In Argentina, the jury system was sought more as a political institution than a legal one, designed to contribute the crisis of legitimacy and distrust of society in the justice system. This concern explains why a waivable jury would not achieve the same effect. The discussion of mandatory jury system or waivable is especially relevant in the Latin America context. So 2 questions at least arise. First, how can a robust jury system be established and implemented in cultures with an inquisitorial tradition? And second, given our recent inquisitorial culture, could a mandatory jury prevent a weak beginning of the system? I hope we can discuss further on this issue and, of course, of many others. Thank you so much.
Yeah, so wonderful presentations. Now we will turn to Leonel Gonzalez Postigo from Universidad Alberto Hurtado in Chile. And you have slides, correct?
Yes.
Great.
The third one.
There, third one. Here you go.
Thank you.
Okay. Well, good morning to everyone. First of all, I want to thank Professors Hans and Diamond for the invitation to this conference and having the chance to share with esteemed colleagues from different parts of the world. As an introduction, I would like to share with you that the jury in Chile is not regulated, but its discussion reemerges regularly, especially due to the very low legitimacy of the judiciary and cases of influence peddling involving judges. In this presentation, I will address three aspects: the political and social context, the technical and political reasons for regulating the jury, and a proposal for its regulation. Concerning the political and social context in Chile, in November 2019, as maybe all of you know, after massive protests throughout the country, political parties agreed to hold a plebiscite on whether to change the constitution. Nearly 80% voted in favor, leading to the formation of a broadly representative constitutional convention. My university submitted a proposal to regulate trial by jury, but it was not included. In 2022, the draft constitution was rejected by 62% of the voters. A second attempt followed, dominated by a conservative proposal that excluded the jury proposal, was related to a second votation by Chileans that rejected the proposal, keeping the 1980 constitution in place. At the same time, trust in the judiciary has remained below 20% since 2019, fluctuating between 15 and 16 and reaching its lowest point of 8% in December 2019 during the protests I mentioned before. This distrust is related to a wide range of factors, of course, but including the perception of impunity, evidenced by only 44 convictions for human rights violations during the 2019 protests and the 2023 so-called caso audios, which led to removal of 2 Supreme Court justices due to the influence peddling involving a lawyer's role in appointing judges. So what are the arguments for introducing a jury system in Chile? Let me start with the historical context. The first precedent of the jury dates back to 1813, when abuses of freedom of the press were submitted to the knowledge of juries in order to safeguard this guarantee. Then, in 1894, during the presidential bill of the Code of Criminal Procedure that governed Chile until 2005, President Jorge Montt expressed that the trial by jury was considered the most perfect of those known. He stated, "It has seemed totally inadequate to our social situation, to the shortness of our resources and to our lack, especially in the second-order towns, of competent citizens who could be called upon to perform the delicate functions of good men." In 1925, the press judgments were handed over to criminal judges, leaving behind 110 years of uninterrupted presence of a jury trial in Chile. This reflects, in my opinion, a legal reality that was present in much of the country's independent history, so it is not unreasonable to propose its return. Concerning the political arguments to introduce the jury in Chile. First, trial by jury could solve the problems of legitimacy and trust faced by the judiciary. In this sense, according to the data obtained in the last survey of the Organization for Economic Cooperation and Development, only 25% of Chileans have high or moderate confidence in the courts of justice. The crisis of legitimacy is also reported by Latinobarometro, which in its 2024 report found that only 18% of the people trust in the justice system. Second, the jury system operates as a guarantee of independence against the distrust that has arisen in the citizens due to the cases of influence peddling that I have mentioned before. Thirdly, the great variety of the members of a classic jury, as opposed to the 3 judges who currently settle criminal disputes in Chile, could generate a greater expression of the diversity of the community. On the other hand, there are technical and procedural reasons that supports the incorporation of a jury system in Chile. Firstly, the jury functions as an important mechanism to improve deliberation. It fosters all those involved in the process to improve the quality of litigation. In Chile, the preliminary hearings have experienced a decrease in their average duration, dropping from 37 minutes on average in 2006 to just 16 minutes on average in 2014. Even in a subsequent sample conducted by Professor Duce in 2019, the average duration of these hearings was just over 13 minutes. Secondly, the incorporation of jurors could revitalize the judiciary by eliminating the distinction between the pre-trial judges and the trial judges. This would transition from two static and well-defined figures to a simpler form of judge available to conduct hearings, regardless of their purpose of the hearing. The benefit of ending this distinction lies in letting the judges intervene in all hearings and be aware of the impact that a poor exclusion of evidence has on the oral trial. And thirdly, the introduction of juries would enhance the impartiality of criminal trials by allowing the parties involved a broad discretion in selecting the jury members. This would eliminate doubts about possible bias or conflicts of interest among judges. That has been one of the main problems that we are facing and I have been mentioning before. Finally, what's the form the jury could take in Chile? In the first place, a gradual and progressive evolution of the model. This means starting with a limited number of cases in a specific territory and then expanding the scope until it covers the entire national reality. To begin implementing the jury trials in Chile, I propose, it's just an idea, that it would be mandatory for crimes carrying potential sentences of more than 15 years and 1 day. Second, I propose, of course, a classic jury model composed of 12 members of the community. The role of the professional judge would be limited to directing the debate, instructing the jurors, resolving issues related to the admissibility of evidence, and in the case of a guilty verdict, imposing the sentence. Regarding the decision rule, it corresponds to the unanimity rule established in the classic jury model and has been upheld by the Inter-American Court of Human Rights recently. It is also proposed the impossibility of waiving a jury trial, and finally a system of appeals based only on the possibility of appealing a sentence resulting from a formally unfair trial, particularly due to the instructions given by the trial judge to the jury. To conclude, a reform of the justice system is necessary in Chile. There is widespread distrust of the judiciary among the citizens, and the dislegitimation of the judiciary poses a problem that affects now the democratic system of the country. In this regard, the incorporation of trial by jury could restore trust and enhance the functioning of the criminal procedure. Thank you so much for your time.
Thank you. You can see the influence of Argentina in some of these. So our last speaker for the first session will be Diego Camaño. He is from Universidad de la República in Montevideo, Chile, and I'm sorry, Uruguay. Please join us. It is Juries 2025.
We're all Latin American brothers. let's say, American brothers. Okay. So, first of all, thank you very much, Valerie, Sherry. It's a great pleasure to be here. And to, it would totally surprise me, this invitation. And we are both very happy with Juan, with John, that is coming from Uruguay, so far away, so small country. I remember we met also with John Gastel in Mendoza, the three of you, and of course, Andres, Sidney, and Dana, great friends. So it's great to be here. Speaking about juries, and speaking about the possibility of having juries in Uruguay. But I would have to apologize because of two things. First of all, my English is not very good. It's not at all good. And second one, the artificial intelligence translation of my article has some dangers. It's very dangerous. Because it took like the word escaminado we use for these tribunals. It says scabby, scabinated, hung jury. I never spoke about hung juries in my article. So Uruguay is a small country. We are just 3 million people, and we have a civil law tradition. And I would like to share with you some features of the state of the discussion today. The juries, as you see, have been always in our constitution since 1830, but there was a decreasing constitutional emphasis. From the first one, it was very strong. It was urgent to establish juries in criminal and civil cases. So it was a mandate that the Constitution made to the legislators. But then in 1917, it turned differently, just to say that criminal trials by juries subsist as whenever the legislator wants to do this, he can do it just for criminals. So civil was abolished, and also this mandate and this urgency disappeared some years later. And now, from 1934, we have the actual phrasing of the Constitution. The law may establish trial by jury in criminal cases, and some say, well, maybe it's unnecessary because the legislator can do this type of things, although the Constitution doesn't say it. But the truth is that we have the mention of the trials, the criminal trial by juries in our Constitution. As all Latin American Constitution, we have also the influence of the Philadelphia Constitution, and all the main influences that we have in Latin America of the Cadiz Constitution and other ones. But what does it mean? What does it mean trial by jury in Uruguay or in our Constitution? I won't stay a lot about speaking about this because of time, but there are some documents that reflect that they were thinking about citizens, a jury made exclusively only by citizens. But the thing is that when we had the jury, we didn't actually have a jury, but a mixed tribunal. It was implemented in 1879 in the Code of Criminal Instruction, Inquisitorial Code, like the French-inspired code, and it had a model of integrating citizens, but in the form of mixed tribunals. They have, in the first instance, 4 citizens with 1 judge, professional judge. Then in the second instance, also having a jury, the possibility of juries in the second instance, something strange. But the citizens were 8, and the judges, professional judges, were 3. So, although we can think that in the constitutional design they were thinking about citizens or a juror, classic juror, then when in the code, the legislation implemented a mixed tribunal. But if I had to put a title to this presentation, I would say something like, how could we overcome trauma? Because we have one case that was a trauma for us. because it was that one case that made that juries were abolished in Uruguay, and that is the La Ternera case, a famous case in Uruguay. In this case, there was a political, very rich man that was accused of ordering the killing of his wife. Everyone was convinced that he was guilty, and he was acquitted in the second instance by a ruling in which the 8 citizens voted for his acquittal, but the 3 judges, professional judges, voted for his convictions. So, this man was very old, he was released after being 8 years in prison, but this case really buried the discussion about the juries in Uruguay. Immediately after this case, the jury was abolished, the mixed tribunal was abolished, and so, these are like the myths we have in Uruguay. When you speak about juries, the people will say something like this: people can be corrupted, judges cannot be corrupted, because in that case they were corrupted, or they're supposed to be corrupted. We cannot trust people, because in that case, if we trust the people and they release this guilty guy, but judges are trustable because they made the right thing, they convicted him. People ignore the law, so they are not able to rule the cases, but in this case, judges know the law. These myths they come from this case, and when we ask the legal academics, scholars, politicians, this like the ghost appears, the ghost of La Ternera. So that's why I speak about trauma. We are about like a trauma, no? Similar to Maracana ghost. For football, no? The Beatles, every time we play with Brazil. Okay? Although you're much better than us, you know? That's why we are the kids and you're baby. So we have to appeal to the ghost, you know, to make some spiritual work to win. So things changed, and we have a criminal procedural reform in 2017, going from leaving the inquisitorial system and going to accusatory, similar to adversary system, but really not adversary system, much more accusatory style. And so we wanted to know which was the state of opinion about the idea of re-implementing jury or trial by juries in Uruguay. So these 3 students, you have one here, the 3 mosqueteros, they started this journey in 2020. They made a qualitative study. They went to ask some scholars, some politicians, some lawyers, some prosecutors, and they obtained very good information. Then, 2022, some professors joined this initiative, but we took it a little bit further. We wanted to have a quantitative, representative results of what the legal actors were thinking when they were asked about the idea of re-implementing the juries. So this empirical study we are carrying it on right now. So I will just talk about some few big picture we are having. First of all, 40% of let's say the judges, public prosecutors, and public defenders are represented in these numbers. We work with expert in statistics, so the number of people that we have is representative. We can say that in the public justice system, 40% of the people are in favor of having juries again in Uruguay. The question was very concrete, no? Having juries in Uruguay, not the abstract idea of, oh, jury, what's a jury? What do you think about having again juries in Uruguay? It is surprising for us that 40% are in favor because we have this civil tradition. I'm just finishing. And then one side, 81%, they understand it as citizens, a group of citizens against 19%. But then when you ask about preference, it's like half and half, citizens or citizens and judges, so there's something like very, we have to analyze this. And for what type of cases, nearly 27% said for all cases, and 75 nearly for some cases, more severe crimes or high penalties. A few of them, they answered, we want juries for misdemeanors, something in this range, because like the idea that juries are not, well, judges will be better for the more serious crimes, but most of these 74% want juries for severe crimes or high penalty crimes. So, thank you, and I hope we can discuss this, if we can re-implement, and you can help us in Uruguay to raise the discussion.
Thank you very much, Diego. Is it turned off? Okay, thank you very much, Diego. So that concludes our first panel, but because everyone was so obedient to my little 10-minute notices, we actually have ample time for questions. Now, our tech expert here tells us that this room is mic'd, so if you ask questions here in the room, people online should be able to hear you. Maybe we'll hear from them if they cannot, but I'll take questions for any of the speakers. Seeing none, I'll launch right in. Actually, I have a comment. I don't know if it's a question, but it's a comment for Richard Jolly, where is Richard? Oh,
back here.
Oh, okay, there you are. So I don't think you need to say that the fair cross-section and unanimity don't support high-quality decision-making, because I think in the majority of cases, the research would suggest they probably do. That is a diverse deliberative body and also a unanimous decision rule would do. Because I think you make a very strong case for the political nature of the jury and the political importance and drive, the way in which juries have developed in the US. So I don't think you need to say, I don't know, do you have a response
Yeah, no,
to that?
I think that's absolutely right. I don't mean to suggest in my juxtaposition between the two main motivators of the jury system, and I think this goes across the board as we look internationally, that whether we're privileging judicial or political roles, we're kind of always doing both at the same time. It's just that I think that when you choose to emphasize one over the other, you start to see sort of peculiarities, as I said. I think you are correct that the fair cross-section and particularly the unanimity requirements advance both, perhaps in equal measure, but at least in the United States' constitutional language, the way we argue it within the cases, it seems that we're doing so more to advance the democratic role than we are the judicial role. But I would agree with you, there's no question that from the studies, some of which you've conducted, that unanimity and fair cross-section also does advance better decision-making. I guess my point is that it doesn't seem like we require those things because we want better decision-making, but rather because we want that democratic voice to be as amplified as possible.
Yeah, fair, definitely fair response. So we now have a few questions. Mauricio and then Diego.
Yes, I have a couple of points for different presentations. In Sanya, the point is I come from Chile, from South America, so it's a little bit troubling, this division between South America and North America, because it's a little bit misleading in terms of what is happening in the Central America and the Caribbean. So I would suggest that maybe you should distinguish a little bit more, between like Latin America and North America and the Caribbean, because Central America, the Latin American countries do not have jury too, but Caribbean countries probably has more, so that picture troubles me as a Latin American guy.
Sonia, do you want to respond?
That's not something that we created, that's based on how the continents are divided. So it's given, that's not North America.
Okay, for Leonel, A point, I mean, I agree with all of you, you said that. What is troubling in Chile is that in the first, I mean, if you analyze the narrative of the first convention, Constitutional Convention in 2021, the narrative behind there was completely the narrative of the jury. I mean, we need to democratize the institution, so on and so forth, but there was no room at all to have this discussion, even within progressive people that was in charge of the legal part of the convention. They were not even willing to discuss the jury. So, I mean, we're in a very difficult position because if the jury did not catch anyone at that time in which the narrative was completely consistent with the narratives of the jury around the world, I mean, I don't know what we should do, because, I mean, in a way we were lucky because now everything that was in the proposal of the first convention was very easy to label as something wrong in Chile. So the jury says from that label. That's a good point. But the problem is that now I see that the narratives, for instance, in terms of democratizing the judiciary, maybe are going in the direction of Mexico. Let's choose a popular election to judge it, which is not the thing probably, in my opinion, best thing. So how do you see that? Because it's been very complex to install the idea. And for Diego, a small point.
So,
Yeah, just a
would you
short
like to
answer.
respond, Leonel?
Thank you. It's a very good question, Mauricio, and to share with you the experience of that first convention, we had the chance to have two meetings with the chief of the Constitutional Convention. One was more political and the other one was a technical presentation. And both were directed to present the jury trial proposal. And in both occasions, the chief of the Constitutional Convention, for instance, didn't know that there was a sentence of the Inter-American Human Court just 2 or 3 years before. So what Mauricio is describing is true. I mean, the first convention was more related to this narrative, but to be very honest, they didn't know like the minimum of the institution. It's very similar to what Diego mentioned in Uruguay. I mean, there were many myths that were easily abordable, but the people there were not, they didn't know about the institution, so it was very difficult to explain to them that the question of the unanimity, that they deliberate, that there was a very complex structure at the time of deciding the sentence. They didn't know that. At the end now, looking that from the distance, I will say it's positive because that process was a failure. So more than 60% rejected the constitution. So to me, it's positive that the jury was not there. We can discuss the jury without that process. But it's true, Chile is a more conservative country. So it would be more difficult to maybe have to think about a new narrative to explain the jury.
And for the point was if you have any information, surveys on general population, because I can understand that the trauma of the La Ternera case is in the legal community are very conservative, keeps narratives going on, but has the same impact in the general population? I mean, La Ternera is a case that it's known for the general people. Do you have something on that?
We don't have something. We would like to do that. I had that idea of making a national survey. As we are a small country, this couldn't be so difficult, but we don't have the money to do that. Maybe it's the third step. I think La Ternera is always present in the mind of surely about older people. I'm sure that new generations, they don't know anything about La Ternera, but maybe middle age like me or older, they know about La Ternera. One thing that is, I just wanted to point out about this idea of the political body, that one of the difficulties we have when we speak about juries in Uruguay, I think Chile may be similar, that to explain that, you know, a decision maker is a political body. Because as we have a tradition of professional judges, the idea of the people and also of legal actors and politicians mainly is that the justice is something to be made by professionals, not politics in judges, in the judiciary. You know, there's something like a mixed in our idea that politics should not enter into the courtroom. And you have it very differently. I find it very interesting, and I would like more know how to deal with this difficulty in countries as ours. Nowadays, we have the government is installing a commission to revise the criminal procedure. So this would be a very good opportunity to introduce juries. I spoke something like informally with high authorities, and they say, you want them to kill me, you're crazy. But there are some of them, for example, some high authorities that are in favor of juries. But we will have to deal with this problem. So what do you suggest? How can we convince others in Uruguay that that politics is not the politics of the parties, not partisan, but politics in the courtroom? Just that. Thank you.
Okay, so right behind you, Richard.
Yeah, this came up a few times, but I guess I'll direct my question to Aldana. And it was something that I was gonna mention in my talk, but I was running out of time. And that's this idea of being able to waive the right to the jury and how controversial that is. In the United States, at the beginning, there was no right to waive the jury trial. The thought was the same as you had emphasized, that the right is both of the parties, but perhaps more importantly of the community. And it wasn't until the 20th century that we started seeing the Supreme Court in particular change its mind on this and start to look at the idea that the parties owned the right and thus could waive it. And given that this conversation is happening actively, at least in Argentina, and it sounds like in other places as well, I'd be curious to hear if there has been any the main argument against it in the United States is an efficiency argument. We arrest so many people that we couldn't possibly provide them all jury trials, is the thought. And I'm curious what about that dialogue. I was wondering if you could speak a little bit about that dialogue of whether or not the right should be waivable or not.
Well, at least in Buenos Aires, that was the only province who decided the waiver closure for jury trials. The main reason was quite similar, but in the sense of they were very afraid about the resources, the infrastructural situation of Buenos Aires province. If you remember my first map, Buenos Aires has already now a kind of mixed type of, not an accusatorial system, not an inquisitorial system, but in the between both of them, so they don't have enough sources to figure out how they can implement trial by jury for all the cases that they at that time they thought that they probably would have. So some issue about the number of cases and how to guarantee they can offer a jury for that number of cases, yes, that was a concern for Buenos Aires situation because of the population, because of the cases, and because of the infrastructural situation of that provinces. It doesn't, in the rest of the province, you are not going to have the same debates. Of course, I think that's one issue about the worry of guarantee trial by jury for all the cases is the decision of which cases we are going to have with jury trials. So the decision about, well, we are going to start, because it is shown as a start point, we are going to start only with felonies, is because your point, is because we are not very sure about if we are going to manage correctly the number of jury trials that probably we are going to have. But not on the idea of waiver or mandatory beside Buenos Aires, more on the idea of what type of cases we are going to have in our province, at least for this beginning. In the parliamentary debate, you probably will find some parliamentary that are saying something like, well, we want to start with these cases, probably in the future we can add more.
Yeah, on the waiver issue, I had a student in my jury seminar who actually did a 50-state study of the waiver features in the United States. And it actually was eye-opening to me because the federal government and most of the states, the majority of the states, require, if a defendant wants to waive the right to a jury trial, that both the judge and the prosecutor agree to the waiver. So it is a joint right, if you will, and definitely one that appears to belong to the community as much as to the defendant. Otherwise, there, I think, is one state, maybe two states, in which the defendant has the absolute right to waive. So quite different. So we have a few more questions now, including one online that Martin Sabelli, a lawyer who has done quite a lot of work in Argentina, training lawyers, has written out, and I'll, no, that was not right. Okay, I was trying to get to, here we go. So you can see him, he's working from the defense side and the perspective of a lawyer who advocates for the defense. Here's his comment: jury trials elevate the level of preparation of the practitioners if and only if they have the tools to do the work necessary to provide the jury with the necessary evidence and instructions. Rules of evidence, opportunities to litigate, sufficient peremptories, that's coming up soon. And other procedural rules like discovery and judges who understand the rules and the rules of ethics. So if anyone wants to respond to Martin Sabelli's comments, that would be great. I do want to invite Carla Pandolfi, who has a comment. She also was an architect of the Neuquén project on the Argentine jury system, with many thanks for your incredible role in that. Please, I want to share your comments.
Thank you, Valerie. I wanted to add to Aldana what she was saying.
Can you speak up?
I think you're gonna have to talk louder.
Yeah, maybe stand up, Carla.
I wanted to add to what Aldana answered to Richard. To maybe you have heard this many times, but I would like to contextualize Neuquén's starting with juries. That in Argentina we had a vacancy to implement the jury trial since 1853, that it was in our constitution, till 2010, when we passed that law in Neuquén, that was the first province. So many myths and fears and many things were debated at that moment that we passed that law. Not only we had fears and myths regarding the jury system, but also the adversarial system. As Aldana said, we did it all at the same time. It was a huge change from an inquisitorial system to a truly adversarial system with the classical jury, the first one in the country. We are not taking into account the mixed courts at Córdoba. We don't like that system. So, we had to make some consensus, to make agreements between all the parties in that Congress to decide which was the best model for us. We could see the experiences around the world, but we didn't have any, and we had this vacancy for so many years. So it was a great challenge, and we didn't want, like happened in the case La Tronera, for one case that they would destroy our jury system. So we were cautious. We don't have unanimity, and we decided it was for 15 or more years when the prosecutor had to put with all the adversarial system changes, having a lot of new duties that in the inquisitorial system are divided with the inquisitorial judge. So it was a huge change. That's why our system still in Neuquén is quite maybe 10 years seeing it conservative regarding the rest of the country. But it was the first experience, and it was a successful one. I think we may be in a couple of years ready to make some new, include some more cases, lower the penalties asked in order to get a jury trial, and give the discussion of unanimity. Thank you.
Yeah, thank you so much, Carla. And one of the benefits of the Neuquén project, jury project actually going forward, is that I know in many venues in different provinces and in the federal system, people paid attention to the results of the systematic research that you helped spearhead. in Neocan, and we're relieved that actually, you can give decision-making to a group of citizens, and they seem to do a decent job, and they leave having more confidence in the justice system and in the judges. So, all right, several comments. Can you raise your hands? Who with those? Diego.
Oh, one little thing about what Martin says, Martin Sabelli, is very important. What are the risks of establishing jury trials without these foundations? Because we don't have the tradition. But I would say also that there is a greater risk in the fact that we have criminal reforms forward to similar to Anglo, let's say, common law systems, accusatory system, not really adversarial, but very similar, that resembles to that. But then we have a tradition that is going, the practices, are going like back. So inquisitorial history may be like by eating this reform if we don't establish juries. I think that maybe the risk is worse if we don't have juries of going back, just that. But there are a lot of risks, it's difficult for our countries that we are starting to build a tradition.
So interesting. Did you have a response?
In response to Martin Sabelli's, there are many scholars in Argentina throughout many years saying that we are not ready yet for trial by jury because first we have to have rules of evidence, we have to have ethics and so it's the same story. The risk is not having a jury system. So I think that now that we have the jury, I agree with Martin that the next step is maybe to have more peremptories, to slow little by little with rules of evidence, and to create a new culture of adversarial litigation. But first, we needed the jury system in operation. That's my point of view.
It's so funny. It reminds me a bit of the introduction of Saiban and Seido, the mixed court system in Japan. When they introduced it, they said, we're gonna have 5 years of preparation. And so they went around the country, they built new courtrooms with 9-person benches and did lots of trainings and mock simulations and so on. And it came close to the introduction of the Saiban and Seido, and there was an uproar. We're not ready, we cannot do it, 5 years is not enough. It's never enough, right? It's never enough. John.
Yeah, if I can just reinforce this point, I'll put this in the larger context of democratic innovations. It's a whole field in political science which never even thinks about the jury, unfortunately. But they talk about things like citizens' assemblies, participatory budgeting, and all these processes. And I hadn't thought of it until you said that, but in every single case, I can't think of a single instance where there was a gradual preparation leading to a bold innovation. What happens is somehow mysteriously the innovation happens, whether it's in Ireland, British Columbia, or in the US and Oregon, and everyone is sort of shocked. And then everybody starts learning quickly, how does this work? And often the first attempt is a bit of a mess, but it just keeps moving forward. So I think, I agree that risk is always part of it. But your point is absolutely right. It's you weigh that risk against the risk of not trying. And some of these innovations do quickly peter out. They try it once or twice in Canada and say, well, maybe we don't need this right now. But there is no successful case that had this gradual ramp up that I can think of in that broader field.
Okay. It is our time, and we have a short 5-minute break in between now and the next session. I see Martin has yet another comment. We'll take a look at that and greet you all when you come back. Should you need to take a break right now, and we'll head to the next session. Please join me in thanking the participants.
Historia y estadística. Dice por ellos.
The biggest places in the United States are the more complex cases, right? The civil cases, antitrust, can be really difficult, absolutely. Maybe right now the big debate is whether or not regulatory. So we have disputes around the SEC, violations of insider trading, that type of thing. It's very, very complex. Should that go to the jury or not? The Supreme Court just last year said it does have to go to the jury. Pretty much all of these types of things that we used to think of as regulatory, that these sophisticated, complex bodies that decide, there's a jury. Make regulations. We're not going to be able to regulate things like water or food and drugs or the fair market. Exactly. Well, so that's kind of, so there's a great news, there's a great news.
So he's coming as well, and we're gonna,
There are and they will in front of the idea here is that the government, now, maybe that's right, maybe that's not, but what's happening right now is how do I understand this week? The fact that we're deciding to be the Supreme Court said, yes, it has to be every first. That's not what I think, that's what we're going. No. It's
well, that's what we heard.
Her whole point was.
Oh, yeah, but there's one more.
It's always if we're looking the other way, it's just.
Yeah, that's okay.
Yeah, absolutely.
Having me.
Oh, no, yeah.
You don't have the. It's so, exactly, like it gets so overwhelming.
Yeah, I don't have science.
Still.
You're not, okay, wonderful, all right, thank you knew that the person was
I know people might not know that.
And so I
I think it's the first time.
Yes, sorry, Diego.
Diego? Oh, I should wish Garcia.
Just so that I understand.
So the last guilty.
Oh, so it's the other way around. Oh, interesting. Okay, so they all said this guy did not kill his brother.
Skepticism.
After the travel.
I don't know how they do it. They just.
So that's sort of like the challenge that I lay out there. I'm like, okay, guys, we're gonna get this type of like, this is a thing. So I'm thinking that something to work on.
I'm sorry, what's the numbering?
Numbers correspond. And why would you? Because,
So I just.
Yeah, you have to fix that, so like, okay, I'm retiring, go. Here, work on that. I've been doing that with Joanne, like, okay, here's what I'm gonna finish this. While you're getting your feet under.
Okay, so this is, we have the exact.
Yeah, those things.
Yeah, this is the same work.
It's a great way.
Democrats in political trials, how we select the American period, we had corrupt selection of jurors also choosing federalist jurors or anti-federalist jurors, and this idea of politics being such a
Scientists, academics, all of this stuff. We're trying to. Not only look at how it's changing over the years, and then the one which was gross is just gross.
That's exactly what
I don't know what this one is.
That was.
So if the judges, how did they corruptly, how is it accused that they corruptly selected jurors?
Yeah, you may feel it a little bit later.
No one believes anything.
But the endorphins wear off. The adrenaline wears off.
Teaching my jury classes.
They're there too, right?
Yeah.
So we're trying to make that narrow path.
Some of the people.
So that's sweet, that's so.
Oh, yeah.
If you look at the pretty corrupt jury selection practices.
Way to roll.
Most often, and very early, very early,
Yeah, look at this.
around the two political parties. And the idea of selecting on the basis of race, but it's always.
But they should just be sharing, but just so you know that that'll be, that'll be. But they know that they're sharing.
Different groups depending on what the important divisions are in society, how we select them.
Swung me completely. Like, now they don't trust me. And so they can make it
Right, this idea of trust cases, are we gonna have all of these bodies, and how does that impact? It's fascinating.
Alright, so you have work
And as a result, I mean, when people work.
Okay.
Some people I'm sure just are not using it.
Some people might not, or they may come up, that's good to know.
Yes, oh.
So, but I usually try.
Exactly. I find that, just one more question, this case from 1934.
We should figure out,
This got rid of, this basically, so much dissatisfaction that's led to. I also have, on my phone, I can,
Yes. So
somebody in that. What was your name again? Sorry.
Yeah, I want.
Lacey, okay, thank you. It's so nice. Yeah, we really appreciate it. This is the kind of stuff that people like.
we don't need it, right? Let's just not do this anymore.
There and like open it and do all of it, yeah.
Are you saying this? Okay, I'm Melinda.
Well, that's a good
Health
issue.
In the early 20th century.
What's the first,
The first one
oh, they're different slides,
You
yeah.
go to first?
Yes.
Because so it's usually such a after dinner, and it was kind of long reading, so
No legislative discussion.
that's what we are going to we have some like highlights, but
Yeah, it seems like it's great.
saying
It's not in the, it's not in the Constitution, it's not in the, oh, that's right, the legislation, the way it's written says, that's right, it says we can choose to get rid of it or not, yeah, or install it.
The law may provide.
I think so, but then also you're right, there.
You must do it, and then they said. It's sort of a foreign actor, the Spanish or the crown, the English crown. So this is how and that's one of the reasons why the United States is thought of as still so important is that there's this federal. So we've always had sort of this external power that we're always kind of pushing against, as opposed to the Spanish or the crown. It's always sort of us against DC in some sense.
And if you're going to support tomorrow, your name should be on here.
So influenced, so
If you would just check off to confirm that you're going, that would be great, and then we'll have it. Okay? Great, thank
Spanish.
Good time. That's the thing to get a screenshot. That's exactly what you
Take the lead up and just. We're ready to start again. Okay, Mary, would you like to come? This is Mary Rose, who is a professor of sociology, but her degree is in psychology from the University of Texas at Austin. Thank you so much. Is this on? I don't think it's on. There we go. Yeah. This session is focused on selecting jurors, and I'm going to give a very brief overview of at least the US system as a way to set up a discussion of the peremptory challenges, and in doing so talking about why we have them. So I actually, in my paper, discuss that I have a not small amount of dread teaching about American jury selection to my students. I explain in the logic of the challenge for cause, in which someone is being considered for the jury, has given reasons why they might possess an actual conflict of interest. They are a blood relative of one of the parties, or they stand to benefit financially in some way from the case. So that would be a very clear conflict of interest, but also a perceived conflict of interest, something that makes them too close to the case. Or they actually say that they are unable or unwilling to be there, and in that instance, the judge is able to excuse them through a challenge for cause. And in all instances, you can name the reason why the person is being excused. And after I explain this, then we explain that there is a peremptory challenge, which, by contrast, a limited number of these are given to the parties, to the attorneys in the case. And they can dismiss people for mostly any reason whatsoever. And what I then tell my students is, if you look at the social science on this, it is not a challenge that profiles well. So I have to explain that although the several court rulings have determined that attorneys are not allowed to use, for example, race or ethnicity or gender in these decisions, you wouldn't know it by looking at the data. So there is an unfortunate patterning to the strikes. So if the excused juror is a Black individual, then they were more than twice as likely to have been excused by the prosecutor rather than the defense. And if they were if they were a white individual, they were disproportionately likely to be excused by the defense. And in civil cases, you see a similar adversarial pattern, but the parties switch. The defense usually dismisses minority jurors. Additionally, aggressive use of peremptory challenges, particularly when there are many that are given to attorneys in like high-profile cases like the death penalty, can really do quite stark racial gerrymandering of a jury, and take off whole swaths of categories of people. And then I have to tell my students that it's exceedingly hard to police any of this, and to actually challenge attorney behavior, because it's very difficult to find an attorney who can't, when challenged on their behavior, come up with a race-neutral reason for why they excuse this person. So you're a bad lawyer if you can't come up with a reason why you did that challenge. And so if I were titling this paper, I might draw on a children's book and consider the peremptory challenge the terrible, horrible, no good, very bad part. But I don't title it that. What I'm thinking about in my paper is the fact that all of those things are true, and yet I am somebody who believes that you shouldn't think about the peremptory challenge in light of some ideal way that we might select jurors to a perfect system. You should think about the peremptory challenge in light of the system that would exist if the peremptory challenge went away and all the selection decisions were made by the judge. And I happen to believe and argue that I don't think that system would be fair. So why is that? First, I think there are extreme role constraints on judges that make it hard for them to dismiss people who really should be dismissed. One type of role constraint they have is that they're the person that's responsible for replacing all the people who are excused for challenges for cause. So if they start getting too liberal, they know they have to then pull in more jurors, and they are also signaling to other people in the room that there's a way, this handy mechanism to get off the jury. And so they are necessarily inclined to be conservative, and if you have been to an American jury selection system, then you know that it is sort of dripping with these very socially desirable questions about can you be fair, can you follow instructions, will you do your duty, and that if somebody suggests that maybe they will have trouble, the judge is going to really engage in questions, fairly, I understand, but about whether they can put aside these concerns, whether they can listen with an open mind. And when you have seen the lengths to which some judges will go to rehabilitate, it raises real concerns about, are they seeing what's in front of them? The second type of role constraint is that judges are put in the awkward position of having to be lie detectors, which humans are not very good at. And as I said, they have to determine if someone's trying to wiggle out of jury duty. But additionally, they have to decide if someone who is saying that they can be fair is not being truthful either to themselves or to the court. Sherry and I did a study several years ago in which we found examples of instances where someone faced a very serious conflict in their ability to remain impartial. Think of someone's children went to school with a victim in the case, a murdered child in the case, or somebody had an experience of sexual assault in the past and is sitting on a case that involves those issues. And what we did in presenting these stories to people is vary whether the person says confidently, I can be fair, or whether they say more hesitantly, I think I can be fair. And multiple groups of attorneys and judges agreed in rating these and rating the likelihood of someone being excused through a challenge for cause, suggested that the hesitant person is more likely to be excused than the confident person. And even though nothing about their background changes with that response, they still face that conflict. And we suggested that what happens is judges pay attention to the magic words or to the hesitance in order to get around this lie detection test. So they're able to focus on being hesitant as a way to say, oh, I don't think you're right for this case. So, but in the case of somebody who says they can be fair, the judge would have to publicly say to someone who's doing their duty, I don't believe you. So in this setting of dutiful talk and promises to be fair, I see the peremptory challenge as a safety valve, one that permits attorneys to veto a judge's assessment of a juror. Additionally, I have reasons to believe that judicial behavior can shape how attorneys use their peremptory challenges. And in a report I did for the state of New Jersey, which looked at their jury selection system in criminal and civil cases, I found that even though they permit their attorneys the defense attorneys in criminal cases up to 20 peremptory challenges in serious felony cases, and the state gets 12, that in no instance did both parties use the full complement of their challenges. And in criminal cases, defense, despite having 20, used on average 6, and the state used on average 4. And why might they not use all their challenges? Well, in criminal cases, the most common way that someone was excused was through a challenge for cause. So the attorneys in New Jersey disagree, but I see the judges as liberal in how they exercise challenges for cause, that they made it possible for people not to feel all this pressure to get rid of potentially biased jurors. And so I think that we can develop a system in which judicial behavior can make attorneys do good things with fewer challenges. I also think that having a say in who sits on the case against you is an important element of procedural justice and something that makes people feel that processes are fair. Having spoken to people who completed jury selection, I found that jurors adopted what I think you once called a generally accepting attitude towards attorneys who dismiss them through the peremptory challenge. Most jurors can guess why they were excused, and accepting when they feel that this was due to a very crass stereotype, which I do need to be clear, jurors sometimes feel they were crassly stereotyped. But in general, they rate their experience with the jury process, with the jury selection system, on par with those selected on most measures. And the last point I want to make is that, and this comes from someone who cares a lot about jury diversity and opening up jury service to as many people as possible, I don't see, and the data supports me, that the peremptory challenge is the most significant reason for why we do not have more diverse juries. As I suggested, the peremptory challenge can do real damage in a single case, but the biggest predictor of what the jury looks like is the body of people who show up to a courthouse being able and willing to serve. And that in the aggregate, knowing about peremptory challenges and being excused through peremptory challenges does not tell you a whole lot about the types of people who go on to serve on juries. And so I happen to believe that we could limit, perhaps drastically, the number of peremptory challenges available to parties in order to preserve this and yet quality to them. And I look forward to thinking with you about what that number might be.
That's great. With that overview, you get the idea of where the conflicts are going to be. And now we're going to get a very different approach to the problem of representation from Sidonie Portery. She is a board member and researcher and consultant in Argentina at the Institute of Comparative Studies in Criminal and Social Sciences, but I think of her as one of the important Argentine researchers who is letting us know empirically what is going on in Argentina.
Ready? Okay, good. Good morning. First of all, thanks, of course, to Northwestern University, ABF, all the staff, and Sherry and Valerie, Hans, for organizing this great symposium. I feel very honored, and of course, I'm very grateful to them because we were learning a lot, and we have this great opportunity to share our work with you. You already know, or you had a good introduction on the Argentinian process just a minute before. As expected, the involvement of citizens in the administration of justice led to intense political debate and conflicts. Some of the most important decisions for the establishment of the jury trial concern precisely on how citizens are chosen. This presentation focuses on this particular political dimension of the law. What is the composition of the jury? Who can be a juror? How are jurors selected? I will try to explain the institutional design choices made by the provinces in response to each question. And I will identify the features common to the different laws, as well as the distinctive and conflicting aspects. For this work, we use a comparative study of the laws and parliamentary debates in the 12 provinces. I couldn't include La Rioja because it was last week, and 8 in-depth interviews with relevant stakeholders. Picking up on Aldana's argument, I will support the idea that jury laws express the search for a possible institution, the jury we can have in Argentinian context after years of postponement. Let's see the problems related with jury composition. In all provinces, the 12-person jury is composed equitably with 50% men and 50% women. In this regard, interviewees and speakers at legislative debates were all very much in agreement. Parity was a political premise of the new judicial institution. Why was it so clear for all? The acceptance of gender equality is the result of a long history of feminist struggles in the country. By the time the first law on juries was passed in Neuquén in 2011, at least 3 provinces had parity laws in the composition of electoral lists for more than a decade. A strong assumption is that it was easier to accept parity in a popular jury than in the procedure for appointing judges or other judicial officials. Argentina has in this a distinctive feature in the parity of composition of juries. Of course, these compositions solve a historical and potential problem of discrimination, and it guarantees a fair representation of the community, at least in terms of gender composition. Another distinction is that 3 provinces of our country establish a special integration for specific cases. The Chacos law, you can see in the slide, is very innovative, established 2 special compositions for the indigenous jury. First, in the cases the accused or the victim belong to the Kwong, Wichi, or Mokovi indigenous people, half of the panel of 12 jurors shall be from the same community to which they belong. But if the accused and the victim belong to the same indigenous people, then the panel of 12 jurors will be composed entirely of men and women from the same community. In the south, we have a different option. Neuquén and Rio Negro, 2 bordering provinces in the south of the country, the jury should be composed of men and women in equal parts, but in addition, it shall endeavor to ensure that at least half of the members of the jury come from the same social and cultural background as the accused. This formula of plural integration was later identified as the intercultural jury, as it was specifically designed for cases involving indigenous defendants, even though this is not mentioned. The formula for the integration of the intercultural jury is also based on the idea of jury of peers, mentioned by Neuquén lawmakers. Following, again, Handler, the purpose of citizen participation in criminal prosecution and jury trials in particular is to protect the cultural homogeneity of those who impose and receive punishments. Neither indigenous nor intercultural juries aim to achieve proportional representation of racial minorities. Instead, they are institutional forms that recognize the coexistence of indigenous people before the national state. Let's see some features of the problem of eligibility. Another characteristic of juries in Argentina is that the requirements set, with few exceptions, tend to be basic to incorporate the vast majority of society. The main concept could be expressed as follows. If you are able to vote, you are also able to judge. As expected, the most significant debates regarding the requirements focus on age and education. The decision on the level of education required for the jury was very much discussed in almost all legislatures, with more ideological arguments. Once the idea of a mixed jury was dropped, the conflicts moved to the education and age of the jurors. As you can see in the table, finally, and luckily, most of the laws are truly broad in relation to age and mostly lax in relation to education, in order to avoid a qualified jury. In relation to jury selection, Argentina has another distinguished characteristics. Since voting is mandatory, the electoral roll includes all persons of age to exercise political rights. Of course, this doesn't ensure that contact and summoning operations are free of systematic exclusions that could compromise initial representativeness. However, it is an unparalleled starting point for the jury pool to be a reasonable reflection on the demographic characteristics of the community. A second feature for the jury selection process is that no province allows more than 4 peremptory challenges per role. The system design was met with virtually no debate in the provinces in this respect. This amount of peremptory challenges, or number of peremptory challenges, was opted understanding that in the context of recent implementation of this judicial system and without a litigation culture, 4 challenges were sufficient to allow the parties to exercise a control of impartiality without the risk that judicial operators would use them to avoid jury trials. It was more important to take care of the system and give it a chance to work than to improve it as a judicial mechanism. To conclude, I would like to return now to the idea of the search for a possible institution. The historical process, as well as the local political and institutional context, can explain variations in the design of jury systems in Argentina's province compared with those in the USA, as well as variations between the provinces themselves. Important features of the jury system related to choosing the jurors, as we just saw, have been sustained from law to law: parity composition, basic requirements, the guarantee of representativeness of the annual list, and the enabling of a few peremptory challenges. These characteristics of the jury appear to have been consolidated now. Finally, I would like to share some questions for collective reflection from a comparative perspective. First, given the representativeness of the annual list in Argentina, province probably could do more to identify deficiencies in jury operations to ensure baseline representativeness. Second, despite the differences in professional culture and the dilemmas facing the US system, as May Rose just told us, it will be interesting to analyze what happens in Argentina with peremptory challenges, how they are currently used, and whether this is linked to the use of challenges for cause. At the end, we are thinking if Argentina is in its intentional diversity, sustains probably a different concept of impartiality. It would be interesting to explore in greater depth how the variations in the composition of the Argentinian jury, such as parity in general and intercultural jury in particular, or for some cases, were linked to the search for an impartial judge. I hope we can keep thinking together on this young and old institution as we are feeling jury trials in Argentina now. Thank you very much.
No problem. What we've just heard about is a very different system than the system for choosing jurors in the United States. Another area of change has been in the United States and in Canada, which will be discussed in the next 3 papers, starting with Jessica Salerno, who has just moved from Arizona State to Cornell and is a professor of psychology.
Thank you so much, and thank you so much to Sherry and Val for inviting me to speak today. I'm very excited to talk to you all today about, I want to stress some very preliminary findings on the impact of Arizona's ban on peremptory challenges on jury racial representativeness. And I want to give a particular shout out not only to my co-authors, but Rose Eerdmans, who is my doctoral student who worked very hard with me on these analyses and slides. So as Mary thankfully set up pretty well for me, despite efforts to reduce racial disparities in the legal system, racial minorities continue to be underrepresented on juries. This is a problem for many reasons. As Richard pointed out, constitutional reasons, but also research shows that racial diversity on mock juries is associated with less racially biased and generally more effective decision-making on juries. Scholars have attributed the lack of racial diversity on juries in large part to peremptory challenges, particularly the discretion that it gives to attorneys to kick people off based on race. We have the Batson versus Kentucky decision, which is the one that prohibited the use of peremptory challenges to exclude based on race. But as Mary pointed out, research shows it's very easy for attorneys to provide race-neutral reasons for kicking people off, and judges very readily accept them. So post-Batson, peremptory challenges still are used in racially disparate ways. In his decision in Batson, or in his opinion, Justice Thurgood Marshall pointed out that he believes that really the only way that we can address this goal of diversity on juries is to eliminate peremptories entirely. And in January of 2022, Arizona became the first state to do so. This gives us a nice kind of natural experiment where we can compare, fortunately, the largest county in Arizona, Maricopa, collected racial demographics before the ban. So we have racial demographics before the ban in 2019 to compare to post-ban in 2022 and 2023. But I want to point out, not only can we not make causal conclusions here because it's correlational, but a lot of other things happened at the same time. So we have the pandemic and 2 years without jury trial. Also, Arizona put forth a lot of additional reforms at the exact same time to try to help jurors with this lack of peremptories and increase juror pay as well. So our team received funding from the National Science Foundation and the National Institute of Justice to study the impact of this ban. I only have 10 minutes, which is brutally short, but I'm going to give just a few highlights for 2 components of this. The first being a survey we did of judges and attorneys. We had 82 judges and 113 attorneys, specifically who conducted trials after the ban in the first couple of years afterward. I can only give a few highlights, but by the way, I was late, but I did post a paper. So if you want details, there is a paper on the website now for this. So first of all, we just asked if they agreed with the ban. On the x-axis here, we have strongly agree on the left, ranging to strongly disagree. The big take home of all of this is that The ban was extremely divisive between judges versus attorneys, probably not a big surprise. We had the majority of judges agreeing with the ban, and the vast majority of attorneys strongly disagreeing with the ban. The open-ended comments were vicious. Judges were 20 times more likely to support the ban. In part, there was division about whether they thought it helped or made it easier on the left, through harder on the right to choose a fair and impartial jury, and to a slightly lesser degree, separately, whether they thought it made it easier or harder to select a more racially diverse jury. So we again see that judges in pink tend to agree more that it made it easier, and with attorneys thinking that it made it harder. I learned this morning, I don't have a lot of time to get into detail, but I just want to touch on a few themes we found about why they disagree. So judges tend to think that voir dire is now more efficient after the ban. They believe that they themselves are more likely to consider cause challenges and less likely to rehabilitate after the ban. And they think that the ban is good because lawyers are now forced to dig into bias and cause challenges, but they need training and help doing that because they're not very good at it in their opinion right now. Attorneys thought the opposite. They think that judges are rushing voir dire. They think that they are now less likely to consider cause challenges, more likely to rehabilitate after the ban. And they are arguing, as Mary pointed out, it's very, very difficult to exclude clearly biased jurors because they are unlikely to explicitly admit it. And even if they do, judges are heavily relying on rehabilitation. And that judges need training to do these things less. I'm gonna skip this for time, because I do want to get to the court data about whether the ban actually changed the representativeness on juries. So we have data from Maricopa County, which is the biggest county in Arizona, before the ban. I'm just going to be showing criminal trials right now. I do have civil data that we've started looking into that I can touch on a little in Q&A if we have time. Before the ban, we have data on jurors' ethnicity and race from 435 trials. And then we have after the ban, we collected from 22 and 2023. As you can see, significantly fewer trials are happening after the ban compared to before the ban. So we have for each potential juror who was called information on whether they were seated as a juror, challenged for hardship or cause, which unfortunately in our data set, they put together. So we couldn't separate those out, which is a big bummer. Whether they were challenged by peremptory before the ban, and then whether they were not seated for other reasons, either they seated the jury before they got to them or the dinner was canceled. And we compared the racial breakdown to the census data for Maricopa in 2020. As Mary pointed out, there are a lot of phases where racial disparities can happen. We start with the jury eligible population, but that gets whittled down to the jury pool. That's get whittled down further, who shows up at the courthouse in the veneer, and then who's seated on the jury. So the peremptory ban is really focused at the very end of this process. It's specifically limited to trying to reduce racial discrimination in who moves from the veneer to the jury, which we're going to look at. But also we want to look at how much that actually solves the problem of how representative these juries are compared to the population. So first we're going to look at the racial representativeness of the seated jury versus the veneer. And the way we did that is we calculated the comparative disparity. So first we started with the absolute disparity, which is the percentage of each racial group that was seated on a jury minus their representation in the veneer, and then divided by their representation in the veneer. So for example, if Black jurors made up 5% of seated jurors and 10% of the veneer, their absolute disparity would be -5%, their comparative disparity would be -50%, meaning they're showing up on juries 50% less than you would expect relative to their presence in the veneer. So here on the figure, we've got all the racial groups on the y-axis. Comparative disparity is on the x-axis. That black line in the middle, 0%, that represents perfect representation. So that would mean that they're showing up to the degree they should compared to their presence in the veneer. So anything to the left of that line means underrepresentation, anything to the right of that line means overrepresentation. So these orange bars are first pre-ban, so this is in 2019, and we see that most racial minorities are underrepresented relative to their presence in the veneer. Somewhat surprisingly, Black people were overrepresented, as were white people, and we can get into that in the Q&A. I wish I had more time to really dig in. Potentially, attorneys might be worried about the threat of a Batson challenge. We're not sure. Post-ban, we see that for most groups, those blue bars are getting closer to zero, meaning they're getting closer to perfect representation. A major bizarre exception is Asian jurors. Do not have a good explanation for this. We can chat about it. I mean, there is a big bump in Asian discrimination after COVID, could be part of it, but we're really not sure. And white jurors were just a touch more overrepresented after the ban. But after the ban, we see that Asian and Hispanic jurors remain underrepresented relative to their presence in the veneer, but it does look like the ban improved representation for a lot of these groups. But let's zoom out and see how much this actually solves the bigger problem of the degree to which the seated jury is representative of their presence in the population in the county of Maricopa. So this is the same figure, but the difference being we're comparing the racial representation on juries compared to the whole population, not the veneer. So here we see, so again, these orange bars are pre-ban. We see that all racial minorities are underrepresented relative to their presence in the population, and white jurors are overrepresented. Post-ban, we see that almost all groups are moving closer to zero, so we're seeing that the ban is improving racial representativeness for almost all groups, again, except for the Asian subgroup for some reason. But we are seeing that post-ban, all racial minorities are still underrepresented relative to their presence in the population. So what does this all mean? I think the headline that's emerging, again, from these very preliminary and correlational data are that banning peremptories does hold some promise for improving the situation at the end of the process during voir dire, but not solving the overall problem. So we found that limiting attorney discretion during voir dire by banning peremptory challenges was associated with more representative seated juries. And I didn't have time to present these data, but also in cause and hardship strikes, which I can chat about a bit in Q&A if you'd like, relative to the veneer for most racial groups. But it's not solving the overall problem. All racial minority groups remained underrepresented relative to what you would expect in their representation in the population. So this may be due to racial disparities at earlier stages of the selection process, such as Mary pointed out, the diversity of that veneer and the jury pool. Black individuals were overrepresented relative to the veneer, which was very surprising in a lot of ways, but they were underrepresented still relative to the population. So again, at least in Maricopa in these years, it looks like the underrepresentation of Black jurors in our county might have more to do with veneer composition than peremptory strikes. And thanks to all my collaborators and funding sources, I look forward to discussing.
Great. And now we'll hear from Paula Hannaford Agor, who is Director of the Center for Jury Studies at the National Center for State Courts. And this is sort of an object lesson in multiple ways to look at the same question. So you just make a methodological check in your mind as you're listening.
So good morning, everyone, and it's first of all, thank you to Sherry and to Valerie for organizing this, and it is the best part of my year is always spending a day with people who actually love and care about juries and jury trials. I am with my peeps. So thank you for that. So I'm really glad that Jessica sort of like ran through a little bit of the background on this. I was gonna actually cede her more time because there's actually a lot of background on this piece of it. We sort of had complementary studies going on. Jessica, as I understand it, because I'm just hearing some of this stuff for the first time, was really looking at the issue of does the elimination of peremptory challenge actually do anything in terms of the diversity, especially the demographic diversity, racial, ethnic diversity of the juries. Because of my work with the National Center for State Courts, we were actually more interested in the interest of sort of not trying to replicate, reinvent the wheel. We were actually much more interested in terms of what does this actually do to the dynamics of jury selection, particularly for, in terms of how do judges look at it and what are the implications for courts? If you eliminate peremptory challenges, does it actually make the process longer, more cumbersome, more streamlined? In addition to these bigger questions that Mary pointed out of just the tension between challenges for cause and peremptory challenges. Does that actually mean that that if you leave everything in the hands of a trial judge, are you going to have biased jurors actually, ending up on the jury in ways that are fundamentally unfair to especially criminal defendants, but also civil. So just, here we go. I'm gonna do the two-fisted piece here. What, is this on?
It should be working.
Okay, yeah. Okay, all right. Probably. So just to sort of go back a little bit, one of the issues around the Batson decision in 1986, it's not a great test in terms of the decision making. So it's this three-pronged test, and just the number of cases on appeal and written opinions that come out year after year after year after year is just astounding. We have now like tens of thousands of written opinions since 1986, and it's something that pretty much judges especially go, this is an absolutely unworkable process. It puts us in a terrible position of having to either agree or disagree that one of the attorneys in front of them is a racist. And the dynamics, particularly in a lot of courtrooms, in urban courtrooms, you might have like judges and attorneys that, are only, meeting each other for the first time in that particular trial and never having to interact again. We've still got a lot of rural areas around the country, and so where you've got a judge and attorney that literally are seeing each other on a daily basis over years of time, that those dynamics do not lend themselves well. And so the judges in particular have hated Batson almost since the beginning, find it very unwieldy and not helpful. So there has actually been some movement in the United States to look at this, and one of the issues is sort of, can we do something to make it less subjective? If we can introduce, and Washington State in 2018, so we've got, almost 30 years of litigation going on, finally said, this is unworkable, we're gonna introduce some reforms instead to try and introduce both an objective observer standard as opposed to this subjective, do I believe your justification for using this strike is pretextual? Would an objective observer looking at this think that race was actually contributing to the use of a peremptory strike, as well as a list of presumptively invalid justifications. The fact that you have some experience with law enforcement, or that you have come from a particular socioeconomic background, or your marital status, or your child status, or whether or not you're getting public benefits, just presumptively invalid. You cannot give those. So when Arizona was looking at this particular reform, they actually had two petitions in front of them. One of which was to do something that, like Washington's rule, that would have introduced this, or just to eliminate peremptory challenges entirely. And I actually had the privilege of actually working a little bit with the Arizona Supreme Court, and as they were sort of considering and coming up for deciding on these two, and got a call from the state court administrator in the afternoon that they actually made this decision. with him being like, oh my God, they actually did it. And I think even the justices on the Supreme Court were as surprised at what the vote outcome was as anybody else in the field. So they have they make this decision. As Jessica pointed out, though, that in addition to this, they were not unsympathetic to a lot of the concerns about what would happen if they eliminated peremptory challenges. And so they actually put in place a lot of sort of other reforms, particularly recommending that the increased use of case-specific juror questionnaires, both to be able to do a more thorough examination of the jurors and potential biases that they might have, but also, as we know from some of the research, that this can be a way of actually allowing jurors to be more candid, because they're not having to sort of put their life out in all of these, in a room full of strangers. So that was one. There was specific training and the thought that, judges, you cannot rehabilitate jurors, that you just cannot do that anymore. Some training that I think, Jessica, you actually did with judges to do just more open-ended questioning, none of the yes, no, but a more expansive and longer extended voir dire. Better record keeping. Respect for jurors' privacy. So that was a bigger issue of it. But also thinking about some of the respect for local practice, particularly about how the different rural areas work with some of these, how they go about summoning and qualifying jurors and the dynamics that go in. So with that background, we were really interested in just a couple of things more about the dynamics. We were looking with different courts. And we were actually doing, instead of looking at administrative data coming from the courts, we were looking with transcripts. And so we're working with a very small group. We had big plans to look at lots of cases. If any of you go to LSA tomorrow afternoon, if you're not going to the court and want to hear about all the methodological issues with this particular study, I'm presenting on that tomorrow. But at this point, this is very preliminary, but we only have about half of the transcripts actually coded in a way. We're hoping to go back to some of this. One of the things that we wanted to look at is what happened to the length of voir dire? That's a big question for judges is, are we taking a 3-hour process and turning it into a 3-day process? So we looked, the transcripts did not actually have timestamps really reliably. So we looked at the words per juror questioned during the voir dire process. And what we see is that actually it does go up, significantly so for civil cases. Marginally for criminal, but again, it's a small sample. This was the big thing that we are still wrestling with, is we actually thought that challenges for cause would go up. Removing people for cause, because we're working with the transcripts, we can differentiate between actual bias and hardship, and so this actually takes out the hardship group. We thought it would go, challenges for cause would go up because you're spending more time and getting more candid information. Sort of the null hypothesis, they stay the same. What we found is that they went down, particularly for criminal. So that was a change. We were also interested in, because National Center for State Courts operationally, what does this mean in terms of the size of the venires, which is a big expense for courts of how many jurors do you actually have to bring in. Predictably, the size of the venires are going down. Unpredictably, and maybe related to the fact that there are fewer challenges for cause, is they actually reduced even more than just eliminating peremptory challenges would have expected. So I'll take questions about whether or not that's a good thing or a bad thing. these are very preliminary. We're still going to sort of refine a lot of our analysis and hopefully you can get some more transcripts done. Sherry did, I am currently the director of the Center for Jury Studies for another 10 days, and then I retire. So I will have more time on my hands to look at transcripts. We really want to look at county level and that distinction between urban and rural of what happens. We do want to look at some of the task force recommendations about how much are the judges actually doing rehabilitation? What can we pick up from that? Are they using case-specific questionnaires? And then Sherry, what Sherry's been dealing with is just trying to look at how did the judges think about challenges for cause, particularly this big question that we have about why are they going down? Have they actually changed their standards and made them even more strict than they were before?
Right. And it's actually interesting if you think about what Jessica just showed us, that if our data are right about cause going down, then the attorneys were right rather than the judges, because the attorneys predicted that they would go down. Our final paper presentation in this session before we all get to dig in and talk is from Nancy Marder, who spent time looking at what has happened in Canada since it has eliminated peremptory challenges. And Nancy Marder is a professor this is very important, she's an important person that you all should know, because when we go to the courts tomorrow, we're divvying up the group, and half will be going with me and half will be going with Nancy. Nancy is a professor at Chicago-Kent Law School and the director of the Jury Studies Center there. So that's yours.
Thank you very much. And thank you, Sherry and Valerie, for organizing this conference. And let me just make sure, yes, I can work this. This is all good. As Sherry mentioned, I'm going to be talking about my project in Toronto, Canada. So Canada was the first country in North America to eliminate peremptory challenges, and it did so. Parliament passed legislation in 2019. The Supreme Court there upheld it in 2020 and issued an opinion in 2021. So the goal of my project was to see how this jury selection was working without peremptory challenges in Canada. So I wanted to observe jury selection from start to finish, from the time that prospective jurors were taken to the courthouse in a large, very large veneer or panel, until the moment that the 12 were seated as a jury. I wanted to hear the kinds of questions the judge asked, to see who was dismissed for hardship and for cause, and to observe the role that lawyers played during jury selection, since they no longer had peremptory challenges to exercise. Although this study only involves one court in Toronto, it does give you a window into how jury selection can work without peremptory challenges. This took place in the Superior Court of Justice in Toronto during the fall of 2022 and the spring of 2024. And you could see the courthouse, the white building in the background, and I love that there's this great jury sculpture. It's like the only one I've ever seen. So if you know of others, let me know. Toronto is the largest and most populous city in Canada, and the Superior Court is one of the busiest trial courts in the world. Toronto has a multicultural population, but its official language, including the language used in courts, is English, and that was important for me. The Superior Court of Justice is a non-provincial court. This means that while the courthouse itself is administered by the provincial government of Ontario, the judges in the Superior Court hear serious criminal cases where there is a right to jury trial, and these were the jury trials that no longer had peremptories. In total, I observed 14 jury selections, 12 in 2022 and 2 in 2024. In 2024, I also spent time speaking to judges and lawyers to get their explanations for some of what I observed during the jury selection and I presented my findings to the judges at the Superior Court. They completed a survey which has not been included in this presentation. My method consists of 3 stages. My first was to observe jury selections. The second was to speak with defense lawyers and prosecutors and judges and to see how they thought jury selection without peremptories was working. The third stage was to have these groups complete an anonymous survey, but so far I've only had the judges do so. The first stage proved much more difficult than I had anticipated. There was no information about when a jury selection was about to be conducted, none. This information did not appear on the website, it was not on the electronic schedule in the courthouse, it was not posted on any courtroom door. The jury administrator claimed not to know this information, nor did the jury staff. In fact, they were reluctant to be seen talking to me. I was not permitted to stay in the jury lounge to wait for a panel because they thought I might corrupt the jurors. So instead, that's me sitting on a hard, cold bench outside of the jury lounge, sometimes for hours on end. And what I would do is, if I saw a jury staff member call a group of prospective jurors and lead them toward the escalator up to a courtroom, I followed them and sat in the courtroom. Other times, I saw a staff member carrying the drum that contains the cards with the jurors' names and numbers. And so I scurried after that person, and usually that person would lead me to a jury selection. So it was not easy. As I observed each jury selection, I took copious notes, and I had a template that I had created. I know you can't read it, but I just wanted to give you a flavor, a sense of what it looked like, and it allowed me to, this is the second page, it allowed me to keep track of some of the features of the jury selection, such as the demographic background of the trial participants, how many were excused for hardship, the nature of the hardship, challenges for cause, how many and what type, the demographic background for the jury that was seated. And I thought that if anybody from the staff ever looked at what I was taking down, they would kick me out immediately. So really what I want to learn is that as each prospective juror, after they've been selected as part of a group of 20, they go out to an interior room, and each individual comes back to the witness box and stands there and takes an oath. And then the judge sometimes quickly looks at the completed juror questionnaire to see if there's a reason why the prospective juror should be excused. Judges are intent upon preserving privacy of the jurors, and they explain that some information must be discussed publicly. But my observation was that prospective jurors were not that timid. They provided far more information than the judge asked for, particularly why they couldn't serve. The questioning of prospective jurors is to enable the judge to decide whether the prospective juror cannot serve because of a hardship excuse or for cause. Hardship excuses typically included medical reason, caregiving, not understanding English adequately. For cause challenges, unlike in the US, are provided by statute, and they're fairly limited. The types of for causes that happened were exposure to pretrial publicity, if the defendant belongs to a racial minority, particularly Black, whether the prospective juror could be mindful of his or her unconscious biases and set them aside, or sometimes the nature of the charges against the defendant. There's a real anomaly in the way prospective jurors are questioned, which is that far more is known about those who are excused than those who actually serve. So if you indicate on your questionnaire that you have no issue with serving and you have nothing else to tell the judge and there's no for cause challenge, that's it, you're on. So it's very quick. And if the judge asks a little bit, has to ask a little bit more with the for-cause challenge. The judge explains what the for-cause challenge is about, and the prospective juror is supposed to answer just yes or no. So if the prospective juror says no to having seen any publicity, no to having any biases against Black men, and yes, that he or she will remain mindful about unconscious bias and try to set it aside, then those three monosyllabic responses, no, no, and yes, you're on, you can serve. Admittedly, prospective jurors do take an oath, and judges could consult with lawyers about the hardship excuses and the for-cause challenges, and many did. In terms of the numbers, I'm just giving you a very brief sense, but jury selection time took anywhere from 1 hour and 45 minutes to 5 hours and 50 minutes. In terms of the number of prospective jurors who were individually questioned, it ranged from a low of 21 to a high of 61. And even though there were no peremptories, there were still excuses for hardship, and these ranged from 7 to a high of 47. More women than men were excused for hardship in 12 out of the 14 jury selections. In 11 out of the 14, the judge used a juror questionnaire. For-cause challenges were not relevant in all 14, but they were in most. And most importantly, the racial diversity of the 14 juries. In all 14, it included people of different races, but most significantly, in 11 out of the 14, there were 3 to 6 jurors from different minority groups. So they appeared very diverse. There were a lot of variations in judges' practices during jury selection. They have common tools, but they have a lot of discretion how they exercise them. So they have discretion whether to exercise use juror questionnaires, whether to grant whether to grant hardship excuses. They have less discretion about for-cause challenges because they're statutory, but they can have discretion about whether the need to follow up with their questions about the for-cause. They also have discretion whether to seek the lawyer's input when they're trying to decide about hardship excuses and for-cause challenges. So excuses for hardship and for-cause challenges are vehicles for removing prospective jurors, why they can serve in a particular case. And judges also but there are also constraints. There are mechanisms to control who serves. And when judges seek lawyers' input, they have an additional safeguard. So quick lessons from the Canadian experience. Jury selection without peremptory challenges looks surprisingly like jury selection with peremptory challenges. Judges still dismiss prospective jurors for hardship or for cause, and they give reasons for both in open court. There are some practices in the US, like a group oath and the presence of the public, that would reinforce jurors' sense of responsibility. There are steps that courts in the US can take, such as having judges ask lawyers' views on the hardship excuses and the for-cause challenges. Not all judges do that in the Superior Court. The elimination of peremptory challenges seems to contribute to the diverse juries. But I guess my bottom line is I think Canada's jury selection should reassure judges and lawyers in the US that the hardship excuses and for-cause challenges and the use of lawyers can mean that you can still remove people who should not serve in a particular case, and that lawyers still have a role to play. So the most striking feature, at least for me, of jury selection without peremptories is how closely it looks like jury selection with peremptories. So I hope it won't be as scary a prospect in the United States, seeing how it plays out in Canada. Thank you.
Well, you've heard a lot of different views. I assume that there will be questions. Rick?
I'd like to make, actually, these are more observations, but people can comment just very quickly. One thing that we know is, social scientists, is when you count what you can count. And what we can count in terms of peremptories are the number of black or minority juries who are dismissed. What we can't count are the number of biased, prejudiced jurors, often perhaps with anti-defendant prejudices, who are seated or would be seated but for peremptory challenges. Though I have to say in this connection, I'm reminded of a terrific study that Shari and Hans Zeisel did about 40 years ago, in which they found that
Please remind us.
in which they found that lawyers were not particularly good in choosing who to dismiss, but that could be different today with modern search capabilities. None of these papers talked about the possibilities of looking at social media and other things to identify jury biases, but that could be unless other steps are taken in the future. So that's just the first observation, and I only have two. The second is that we tend to focus, like, the problem here is the peremptory challenge, that can be used to eliminate black people. My view is a lot of the problem is the law that is built up around this. After Batson, there was a possibility that it could be rigorously enforced with the benefit of the doubt given to those who felt somebody was prejudiced. But as with so much else in criminal procedure, what was given by one court began to be taken away by another, and also at the trial level. If the legal system took this seriously and was consistent, we might not have this problem today, because the kinds of people who are being dismissed through peremptories who we don't think should be dismissed might not be. Prosecutors would shy away because there would be a real danger of reversal. So a lot of the problem is there is no danger of reversal in almost all cases. So I say, don't blame the peremptory and change the system.
Well, Rick, you know that in Washington State and a few other places, they have tried to change that. And it's a little unclear at this point how it happens. Yes?
Oh, when you speak about banning the peremptory challenge, to me it's like a surprise. And I would like to ask why you have this idea of banning the peremptory challenge? Because as a criminal lawyer, I find it dangerous, because it's a powerful weapon for a lawyer, And it's also right of the accused to get out of the jury without giving reasons.
Well, it is just a little background of what happened in Arizona, and that is that the court decided to eliminate the peremptories. There was huge opposition from the bar about that taking place, but so far that seems to have held that the court had the power to do it. And what the court was concerned about was all of the evidence that peremptory challenges were being used in a discriminatory way on the basis of race in particular. So that's what led to it, and that's where the decision came. And you are on the same page with many of the lawyers who were opposed to that move. We were going to have someone who had actually a lawyer from Canada who wanted to come to this conference, and he at the last minute wasn't able to come because he had a motion that he had to argue, and he had been opposed to the elimination of peremptories in Canada. So I think there has been a difference in reaction in both of these places from the bench and the bar. Paula?
I would just add one other thing in terms of the legal context. In Arizona, peremptory challenges are established by court rule. And that's actually about across the United States with 50 states and 4 territories. It's about half and half of they're either statutory or by court rule. And so I think one of the reasons why a lot of the states have not followed Arizona is if they're in a statutory, the bar has a much larger presence typically with the state legislature and have been able to block efforts to address it there.
I have a couple of questions for Jessica. The first one, I was not surprised to hear that lawyers don't like the abolition of peremptory challenges. But I was curious if there are differences in the level of opposition between different categories of lawyers, between defense lawyers and prosecutors in criminal cases, or between plaintiffs and defense lawyers in civil cases. And also, if you have an idea, why are there so many fewer jury trials? I mean, there are other things happening at the same time, but the difference in the number of jury trials is dramatic.
Yeah, so over here.
Sorry, misconception.
Yes, so there were no differences between type of attorney. They were a united front. They all hated it by far.
Which proves that this is a system which disadvantages all lawyers.
Yes, exactly.
Can't disadvantage all their clients.
Exactly. In terms of the drop in the number of jury trials, it's very difficult to say for sure. I will say, in the surveys of the attorneys that we sampled, a lot of them mentioned, I think they're terrified of not having peremptory challenges. I think that might be factoring into it in part, is that they don't want to try cases without peremptories. I think they're scared to do so. I'm sure that's contributing to some point, but that's anecdotal evidence, obviously, based on those. They went 2 years without jury trials with COVID. I don't know how much of that had a role. But the only thing that came up explicitly, we did ask a question in the survey, are people less likely to opt for a jury trial because of this? And I'm trying to remember, I believe, we found judge versus attorney differences on everything, but I was surprised that they didn't say yes more than they did. I remember having that feeling. Unfortunately, I don't have the exact numbers, but that might be contributing to it. But that's why we collected more data. If we only look, because we were just going to look at 2019 and 2022, and there were so few trials in 2022, we took another 6 months of 2023. So I think that might have contributed to it. The attorneys just hate the idea of going to trial without them.
Quick follow-up. Any indication across the time period of a bounce back, that the number might be going up in 2023 or after that, after they get used to it?
Unfortunately, I don't have data past that window. It's actually something that we do. So we have been getting updates from the courts ever since up until now. We haven't collated it to be able to analyze it. So it's a question we might be able to answer soon, but not at the moment.
Yes, one.
I just had a question also about your study in Arizona. One of the reasons, my understanding, one of the reasons for the peremptory challenge isn't necessarily so much to shape the power of of what the jury looks like, but rather to push back against the authority of judges. It's an institutional protection to limit the authority of judges who might be less inclined to dismiss certain people. And in Arizona, you have elected judges. They face retention elections, and I'd be curious to see, and I'm wondering if you might see something like this, about when for-cause challenges are more likely or less likely to be granted if they correspond with those election timelines. Given the judges' incentives at those times.
In Maricopa, they're elected, but in some of the counties that Paula generated data from, they are not elected.
So this is, so you are.
No, Maricopa, they're actually appointed.
They're appointed, I thought they
it's
faced
the other way
retention
around.
elections.
Yeah, and that's,
Yeah.
it's hard to not win those.
So
It's absolutely retention, totally across the board. We see those as low salience elections, but I'd be really curious to see when the judges are put in a position, in a new position in relation to jurors, perhaps if we see any distinctions there.
It's an interesting question. We do have information about who is the judge in each trial. We have, as Paula pointed out, unfortunately, so in my big aggregate data set, we don't have cause and hardship separated out, unfortunately, but as a clump at least, we could potentially look at I mean, we have the date of the trial, we have the judge. I had never thought of doing that kind of analysis.
There are
but-
studies around how judges rule in actual rulings around election time, we see distinctions there, and I'd be curious to see if we see a difference. How far those elections influence judicial behavior, perhaps even considered.
Interesting.
Valerie?
Yeah, thanks to Carla, I was able to actually observe a jury selection in Mayo Kent. That is the jury, that's the place with one peremptory challenge. And the prosecution team allowed me to come with them as they debated how to use that one peremptory challenge. And it was a really intense discussion. I mean, they obviously they valued it very much. But another thing that was fascinating about this is that the lawyers did an incredible amount of the questioning. And this is something I'm really wondering about the Arizona papers. Maybe I missed it in your papers, but I didn't see a discussion about whether, as you might want, that the role of the defense attorney and prosecuting attorney and plaintiff's attorneys actually expands in this no peremptory challenge environment. I mean, it should, right? If judges are saying, well, let's give them something now that we have taken away their ability to actually exercise a challenge.
So this goes back to Nancy's observations, and that is huge variation across judges in what they do. And so we'll be able to say something about that. But the enormous variation across judges it's a topic that actually the research doesn't talk much about, but it is huge. And Nancy saw it in the voir dire in even in 14 cases, and we're seeing it in the transcripts from Arizona.
Yeah, and
we're supposed to have gone on break. What we can do is we can just take a few more questions, because this is a lively debate and I don't want to cut it off, and then just go directly into the next session. Okay? Right.
I think
Yes.
Jessica wanted to respond, I think.
Oh, sorry.
Yeah, that's all right.
No, a question for Sidonie. It's, I think it's amazing what you did in Argentina in terms of parity. I mean, it's a new approach to try to get more diverse juries. And I wonder if the political change that experienced your country has made some noise to this type of decision. I just want to know if how now it's perceived, it's in talk, or there have been a movement trying to go back, I don't know.
Now, just now, because of the national change.
Yeah.
No, it's difficult to explain, but the government has a law to introduce jury trials at federal level. So they have like a speech related to give the power to the people again. So in that sense or narrative, they took the option to try to discuss this at the parliament. And last year, we had for the first time an approval at the commission in deputy chamber. So there are probably chances to be discussed in the Congress in the next month, maybe depending on the results of the legislative elections we have on October. But it was not as we could suppose that they were going to reject jury trials. They, our president now, he's like very inspired in the US system, so he understands in this point that it's a good feature to copy or to reestablish as our constitution mandate. So it's a weird opportunity to move on at the federal level too.
Sorry, we should add that we are a federal country. So all these laws that pass it, and Dana said in all 14 provinces now, 13,
Yes,
13
provinces.
they are regional, they are from each state. So they cannot do anything on the federal level. That.
No, and the court, as Aldana told before, has support the different shapes or models that Argentinian provinces had adopted. So it's pretty it's a very good moment, and we think it's can also
moving
add
things
another provinces too.
Okay, that's great, everything, but if we go straight into the next session, then we can make up time. Okay, we're going to do that, great. Nobody's standing up and yelling at me. Okay, right, all right. And this is a very important section because this is about the content of the trial itself. And we have a number of distinguished presenters here and crucial topics. So we're going to start with Professor Duce and from Chile, and he is going to talk. He's a lawyer and professor at the Pontificia
Catholic University.
Catholic University, and he is going to begin our session.
Well, thank you very much to the organizer for the kind invitation. I have just 10 minutes, so I will do very fast. Basically, I will give you context about Latin America. My country, Chile, do not have juries, so I will talk a little bit about what has been happening in the region in the last 30 years. And basically, my paper goes to 2 points. The first point is to give you an overview of the criminal justice reform in the region and explain you some basic features of the new procedure implemented because of this reform. And the second part of the paper goes to review some basic evidentiary rules that are related at trials, basically in 3 areas that you have here in the slide. Okay, let's talk a little bit about the reform process. Let me stress a couple of points that I think are very important, particularly for the North American audience. First of all, you will not understand this reform process if you don't have in your head the idea of radical change. When you talk about with people from US and you explain that we are involved or we were involved in a reform, that you tend to think in minor adjustments or fine-tuning reforms, and we did a radical change. Radical change means a complete replacement of the old system, taking the elements that Lawrence Friedman said belongs to any legal system. We attempt to change all the 3 levels: substance, rules, structure, institutions, and also we were very ambitious. We tried to change culture, values, understanding how the things going on, internal culture and external culture too. In procedural terms, we moved from different forms of inquisitorial system to what has been called here by others as an accusatory procedure, which is not exactly the same. I will go back to that. Okay, accusatory procedure for us is basically we took the rules that were being developed in Europe after the 70s, particularly in Germany. So we did not take the adversarial systems such as in US, but the development that European countries has experienced in the last, 30, 40 years. Actually, there was a model developed by legal scholars in the region, the model code that was developed in 1989, that basically copied or took rules from the German procedure after the reform that Germany has in the 70s. But there was a point in which many countries began to adopt new adversarial features for their regulation. Chile probably is one of the first in 2000, but then, for instance, Colombia is an extreme case. Colombia took several federal evidence rules and they put those rules in their code. Probably they are not understanding the rules and not using the rule in a way that you understand the rules. So that goes to another point. This has not been a process that you can describe, in my opinion, as a legal transplants, but rather legal translation, taking the concept of Maximo Langer, meaning that there was a process of cultural understanding, adaptation, and change. So you will find probably in Latin America a new synthesis of pre-existing comparative models. If you go to Chile, an American lawyer goes to Chile and see a trial, probably they will say, that looks a little bit like here, but with 3 judges instead of jury. And if the same lawyer goes to Costa Rica, probably will say, doesn't look very similar to what we are doing in my country.
And probably a German lawyer will go to Costa Rica and will say, this is very similar, and to Chile say, this is our American guys, whatever. So it's a lot of differences and probably a new synthesis at comparative level. Third element, you have to understand that it was a regional movement, not isolated effort by each country. Because we share similar problems, we have similar strategies, there were very strong links among reformers in each country, so you can see that this was moving as a waves in the region. And finally, you will find that there were different programs at play. Some reformers want to do this because increasing due process rights. This is a very important agenda of the reform, but at the same time was an important agenda of introducing new tools to manage better management of the system, and at the same time, there was the idea to democratize our criminal justice systems, meaning more transparency, accountability, so on and so forth. Okay, here you have the map. 17 out of 19 countries that you can put under the umbrella of Latin America did this reform. Only exceptions, Brazil, but you can present your case, and Cuba. And the first reform, Guatemala, 1994. The last one, our friends from Uruguay, 2017. Okay, there was a lot of forces that are behind this process. That these legal changes are not happening because lawyers are great. It's because something is happening. I don't have time to go to this. But let me emphasize that, in my opinion, it's not just a coincidence that this process happened when we were in the middle of our transition to democracy processes. Transition to democracy processes open up a window of opportunity of institutional change in the region, and I think that gives us the chance to make this type of reforms. The problem is that window of opportunity has been closed in many countries, and now I see a new window of opportunity for institutional change, which is a new form of authoritarian democratic governments in the region. So that's a little bit concerned in terms of, for instance, the agenda of democratizing justice could lead to different type of reform that we probably are thinking. Another example is the role of international players. I have seen some bias in North American literature about that because they treat us a little bit like we are the same in terms of the level of the international players, for instance, USAID. And it's completely different in different countries. USAID has a lot of, for instance, participation in Colombia and Bolivia. Chile, not very important. So there's a lot of different there that you have to think with, but international players was a force or factor that was there, of course. Okay, in terms of procedural change, I have 4 minutes, so it's incredible. That picture represents the procedure in Chile before the changes. That means many things. Complete concentration of power in the hands of a single judge that was in charge of investigation, present charges, indict, and take the final decision. The very same judge, everything written, secret for the defendant, no discretion, at least in formal terms. Of course, under the RAT, there was a lot of discretion, but not control. There was no form of trial. This is the Chilean case. In many countries in Latin America, they have a sort of type of trial, but not like you can imagine. And all the decision was taken by the dossier. And very limited victim rights. This reform process also coincides with the movement of victim rights. Probably Veronica will talk a little bit about that. The accusatory procedure, separation of functions between prosecutors and judges usually between pre-trial judges and trial courts. Okay, let me skip a couple of things. Limited discretion has been the way to introduce a lot of pre-trial diversion, pre-trial alternatives, and also functional equivalents to plea bargaining in Latin America that are playing an important role. But the backbone is the picture. The public trials, in most of the cases, handled by courts integrated by 3 professional judges, with the exception of the country that has juries that we have been heard. And ample victim rights, or at least the increase of the scope of the victim rights. Okay, let's go to the second part, 3 minutes. Let me skip that. Okay, first, a decision has to be made in terms of the mean of proof that can be, the sources that can be used at trial. The 17 countries took the same decision to advance what we call free proof or evidentiary freedom. basically the same rule in the 17 codes that I reviewed for Argentina. I'm talking about the Código de Provincia de Buenos Aires. Sorry, the other regions, but I took the biggest one. Otherwise, it would be very, very difficult to do it. Basically, any means or source of information could be used in Latin America as evidence if it meets two requirements. It's relevant or the interest to the case, as many codes regulate, and second is introduced according to the law. That gives room to the exclusion, for instance, for violation of due process rights or something like that. Okay, the main challenge that I find out is not over there. It's here. The main challenge is the way in which have been this free proof principle understood. And according to empirical evidence that I collected in Chile and a lot of anecdotal evidence that have been collected across the region, it's understood as an absolute freedom, which means no filter in terms of admissibility of evidence, that posing a lot of problems in terms of organizing trial, because our trial has much more information that we should have in terms of relevant information, in terms of abundant information, so on and so forth. Second decision, how we will evaluate the proof. And again, the principle of free evaluation was the most important decision out there for most of the country. At least 14 out of 17 countries has an explicit rule on that, taken from the model from Ibero-America. This principle is understood not as an absolute freedom, but as a reasoned conviction, as we call it, or rational or sound criticism, which means with some limits. And those limits are basically two. You have to respect the rule of rational inference to take the decisions, the scientific knowledge, and the maxims of experience, whatever that means. But this is a limit. You cannot go beyond those limits. And second, and probably most important, most of the code impose a very strong duty for judges to do detailed written justification of their decisions. The main challenge here had been that if you review the written decisions in most Latin American countries, they are very long, very, very long decisions, but with formalistic evaluating reasonings, which means that most of the decisions are transcripts, but you will not find reasoning. I mean, why this or that judge think on that, how they evaluate, it's not very clear. And third element, the standard of proof, you will find a greater level of diversity in the rules in the region, probably because it was a point very not well understood even in the beginning of the discussion for the new codes in the late 80s and early 90s. The CPC model, the model code, do not have a clear rule, but rather a rule regarding to presumption of ignorance, the in dubio pro reo principle. So for that reason, you will see that 7 out of 17 countries have explicitly introduced the beyond reasonable doubt standard or reasonable doubt standard. Chile was the first case to introduce it in the year 2000, and then many countries began. There's, at least in my research, 3 other countries that has the idea of doubt, and the case law of the Superior Court introduced it. And there's some countries that do not have a clear rule or still stick in all type of standard like intimate conviction, so on and so forth. But what's happening here is that the Inter-American Court, someone mentioned that, have a couple of rulings at least from 2017 that said that the presumption of innocence imposed the beyond reasonable doubt standard of proof in the region. The challenges here are it's a little bit more complex. I have empirical research in Chile, but basically in 30 seconds, because I'm completely running out of time. Even though there's some positive things in the introduction of the beyond reasonable doubt standard, because there had been more effort to justify the decisions, there had been a movement from subjective understanding of the standard to an objective understanding of the standard, so on and so forth. But at the end, it is very unclear the meaning of the standard. And it's not a surprise. I mean, here you have, I don't know, Larry Loudon said that about US 20 years ago. And probably the main point here is what we can expect from a standard of proof more than this.
because there's a lot of theoretical debate in Latin America regarding how to improve the standard, but maybe the standard gives you some basics, and I don't know, maybe we cannot expect much more than some initial positive results. Anyway, this is my email. Thank you very much for your time.
This is, the next speaker is Rick Lampert, who is Professor Emeritus at the University of Michigan Law School and the author of a widely used casebook on evidence.
And Sam is a co-author of that?
And Sam, we have two, okay, great. Right, all yours.
Okay, so my remit when I was invited to give a paper was to discuss the rules of evidence. That does not give you very much guidance. I began with the question, okay, what am I supposed to discuss? What are rules of evidence? As it turned out, I sort of wrote two papers, so I will discuss them in turn. The first was this, what are the rules of evidence? And to try to answer this, I thought, for me, it's easy. I'm an American lawyer. Here's this pamphlet. It says federal rules. Here are the rules of evidence. But I thought that might be a bit parochial. So I should look at other countries and see what they did. I'm not a comparativist, but I did assemble what I call a grab bag sample of articles and codes from maybe 20 different countries to try to read as broadly as I could in the time that I had and how evidence was handled in different countries. I found that answering the question, what are the rules of evidence, was a much more difficult enterprise than I thought they might be. That in many countries around the globe, you can't find anything that's labeled rules of evidence. You can find codes of criminal procedure, you can find codes of civil procedure, and within these codes, if you're lucky with a couple, you will actually find a chapter that says rules of evidence. In many of them, you'll find nothing of that sort, and you read through them and you kind of see what regulates evidence. And this, looking at this, gave me a new perspective on our own federal rules. Because, I teach it, but when you teach the rules of evidence in law school, probably 85% of what you do is you talk about the exclusionary rules. But a lot of the rules, including the federal rules, are procedural and not exclusionary. In fact, there's a blending of what is substantive, what is exclusionary, and what is procedural. And there's no hard line, and that becomes visible when you look comparatively at how the rules operate in different countries. I'm not going to dwell on this. I'll just say the most interesting finding for me was that there seems to be a convergence between the classic inquisitorial and continental model and the US model, in the sense that in Britain, in the common law countries, the rules are getting softer when it comes to exclusion. I'm now talking about the exclusionary rules, that more hearsay is admitted, exceptions expand, and in most cases, with perhaps opinion evidence be the expert evidence being the outlier, they look more like systems of free proof than I think they ever have. On the other hand, in a number of the continental countries, we're seeing that there are real rules that are being imposed. A lot of them have been done through international treaties of human rights. And what they impose are what we would think of as constitutional rules of evidence, exclusionary rules for, certain kinds of interrogations or other things. But there are other rules like hearsay that occasionally will pop up in some of these continental codes. Okay, so that's paper one. As I finished this, I had something in mind, but then I kind of noticed that my paper was supposed to be in a section called construction of the jury. I wasn't really talking about the construction of the jury in this first subpaper, so I thought I should turn to that. I owed it to the organizers of this conference to at least address the topic they were concerned with. And when you look at the jury and you look at rules of evidence, you find a mutual, I would say a mutual shaping. The rules of evidence shape the jury, but the jury system has shaped the rules of evidence. So it's easy to see how they shape the jury. They determine what the jury can hear and what's admissible. And here I'm just going to focus on rules of admissibility. But from the start, it was the jury that shaped the rules of evidence. The primary rule of evidence in England up through probably the 16th, 17th, at least the 17th century, into the 18th, was that all testimony basically should be oral, or you should have sort of documents that were clearly acceptable because they were sealed. They were under a certain seal. And when you think about it, why should that be? When the continent had a very different written system. Well, if you're taking ordinary people from the neighborhood of a crime, for example, many of them won't read English if you're talking about 16th century England, and certainly if you're talking about 13th century England when the jury arose. Now, seeing that reciprocal relationship, I thought about the implications of this for countries that are new to the jury system and grappling with what, if any, rules of evidence should apply. That the place to begin thinking about this might not be to begin thinking about rules of evidence to say, here's the US model, what should we adopt, which is something that a lot of people look to, but to think about the characteristics of juries. How should we structure our juries if we're just forming them to affect the evidence that juries are capable of dealing with? And I tried to think of a couple of examples. One I find really interesting is what is happening in Argentina, where we've heard juries are half men, half women. I don't know what follows from that, but I think something must follow about the admissibility of sexual history evidence. If you have a jury in which there's going to be half the women, to give a perspective that all male juries would not have had. So maybe one thinking about that subset of rules of evidence would come out with a different set of rules than one might be in a country like the United States. I also used a couple of examples. So hearsay. The hearsay rule as it's now developed in our country is almost impossible to either teach or apply. One rule with 80 exceptions, and then if you don't like any of these exceptions, find another one. And yet hearsay really has weaknesses. And we don't know, and it will be weaker in some circumstances, and in some cases, maybe stronger. And I thought, inspired again by, keep sort of flattering Shari, I guess, but she's paying my way here. She did this really great study with Jay Casper called Blindfolding the Jury, in which they found that if juries understood why the rule for triple damages existed, maybe they would actually do what they're supposed to do and give the real level of damages. Anyway, and I thought about that, and I thought, well, maybe juries understood hearsay better. If we structured that part of it, juries could do a much better job handling hearsay, and we can move towards this relaxation of the hearsay rule, which is happening in practice whether we want it to or not. And so part of my paper, I sort of come up with a model instruction. People can tear into it if they want, but the idea is that there's a literature on pre-instructing juries that shows, particularly if you instruct them before and after, before the trial begins, and then after, before they deliberate, that these instructions have real effects. Most of that research is not directly on point because they deal with substantive, not procedural issues, but I thought maybe we could restructure that jury system. Another thing I thought about was the opinion rule and scientific evidence. Juries are thought not to handle it very well. Well, one reform which is happening in lots of places now, but could affect perhaps the rules that we apply, is simply allowing juries to ask questions. Because then they're just not going to be helpless passive observers, but they can push back on what experts tell them. We can even go further and have an expert or expert panel that the jury could ask questions of as well. Or we can engage in hot tubbing, in which an expert for each side will testify at the same time. And couple that with an active questioning jury, that may be enough, and we can get rid of a lot of the Daubert stuff that now occurs, except in the most extreme cases. I don't know, but it's something that's worth thinking about. Going beyond jury changes, what about other rules for the new jury system? I think one of the things we have to realize when we think about rules of evidence is they're based on people, or they're developed, I should say, by people with wild imaginations. They imagine how juries behave, they imagine what is probative, what isn't probative, with no attempt often to link these things to reality. They've not really been studied. I mean, one good example is excited utterance, which was supposed to be a great exception in the hearsay rule, because God, these people are excited, they can't lie. Well, that's probably wrong, but even beyond that, they can still misremember, misperceive, and other things. So we kind of invent that. So a first step, if I were thinking about this for a new country, is to look at whether the imagined jury, because also juries can't handle certain things, whether the imagined jury is in fact the real jury, which requires both thinking and it also requires empirical research before you arrive at certain of these conclusions. So I'll just give one final example. The federal rules, and I don't know about other countries, but allow impeachment by prior crimes. And the crimes ordinarily have to be serious and really outweigh prejudice of the defendant, but there's a subset of prior crimes that don't have to be that. And these are the ones where you've committed perjury, you've done something about lying. Well, that imagined person is someone who is a liar, and he's been found to be a liar. Well, is that person any more likely to lie than anybody else whose fortune is on the line, say the person who's been convicted or is being charged with burglary, or has a past crime of burglary? Why should we separate out, except we imagine this kind of personality that lies, which probably does not exist in the highly selected circumstance of a person actually charged with a crime and on trial. So it's this kind of thinking, and based on research, which there should be, which I believe should stimulate people who have the virtue of not being trapped in an historical kind of path-dependent jury system, but can actually improve on the jury system and maybe teach us in my country how we can do a better job. And then finally, I think one also has to distinguish between two kinds of exclusionary rules of evidence. The first, people like me, social scientists and others, can contribute to, and these are the rules designed to improve the quality of fact-finding by juries. And that's what the exclusionary rules are in theory, or a lot of them are about. But there's a whole nother set of rules of evidence, constitutional rules and other policy rules, privileges being the best example, which have nothing to do with and can even impede the search for truth, but they have a lot to do with other values, they have a lot to do with the social effects of not having the rule, if you knew what everything you told your attorney you'd be compelled to say in court, it would change the attorney-client relationship and everything else about the system. So there, I think, countries that are new to the rules of evidence have to think about their own policies and what they value and what they're willing to sacrifice in terms of finding the truth for their own values. Okay, thank you. I could trip you up.
So we've got us to our later afternoon's activity and set the agenda already. Great. Okay, she's ready? Okay, so we are now we now have a speaker who is going to introduce another kind of topic here, slightly different, which is part of the trial, but a very interesting aspect of trials that are not true in the United States, but are true quite frequently across Latin America. And so, am I in the wrong order? Is Veronica first?
No.
Natalie. Oh, okay, great. So we have a colleague who had a very sick child and was unable to be with us in person. And so she is going to be with us by Zoom and
I'm here, Sherry. I'm not sure if you can hear me or see me.
We can hear you.
Can she share her screen?
Did you share your screen?
1 second, then give me 1 minute because I need to close some windows then.
Okay, I will introduce you while you're doing that. Natalie is a lawyer, not just in Argentina, but also in Canada. And so she has had a view of private prosecutors.
If you remove the pin, you can see her. You have to
She does have slides.
Yes. Yeah. If you want, we can pass it. I don't know if it's in the computer. Can I help you?
She said she had to close some screens in order to get her.
She preferred to.
Good for her?
Yeah, because.
Oh, we're doing her slides here. She's not doing her slides. Okay, nobody.
It's the
sorry.
same, I think so. So
She.
I don't know what Natalie prefers, but that it helps, we can do that.
Let's see, there she is.
I can, yeah.
Her face.
Do you want to advance your screens or should we?
I think if you can, if maybe Sidonie or Aldana can stay there.
Of course. Wait, we're here. Don't worry about that.
1 second then.
Natalie, check. What?
Tripping? I know some people have fallen. You don't want to take any of your.
Yes, we send it.
And I can let Aldana know when I need that, or you'll notice because you've done the paper with me, but in case you need some help, I can let you know.
We send it, but I don't know why it isn't here.
It's not there?
¿Te fijas en cómo está el título del slide? No, but we send it to Sophie. Natalie sent it. I don't know.
And it should be there.
Yeah.
Happy to resend it if need be.
Use this.
Natalie, ¿me decís el título cómo estaba?
Give me an email.
Let me tell you.
Yeah. Sorry.
1 minute. Paper presentation, it's the name.
Paper presentation.
Just that.
The role of the victim in the criminal justice system, ArgCAN. That's the name of the PowerPoint.
I didn't see it here, but don't worry, we have a pen drive. We are going to.
I can also resend it.
No. Sidonie already has it. Don't worry. And I am being here to pass the slides you are going to talk. If you want to introduce at least
No dividido.
me. Right.
Paper presentation.
No, that's the word, I think, the written part. But I'm not sure if someone changed the name.
That's a
Slide o el Word.
No, the slides.
Para hacer Word, estamos en slide.
Give me 1 second.
Sorry, if you want to start to. ¿Quieres empezar una intro? Vamos a hacerlo mientras descarga lo que quieras.
Shari, would you want me to start and without the PowerPoint, and then I think the most importantly, there are 2 slides that I think are gonna be useful. So I can start and come back.
Why don't you start? That's great. Go ahead. Yeah.
But
She said there are 2 slides, so
like for me, there's slides that are more important. The rest I can handle without it. Okay, so while they figured this out, as you can see, with Sidonie Portery and Aldana Romano, we've been working on this paper, which is a work in progress. We are intending to highlight the form of victim participation in criminal trials, including jury trials, both in Argentina and perfect, there it is. Okay, in Canada and in Argentina. And Sidonia and Aldana will hopefully join me during the Q&A part of the presentation. In Argentina, we will focus on one of the provinces called Chaco. We have there what it's called querella. This is a third party, not defense, not prosecutor. We call it private prosecutor or querella. This third party is allowed to participate in criminal trials, advocating for the victim, and their participation is not mandatory, it's completely optional. In Canada, what we have is a council called Complainants Council, who represents the victims in sexual offenses and only in very specific application. And I will come back to the comparison later. We can start now with the slide that addresses the legislative background. You let me know if perfect. Next one. That talks about the Argentinian system. So we know that many civil law jurisdictions have querellas as third party in criminal cases. For us in Argentina, is the last 40 years. Between 1976 and, okay, perfect. Between 1976 and 1983, Argentina was ruled by military dictatorships responsible for severe human rights violation, including torture and killing. After democracy was restored in 1983, people began to question the concentration of power in the state's prosecutor's office. And as Mauricio described just minutes ago, in Chile, this also brought some changes to our region, including Argentina. So the push to investigate and prosecute crimes committed during military dictatorships came mainly from civil society groups, often in opposition to political and judicial leaders. So by 1993, during the National Congress on Criminal Procedure Law, this led to the inclusion of private prosecutors in criminal trials. This is how the system was born in Argentina, or the reason why it was born. If we can now go to the next slide, the Canadian system. So before the 12th century, victims or their family were the ones who took actions, right? Like, I'm gonna leave it very briefly there because we only have 10 minutes. I wanna focus on the more recent story. But in Canada, following the introduction of the Canadian Charter of Rights and Freedoms, we call it the Charter, that was in 1982, Parliament made several amendments to the criminal code to enhance the role of victims in criminal procedures. And there's a special interest in protecting complainants in sexual assault offenses. Charter principles, particularly Section 7, life, liberty, and security of the person, and Section 15 of the Charter, equality rights, are the key to understanding the enhanced role of victims after the Charter was born. Both the Supreme Court of Canada and the Parliament have been trying to balance these accused rights to a fair trial with the victim's right to dignity, privacy, and equality, especially in sexual assault offenses, while also considering the public interest in the truth. I can go to the next slide now. Next. Perfect. So I'm going to now talk about the role of the querella, the role of the private prosecutor in Chaco. Chaco allows private prosecutors to work alongside the state prosecutor or even take over a case if the state decides not to continue. This is massive. So even in a situation when the state prosecutor decides not to proceed, private prosecutors can proceed alone. So they are party in the proceedings. They are involved in every stage from beginning to the end, and this includes trial. And they are on equal footing with the state prosecutor. They can present its evidence or join the state. They can participate in jury selection, although it must coordinate the use of peremptory challenges which it shares with the prosecution. Has the right to make its opening and closing statements, present their own witness, and examine and cross-examine. Trying to be brief here, there's a lot to say, but only some minutes. So let's move to the next slide. There's a study now on jury trials in Chaco. This is INESEP, Valerie Hans, so Cornell University, and Chaco's Superior Court of Justice. They've been analyzing the first 30 jury trials since 2019 there in the province of Chaco. What the research shows is that private prosecutors have been involved in 70% of cases. So 21 out of the 30 jury trials, there were private prosecutors involved. Judges were asked about the coordination between state and private prosecutors. In 12 jury trials, well, there's a typo there. Judges assessed that they both, sorry about that, that they both coordinated quite a bit or a lot in presenting the case. In 6, they considered the coordination to be moderate, and in only 3 cases, the response was there was little coordination. We can move to the next slide. So you can see there's a photo of the 3 parties, and it says defensa, querella, fiscal. So we have the 3 parties sitting there and again, state and private prosecution on equal footing. And as you can see here in the PowerPoint, you can read what counsel said during an interview, and the idea that private prosecutors humanize the victim, right? So the state prosecution usually assumes a more technical role, and the private prosecution is focused on telling the victim's story, giving them a voice. So in practice, during the trial, the querella tends to act almost as an auxiliary to the state, right? It's an aid to the state. We can go to the next slide. So who is this counsel that represent the victims? Interestingly, victims in Chaco have the right to be represented by public defenders. So public defenders are defense counsel working for the province. So victims can either decide if they want to have public defenders acting as their private prosecutors, or they can pay for their own counsel. But if they want to have one at no cost, they can go and seek help from public defenders. So we have public defenders in Chaco who work for the state, and they also may serve as defense counsel, depending on the case. So you can see there an interview, right? Let me talk about that. Well, I don't have time. Let's move. Let's move to the next one. 1 second. Okay, no, let me come back. I think I need to say something. Yes. This is what someone says during the interview. This is counsel, defense counsel working for the state, talking about how he feels when he performs the role of a private prosecutor. So he's saying, I need to wear different hats, and I need to change my mindset depending on the role I have to play. This could be a bit challenging, right, to wear 2 hats. And however, it's notable that in 5 cases that were part of this research, where public defender acted as private prosecution, judges reporting a strong coordination between state and private prosecution. So there's some food for thought here, right? And now let's go to complainants counsel in Canada. Thank you. Very different from the role of private prosecutors in Argentina, specifically in Chaco. I'm not going to get too technical here, but I will summarize the role. How does it work? The criminal code, allows complainants in sexual assault offenses, to have a voice during criminal proceedings. Any involvement happens in camera. The court will excuse the jury and the public and will lock the doors. The jury will never see the complainant's counsel advocating for the victims. It's a very limited role. In a nutshell, in a case where the court must make a ruling about admissibility of private records, hospital records, employment records, text messages, notes from psychologists, from psychiatrists that are either in the hands of the of the accused or a third party, for example, a doctor with notes from, or psychologists with notes from the session. So these records, when these records relate to the complainant in a sexual assault case, there will be a hearing where counsel for the complainant can take. And so the criminal code allows victims either alone, they can be alone, or represented by counsel to participate in these hearings. And the goal to be involved with the hope of preventing that certain records, these records that I just named, for example, right, like those are some of many, from being disclosed later during the trial. It is a right to have counsel, and it is a right to be informed of this right. And generally, it is expected to seek this application before the trial proper. So before the jury trial, we want to avoid wasting trial time. And this is particularly right in jury trials because judges, they don't want to waste citizens' time. One side note, complainant counsel also can assist victims in hearings where the prosecutor or the accused asks the court to assess whether evidence of the complainant's prior sexual activity can be admitted in a trial. So this is interesting because the fact that prosecutors can seek permission from the court to lead evidence of a complainant's other sexual activity is an example of how prosecutors are not lawyers for the victims. Their role is not to advocate for them, but to pursue justice. Therefore, a perfect explanation as to why complainants' counsel is of great assistance, as the interests of prosecutors and complainants are not necessarily aligned. What happens in camera? Complainants' counsel is allowed to make oral and written submissions. They do not have the right to cross-examine the accused. The purpose is to present the complainant's perspective to help the court decide where the evidence should go in. This role is very confined to the application, does not extend to the trial proper, and does not involve standing during the trial. Moreover, complainants' counsel are not allowed to advise victims regarding the trial itself. So who pays for it? So this is the end of that slide. Regarding funding, each Canadian province determines whether the complainant's counsel is covered. For example, I work as defense counsel here in British Columbia. So in this province, legal aid provides representation through a list of lawyers with specialized training in this area. I'm not one of them. There's lawyers that really specialize in this area and are trained in this area. Generally, referrals are made by prosecutors, but complainants could also reach out to legal aid and ask for representation, which will be free, and it's not subject to any financial eligibility assessment in these cases. Perfect. So there's some debate. There is debate around victim participation, and it's about allowing these greater participatory rights for complainant. What I can tell you is the Supreme Court of Canada had to address applications from accused individuals challenging these sections, arguing they violated charter rights. For example, fair trial. One of the arguments was that granting participatory rights to complainant altered the structure of a trial, disrupted the role of the prosecutor. The Supreme Court disagreed. That was in 2022. The answer was that the present is justified because they have a direct and personal interest in whether private records are shown in open court. They're in the best position to explain how releasing these records could affect their privacy, something directly relevant to whether the evidence should then go in, right, during trial. They also said that there's a very limited role that they play. They are not prosecutors. They don't have the right to participate in the trial proper. The involvement doesn't change the basic structure of the criminal procedure. And the victim's input isn't meant to echo the prosecutor's argument. It's at a different and valuable viewpoint. 2 more slides and I'm finishing, I promise. I'm not keeping track of the time, but I'm hoping I have 2 more minutes. Do I?
2 minutes.
1 minute? 2 minutes? Perfect. I can do that. So let's get a little bit visual here. We have a table comparing the 2 systems. It's what I told you already, right? The civil law versus common law, equal footing versus limited role in camera, whereas in Argentina, we have them before the jury. We have granted broad powers to victims in Argentina, whereas here, the jury does not see or hear any submissions from complainant's counsel, and it's very specific to pretrial applications performing a limited role. In one case, in a nutshell, it was created because of military government, distrust and distance between prosecutors and victims. In a nutshell, also, there were charter reasons for enhancing victims' rights in sexual offense cases. Counsel, usually defense counsel, acting as a complainant's counsel in Canada, a right and should be informed of this right. Counsel in Argentina, public defender acting as private prosecutor, or you can pay for it and have a querella that you're paying for. Cases, all cases in Argentina, sexual assault cases in Canada. In both cases, it's not mandatory, it's the victim's right. So to conclude, last slide, we were wondering, should Argentina consider limiting the victim's role? This is more so now that we have jury trials, or should Canada expand the victims' participation during trials? We are of the view that both systems adopted and developed a form of participation that respond to their background, to the legal origins. The law as it stands in Canada today seems to be telling us there's no possibility of inserting the complainants in the trial proper, including jury trials. This could not gain traction. For more radical reforms, such as extending beyond admissibility hearings, seems that will not take hold. We in Canada seems to be positioning as an example of how an adversarial system can be adapted to give complainants a voice without compromising the adversarial nature of a trial. Meanwhile, in Argentina, and I have 30 more seconds, particularly in Chaco, the research shows that the private prosecutor plays a significant role. They've been there for 70% of jury trials. Their involvement is often driven by dissatisfaction with the state. And notably, and specifically in Chaco, the implementation of jury trials is very recent, 2019. So at this stage, it will be too early to assert that the role played by private prosecution has the potential to impact jury verdicts. So far, there's no indication that the presence of influences jury decisions, or if they do, whether this influence is necessarily prejudicial to the accused. Judging by the outcomes, the conviction rates are nearly the same with or without private prosecutors involved, 83% of the role and 85% in cases with private prosecution. More trial experience and future research may be able to shed some light on whether more coordination between state and private prosecutors is called for, whether limiting the victim's role is warranted, and how having an advocate for the victim throughout the whole process may influence the outcome of jury trials. And I think that's the end. Thank you so much. And I'll stay in the background now.
Veronica? Veronica Michel is a professor of political science at the John Jay College of Criminal Justice in New York. and the author of a major book on private prosecutors in Latin America.
Thank you so much. Thank you for organizing this amazing event, and thank you for allowing a political scientist to come here to our room, mostly full of lawyers. I know there are a few of you that are not necessarily attorneys, but I do not have a legal background, and somehow I ended up doing research on criminal procedures. Okay, so I'll start by saying I know nothing about jury trials. My research has focused on victims in general, a little bit in general on criminal procedure reform, in particular victims' rights. And today I think what I would like to do is summarize what I wrote, which is a small descriptive paper trying to give a little bit of the summary of the different rights that are granted to victims. And in a way, I think my paper links well to some of my previous presenters where they explain how victims can participate in proceedings. So like I said, my attempts with this paper are pretty humble. It's mostly description of victims' rights. And I will not, unfortunately, address if these rights are being used, that I have done in different things. I have also not included secondary legislation, which I know it's there, and it also has appeared to expand victims' rights in various ways. And I'm also not gonna discuss if these rights impact or not, which I do think they do, and they are used, but that's too much to cover in only 5,000 words and 10 minutes. How do I move this? Is it clicker? Okay. Now, how I did this, I drew a sample of civil law countries in Latin America, 17, and I've been doing, this is part of a larger project that I've been working on for a few years now, trying to gather information on victims' rights around the world. And for Latin America, what I have is 45 criminal procedure codes, or CPCs, and this is the analysis of this database. This is what I'm presenting today, just a description of what I found. So through time, the victim has increased its presence, at least in, I'm pretty short so you guys cannot see me. I'll move here, okay. Over time, the victim has increased its presence in criminal procedure code. You can see that in the number of times the word victim appears in a CPC, in a criminal procedure code. What I find interesting is that even though the victim as a party may have appeared probably later in criminal procedure reform, the word private prosecution, querellante, querellante adhesivo, acusador, acusador particular, there are different ways in which CPCs refer to the victim as a party. In CPCs, the private prosecutor had appeared earlier on. And this has to do with its, colonial heritage or transplants, and that's, again, a larger topic. But the victim has always been quite present in criminal procedure in our region. You can categorize the type of victims' rights into three. Those rights that have focused on protection, like personal safety, property, try to avoid re-victimization in the criminal proceedings, to give fair treatment. There's also the rights to reparation. This is something that has increased its presence in criminal procedure code in the last, I would say, 20 years. And these include anything related to redress, restorative justice, civil action, and that sort of thing. And participation traditionally as a witness, yes, but more interesting probably for this audience is private prosecution. that it was already discussed, and I will talk a little bit more about that. In terms of private prosecution in Latin America, it was diffused from continental Europe, as Mauricio was explaining before. There are two different antecedents to this figure or legal figure. From Spain, there was the popular action or acción popular, and that was inherited by colonialism, basically, to our region. So that is something that a lot of countries inherited just by nature of being a former colony. But in more recent reform efforts in the 1980s, there was obviously, as Mauricio was explaining before, a huge influence from Germanic and continental Europe reform efforts. And the figure of the Nebenklage, which is a private prosecutor in Germany, was also incorporated into our criminal procedure reforms. What we see today in Latin America is basically three different forms of private prosecution, which I'm broadly categorizing as private prosecutors. And one is what I call the exclusive private prosecutor, meaning it's a victim that can prosecute by themselves the whole case. You don't need a public prosecutor. This is only for misdemeanors. It appears in virtually almost all criminal procedure codes. More relevant, at least for my work, has been the figure of the private prosecutor in criminal offenses, and like homicide, femicide, where that's my type of work. And in these, you find two different types. One is, which I call the autonomous private prosecutor, which is a private prosecutor that can litigate next to the public prosecutor a case. They have their own indictment, and they have the same rights as any other party in proceedings. Relevant to this audience may be the case that private prosecutors for like the autonomous and the auxiliary type, they're both considered parties in criminal proceedings, meaning they could also participate in the selection of juries and in interrogating witnesses. As this is a similar picture also, but in Mexico. This is one of the first trials where we had after the reform that introduced a more accusatorial model of criminal prosecution in the state of Chihuahua. And you can see in this corner, the Ministerio Público, which is the public prosecutor's office, is litigate. You have the prosecutor, but also the private prosecutor sitting next to each other. And it highlights that Mexico has the auxiliary type, meaning in contrast to the autonomous private prosecutor, the auxiliary cannot present an indictment different from that of the public prosecutor. They call it also querellante adhesivo, meaning they just adhere to whatever indictment the public prosecutor presented. And this can have very interesting results when you see how this plays out and how it's being used. But these are basically the different types of private prosecution that you see in the region today. And I think that's pretty much the summary of what I wanted to do. So I thank you everyone for your time, and I'm happy I did a very short presentation because I had a lot of time for the previous one. Thank you, everyone.
So, Lysandra? Yes, okay. Lysandra Penzoldo, I'm correct, is an attorney and expert on criminal procedure law with publications on the jury in both Brazil and Argentina.
Hello, everyone. Thanks for coming along. It's an honor to be here today, sharing some perspectives on the Brazilian jury system. My presentation today will focus on how the jury trial works in Brazil, with particular attention to the exclusion of prejudicial evidence, especially criminal records, and the role of the private prosecutor. It's crucial to understand how these elements can influence the juror's decision in a system marked by structural flaws and inadequate control mechanisms. I'll give a quick overview of 3 main points today. First, I'll introduce the structure of jury trials in Brazil. Second, I'll present some arguments for and against the role of the private prosecutor and its impact on our criminal justice system. And finally, I'll discuss how the system deals with potentially biased evidence, particularly the defendant's criminal records. Well, to start with, although the Brazilian jury trial is often celebrated as a symbol of democracy and lay participation, its actual functioning reveals serious structural flaws. Despite its long history in criminal justice system, which spans over 2 centuries, Brazil's jury system continues to fall short of delivering what it promises in theory. Among the most pressing issues are the absence of a jury selection, the lack of judicial instructions provided to jurors, the absence of deliberation, the small number of jurors, there are only 7 in Brazil, with no unanimous verdict. Besides that, we also face a challenge such as the possibility of appealing acquittals, which distance us from an adversarial model. And these procedural shortcomings weaken the legitimacy of the verdicts and contribute to public mistrust in the criminal justice system. And understanding this fragile foundation is key before we move on to examine 2 specific concerns that I mentioned before: the role of the private prosecutor and the improper use of the defendant's criminal records. It's widely recognized that in the United States, the idea of private prosecutor is largely rejected. In contrast, Brazil allows the participation of a private prosecutor even when the public prosecutor is actively handling the case. In Brazil, the private prosecutor may propose evidence, request questioning for witnesses, participate in oral arguments, and support state appeals. Although legally permitted, the presence of this figure in the courtroom raises serious concerns. The private prosecutor often embodies personal grief, moral outrage, and a desire for punishment, introducing elements that compromise procedural fairness and further sway the trial in a manner that exacerbates existing structural flaws. Critics maintain that this role disrupts procedural equality and compromises impartiality, and they argue that the private prosecutor motivations may be rooted in vengeance or symbolic justice rather than legal reasoning. And this imbalance becomes even more evident when private prosecutors appeal from acquittals, even then the public prosecutor did not, because this creates a scenario of imbalance of dual prosecution, which runs counter the due process. On the other hand, those in favor argue that the private prosecutor brings transparency and acts as a safeguard, while the public prosecutors fail to act. Turning to the next point, regarding the use of the defendant's criminal history, it's common practice in Brazil that the prosecutor mention the defendant's prior convictions in front of the jury. And it remains deeply problematic in our country because when jurors hear that the defendant has a criminal history, even if it's unrelated to the case at hand, it can influence the juror's decision, not based on evidence, but on assumptions of the defendant's character. Introducing prior convictions this practice violates some core constitutional protections, the presumption of innocence, by encouraging jurors to see the defendant as a predisposed to criminality rather than judging the case on its merits. In addition, it compromises the right of a full defense, as prejudicial information is often introduced without proper opportunity to response. This practice is particularly dangerous in the Brazilian context, where prosecutors often rely on the defendant's criminal record as indirect proof of the crime charged. In cases where there is insufficient evidence to support a conviction, prior convictions are sometimes used to fill that gap, suggesting a pattern of behavior rather than to look for specific facts of the case. So why is it still allowed in Brazil? One key reason is the absence of procedural safeguards. There is no clear rule prohibiting the disclosure of prior convictions, and just as critically, no legal instructions are provided to jurors to guide their interpretation of the evidence or to shield them from emotional or symbolic arguments. To conclude, while the Brazilian jury trial is constitutionally framed as a democratic institution, its structural shortcomings deeply compromised its legitimacy. The lack of basic safeguards as jury's instructions, voir dire hearing, deliberation, and no unanimous verdict makes the system highly susceptible to emotional bias. In this fragile setting, the private prosecutor may turn the trial into a moral confrontation, while references to the defendant's criminal record distort jurors' perception and erode a presumption of innocence. Both elements, although legally allowed, gain disproportionate weight precisely because they operate within a courtroom model that lacks procedural balance and normative guidance. As a result, the jury trial, instead of fulfilling its democratic promise, often amplifies inequality and contributes to unjust outcomes. Thank you very much.
Okay, we have time for questions. Yes.
Thank you. I have a question to the panel, so it could be addressed by any of the presenters. in Latin America, we are facing trials in which the accused has to defend himself or herself from more than one accusation. I mean, the public prosecutor, but also one, two, or more private accusations. The victim, but also organizations for the state. So despite the fact that I am in favor of letting the victim a more active role in the process, at the same time, I wanted to know how do we strike the balance between the active role of the victim and the right to a defense of the accused. So my question is, if in your research you have identified any difference in the jury behavior in those cases in which there is only one accusation, the public prosecutor, compared with those cases in which you have one, two, or more accusations that should be part of the process. That would be my question concerning the role of the victim.
I think Aldana, did you?
I don't know, some other country with trials and disinformation, but at least about Argentina, we look about that in our research in Neuquén, in Chaco, but the results didn't show that there is any big difference when the public prosecutor works with the private prosecutor in the trial. Maybe, and this is just some ideas that we need to look further in our data, maybe because they want to have a more coordination between the public and the private prosecutor. So the private prosecutor usually helps the public one, the prosecutor, the querella helps the prosecutor without giving some special evidence to the trial. So how can I explain? The role is a secondary role in the jury trials. That is the idea, a really secondary one, at least in Chaco, what we are seeing. They try to, for example, in the open statement, they have a short open statement, shorter than the public prosecutor. They usually they present the victim history, telling the jurors who was the victim of the case, but not more. And the timing of the case during the trial is in charge of the public prosecutor, not on the querella. So that's maybe helps to understand why until now we are not seeing big difference between cases with public prosecutor and querella and cases with only public prosecutors. But of course it's a very good point, and we need to look further to try to see if in more cases we can see some other results. At least for now, as Natalie said, the number of guilty verdicts are the same with public and private prosecutor or only with public prosecutor.
Just a second. Did you want to respond first?
Yeah. I just wanted to say, at least I totally understand your concern regarding defendants' rights. In my research, in a subset of crimes, like focusing on human rights cases or femicide cases in Mexico, for instance. And I'm not talking about instances where there were multiple accusations, because not all jurisdictions in Latin America allow for multiple, for these autonomous versus the auxiliary. Usually there's only one for different reasons. But what I have found, at least in terms of the usefulness of private prosecution in those type of cases, is that cases that would otherwise would not go punished find a way to get to court. And I'm talking about cases where the state has very little or no interest to prosecute at all, like against a state official, because why would you go against a former military? So virtually all cases, including Argentina and Chile, that have led to convictions in human rights cases were private prosecution cases, where the prosecution contributed. The first genocide, conviction in history of the world in a domestic court against Rios Montt was done through the perseverance of private prosecution. So I have found that private prosecution matters, but in a subset of cases. Having said that, countries like another one that I looked closely, Chile, where impunity is lower for common crime. Well, there's not that much violent crime. In that sense, it's kind of boring to study, but it's, in those cases, there is not much difference. The private prosecutor works mostly like providing customer service to the victim. But in cases where the state has little interest to prosecute, I think that makes a difference. So yes, it's bad news for defendants in those cases, but it's really good news for victims.
Natalie, did you want to say something?
Yes, I'm not sure, can you hear me at least?
Yeah, we can hear you.
Yes. Okay, perfect. I think I just wanted to add to both speakers something, to both presenters. The fact that there's a private prosecutor involved doesn't necessarily mean that this will be a bad thing for the accused. With Sidonia and Aldana, we've been talking about that. We didn't put this as part of our research, but we had this in mind for the Q&A part of the presentation. And we've noticed that sometimes, because the coordination between private prosecutors and state prosecutors it's not necessarily perfect, and that could actually be a problem when presenting your case. Because if you're presenting your version and then as a private prosecutor and the state prosecutor doesn't necessarily overlap with your version or it's not necessarily ideal, or you're cross-examining a witness that the state prosecutor was not considering, then it might actually work in favor of the accused. You just don't know, because it will be highly dependent on the ability of these two parties, as Aldana pointed out, on their ability to actually work well together. So it could actually be a very difficult issue. If they don't work well together, they might end up with an acquittal instead. And that will be in favor of the accused. And it's important. And then something else that I wanted to add with respect to the role of private prosecutors. I worked as a private prosecutor in Argentina and in the human rights aspect of it when I was working there. And what I found is that our presence, I'm not talking about juries, I'm talking about like generally trials. Sometimes the state doesn't know when it comes to this like very specific situation like discrimination law, human rights. Sometimes they really need the help because they really need the expertise that they don't have otherwise. So it's so fact dependent, I feel.
Great. Okay. Yes.
I wanted to add to Leonel's
Could you speak louder?
I wanted to add to Leonel's question that in Neuquén we addressed this problem of multiple accusations and accusators by an article in the procedural code obliging all the parties, the public accusator, that they have to unify their accusation coming to in the intermediate stage. No? You can have different theories of the case, but at one point you have to unify them in order to proceed to the trial, so that the defendant can defend properly from one theory of the case, one accusation, and not having so very different elements.
Yes, back there. But one more, because You're keeping people. It's lunch. Just saying. Okay, go ahead. Yes.
Me?
Yes.
Okay. No, just to say that, Mauricio can speak also. In the NGO movements of human rights, the victims, the participation of victims was very important. But in individual cases, and particularly in sexual offenses, it's very complicated. I speak as a criminal lawyer, and I tell it's very complicated. And just to say that the actual president of Uruguay was falsely accused by a victim because they used the accusations as a political weapon also. Because of the statute of the victim is so favorable to victims that they made like a political issue using this. And this is a big problem in Uruguay. And to what extent, we take the victim because we had no victim in the past, but now we have a lot, it's very strong participation of victims.
These are complicated cases. Well, I won't keep you, but conversation can take place over lunch, okay? Because we want to start promptly at 2 o'clock. Okay.
It is safe to leave
Now,
things here?
I will tell you where lunch is. Would be a good idea, right?
Sherry, is it safe to leave things here?
Is it safe to leave things here? Yeah, yes, well, I'll see. Can we like to do
Are you ready for slides? My part is easy.
So we have now gotten through the trial and talked about evidence, and we are now reaching the verdict stage. And so this next session is going to be about reaching and reviewing jury verdicts. And we are going to begin, we have now also made a movement toward Brazil for the first time, the way things came out in order. And so we are going to start with Brazil again with Gabriela Almeida. And she is a psychologist as well as a lawyer. And she has been studying the Brazilian jury system.
So, good afternoon, everyone. I'm so happy.
Can you use the mic?
Oh, yes, sure. Hi, it's Mark.
Turn it on. Little red button.
Hi.
Yes.
So, good afternoon, everyone. I'm so happy to be here today in this amazing meeting with so many interested people in jury studies. And so thank you, Valerie and Sherry, for this huge opportunity. I'm Gabriela. I am a Brazilian postdoc researcher, and I was invited to speak about the absence of deliberation in Brazil. So, as Lisandra already mentioned, Brazil has several distinctive characteristics. Several jurors decide intentional crimes against life. There's no voir dire action. Actually, the jury selection happens super fast. There are some peremptory challenges, but that's it. And now perhaps the most striking characteristic of Brazilian jury, and maybe I'm being somehow biased here because I was invited to speak about it, is the lack of deliberation. So jurors just have to decide by depositing yes or no cards in an urn. So they are asked about at least 3 standard questions, like first, if the crime did happen, if it was the defendant, the one who had committed it, and also if he should be acquitted or not. And so as far as we know, so please let us know if you know otherwise. The Brazilian jury is the only one in the world where there is no deliberation. Scholars consider the deliberation was abolished during Vargas' dictatorship, and this kind of makes sense, right? a dictatorial period and the imposition of silence. It's a plausible hypothesis, right? But a researcher, Fabiana Bittencourt, who is the one in the photo, she conducted meticulous research on documents, mostly the Constitution, the Brazilian Constitution, and jury laws. And she found out that this was not exactly a turning point, right? So let's take a look at this change. Okay. The jury was established in Brazil in 1822. So Brazil was still a Portuguese colony, so it has not its own rules regarding the jury procedure. So the Portuguese laws were applied. So, and as in Portugal there was deliberation, we also started having them in Brazil. After the Brazilian independence in 1830, we have our first law regarding the jury procedure, a national really one. And it stated that jurors should confer about the case. So there was still deliberation at that time. In 1891, a new constitution maintained the jury, but granted individual states autonomy to legislate on procedural law. So at this point, jury procedures, including voting methods, started to vary across Brazilian states. And many of them started allowing some people in the secret room during deliberation, such as the presiding judge, the clerk, the prosecutor, and the defense lawyer. According to this research I already mentioned, the admission of non-jurors into the secret room during voting appears to mark the beginning of a movement towards inhibition in this interaction among jurors. After the end of this pluralistic system in Brazil, this kind of tendency persisted. So the new law, the following law, the Decree Law 167, established the presence of the judge in the secret room. Yes, and not only to conduce the procedure, but also to prevent jurors from influencing one another. So here, this kind of argument started. Other individuals could be present too, but were prohibited from interfering in the discussions and were required to observe complete incommunicability. So the legal test kind of reflects some ambiguity, right? While it mentioned that discussions could happen, implying among jurors, since others could not interfere, it also mandates complete incommunicability, a term later interpreted to apply to the jurors themselves. Although some attribute this restriction on communication to this dictatorial period through this decree law, the change was not explicitly stated in the law at the time, nor was it interpretation or application clear. Indeed, this research found out that in 1951 was published a Brazilian Supreme Federal Court decision acknowledging communication between jurors, among jurors. So Justice Nelson Hungria explicitly said that there was communication between jurors at that time, and he was part of the team that drafted the bill, the reform project leading this decree law, and also the Criminal Procedural Code of 1941. So when this changed after all, it was only with the enactment of Law 2008 that amended the Criminal Procedure Code that the incommunicability was explicitly established in law. So you can read this. The presiding judge shall also warn the jurors that once drawn, they may not communicate with each other or with others. This prohibition is interpreted in different ways depending on whom the juror might interact with. So it's absolute when interacting with the general public. So jurors can talk, must not talk with anyone out of the jury of any topic at all. But it's relative concerning interactions among fellow jurors, court staff, legal representatives. So jurors must not speak about the case itself, but can chat about other subjects, other matters unrelated to the case itself. Jurors have different perceptions of the incommunicability rule. In interviews I conducted with jurors who served the infanticide trial, almost 60% of them found the incommunicability rule appropriate. They're supporting the status quo. However, a significant portion of those jurors also recognize potential advantages to the deliberation, as you can see here. For those who support the incommunicability rule, it should continue being a rule because of the perceived need to prevent undue influence of one juror over the other. So communication among jurors is seen as a potentially contaminating the intimate conviction. So with incommunicability serving as a shield against those negative influences. The second point is there is somehow an underlying belief that professional judges are superior decision makers compared to jurors who are perceived as too emotional. Finally, there is a constitutional concern, let me say like this, that the constitutional interpretation that deliberation would be incompatible with the secrecy of votes. This is a constitutional rule that has two main goals. First, to protect jurors from external influence or pressure, like in mediatic cases, but also in another point, in another sense, to safeguard the privacy of each juror's individual judgment in a way that it's not possible to know, for any juror to know how the others decide. So critics of introducing deliberation argue that through discussion, jurors would review their instances, making it possible for at least their 6 peers to know how each juror intended to vote or voted. People that are pro-deliberation say the legal change would enhance the democratic nature of the criminal process. And other supporters argue that deliberation is compatible with the constitutional requirement of vote secrecy, and it's different from unanimity, so individual votes could continue. And finally, research has shows that deliberation improves fact-finding, can help clearing doubts, reduce bias, and so there is a current legal proposal to introduce deliberation into the Brazilian system. It's part of a broader legislative change. And you can see the proposal here regarding the deliberation. So if there is no doubt to be clarified, the jurors must meet privately in a special room for up to 1 hour to deliberate on the vote. So it's interesting and surely an advance, but there are still problems like the restriction of time to 1 hour that can increase bias, at least. So a legal change is possible, but it's important that we consider other changes too to make deliberation effective, right? Like such as prioritizing a diverse jury and a representative jury, since Brazilian research shows that Brazilian juries lack representativeness. Another point I would like to add is about the vote secrecy. Other countries consider this rule like applying to the deliberation itself, right? So jurors must not share what was discussed and other jurors' views about the case. So maybe the reinterpretation of this rule can be a way for us too, after all. So the debate should encompasses not only whether deliberation should be introduced, but also how it should be structured if adopted. And I hope this event can help us to find a good path to mature this idea. Thank you very much.
Thank you. And we are staying in Brazil. So Professor Faux. Professor at FAE, right? Centro Universidade. And he's a professor and a lawyer.
Thank you. Thank you very much. First, thank you, Professor Valerie, Professor Shari, for this opportunity to talk to so many researchers on the field. And it's necessary to, okay. And I would like to, yeah, it's turned. Hello.
Is it green?
Okay. And I'd like to thank also for our viewers in the Zoom. My students also, I think they are watching from Brazil. But, okay, and today I will talk about the Brazil's majority decision rule and jury size. My research analyzed the Brazilian jury system, emphasizing on its decision-making process, composition, and compatibility with democratic principles. In Brazil, jury trials are limited to prosecution of intentional crimes against life. A bench trial judges all other criminal offenses. The procedure follows a bifurcated model. In the first phase, the judge conducts a preliminary proceeding that includes admissibility hearing, during which evidence is presented and witnesses are heard. If the judge decides there are substantial evidence that the accused committed the crime and that the crime really happened, the case is submitted to the trial before a jury. It's kind of a grand jury phase. After this, some proceedings are important, so we can talk about in our conference. Jurors are selected from lists compiled by the court. A persistent issue is the lack of fair cross representation. In many judicial districts, jury pools are composed of public servants and middle and upper class individuals, often socially distant from the defendant. It is not uncommon also for jurors to serve repeatedly over several years. The physical layout of the courtroom favors the prosecution. And here it's quite interesting because the prosecution in Brazil is entitled by law to sit at the right hand of the presiding judge. So while the judge and prosecutor occupy a central and prominent positions, the defense is set aside. I also brought like some pictures here. It is from a rumorous case. Here is in the courtroom of Niterói. I was defending here a congresswoman accused of killing her husband. And here is the judge, here is the prosecutor, here is the assistant prosecutor, and here is the defense. The juror will be here facing the defense. Another example here in Curitiba, it's where is my city is. Here is the public prosecutor, here is the judge, here is the defense. Here is the, I am, of course, of the jurors that are here. And in Rio de Janeiro, I actually put a video so you can see here. Also, it was a defense in the courtroom in Rio de Janeiro. Here is the judge, here is the prosecutor, and the defense will be here, like far away. I don't know if this we can put play here, just so, like in Rio de Janeiro. Here's the jurors, the bench, and the defense, where it sits there. Okay, so it's okay. Continuing, after at least 15 jurors must be present on the day to initiate the trial. 7 of them selected by lot to compose the jury. Each party is entitled to up to 3 peremptory challenges without any justification. There is no limit for cause challenges, of course, which must be based on evidence, for example, demonstrating the relationship between a juror and someone involved in the case, or if that juror has talked about the case publicly before. There is no voir dire. That's why it's so important peremptory challenges for us. Officially, the only information provided about prospective juror is their name and occupation, and it's impossible to interview or even submit questions for potential jurors. Once selected, the jurors are informed that they must remain incommunicable through the trial. Typically, jury trials are concluded in a single day, but if the trial extends beyond one day, the jurors are always sequestered and prohibited from external and internal communication. That trial that I told about the Congresswoman, it lasts for 7 days, beginning at 9 a.m., finishing at each day at 10 p.m., 11, even in the morning. The last day was for 26 hours uninterrupted of juror. The trial opens, The trial opens with the evidence presentation. Witnesses are called and examined, starting with the victim, if available, and followed by the prosecution and defense witnesses. The questioning style is similar to direct and cross-examination, but the presiding judge is also permitted to question the witnesses directly. Jurors may also ask questions either orally or in writing, but they must refrain from expressing opinions about the case. The defendant is always the last to testify. While defendants have a constitutional right against self-incrimination, remaining silent is rarely used due to the widespread belief that silence would prejudice the jury. Additionally, in Brazil, Brazil does not criminalize perjury by defendants. After this evidentiary phase, there are the closing arguments. It's broader than a closing argument since it's the party's first official opportunity to present their case before the jury. The prosecution argues for the conviction, then defense may present its case. If the prosecution opts to rebut, the defense can rebut as well. Following the arguments, the presiding judge publicly presents the jury questions, which is a structured set of yes or no factual determinations that jurors must vote on. The jurors secretly and individually cast their votes. The verdict is reached by a simple majority without any deliberation or discussion. Furthermore, the judge provides no instruction regarding the applicable law or legal concepts. Jurors are limited to factual findings, whether the crime happened, whether the defendant was the perpetrator, whether the defendant should be acquitted, and whether there are aggravating or mitigating factors. The presiding judge is responsible for the sentence in accordance with the jury's findings. The legitimacy of the trial in general derives from the respect of the constitutional and the procedural guarantees. In this light, the current composition of the jury, with only 7 jurors, constitutes a structural barrier to realizing fundamental principles that underpin the rule of law. This model poses a serious problem. A single vote difference is sufficient for conviction, undermining the ability to assess whether the evidence supports a reliable and secure decision, especially since we are dealing with the harshest sentence. A 4-vote majority in a 7-number jury amounts to just 57% of jurors. What does this mean in the context of criminal adjudication? Most notably, it represents a direct violation to the principle of the indubio pro reo and mainly the standard of the beyond a reasonable doubt. Academic debate has proposed potential reforms to address these issues. Although it is impossible to control how jurors form their convictions, the voting system could be improved by requiring a qualified majority to convict, thus aligning the verdict more closely with the presumption of innocence. For example, requiring 5 out of 7 jurors to vote for conviction. A second, simpler reform would be to increase the number of jurors from 7 to 8. This adjustment, though minor, would have minimal impact in courtroom logistics. In the event of a tie, the outcome favors the defendant. In a real democratic criminal justice system, the prosecution of the accused must be a guiding value that permeates all procedural stages. The system should prefer the acquittal of a guilty individual over the wrongful conviction of an innocent one, of course. Increasing the number of jurors and requiring a qualified majority for conviction would strengthen the conclusion that the prosecution has fulfilled its constitutional burden of proof. Moreover, it would signal that an alternative narrative offered by the defense failed to plausibly undermine the prosecution's evidence or generate reasonable doubt in the jurors' minds. Also, introducing deliberation, I'm almost finished. Also, introducing deliberation among jurors is a significant step forward. In conclusion, the trial by jury is one of the most significant institutions in the Brazilian legal system. It has more than 200 years. It's the only formal mechanism for popular participation in the administration of justice, and it is a fundamental guarantee itself. It reflects the foundational principles of criminal justice under an adversarial law, based on oral proceedings, publicly, and immediacy. For some time, practitioners and legal scholars have highlighted the pressing need to reform the Brazil's jury system. Several proposals have emerged, including the need for a more pluralistic and diverse jury pool, an increase of the number of the jurors, courtroom architecture that respected the adversarial system, the introduction of a voir dire phase, a pre-trial evidentiary review, the implementation of opening statements, and enforcing a deliberation phase among the jurors before voting. The jury trial plays a significant educational role as it enables society to gain a deeper understanding of the function of the justice system and fosters greater awareness of civic rights and responsibilities. Although the Brazilian model is not immune to criticism, far from that, such critics should be directed toward its improvement to build a justice system that's more fair, equitable, and humane. The jury trial must be protected not only because of its historical legacy, but also because of what it represents for democracy. Thank you very much.
Next speaker is Andres Harfuch. So many titles. Professor at the University of Buenos Aires and prolific author and troublemaker in Argentina, or guru, depending on how you see things. And he is going to talk to us now.
Thank you very much. After listening to all these wonderful presentations from various experiences, and I'm really honored to be here. Thank you, Professor Diamond, for inviting us. and to make this possible, and Valerie too. And okay, so now it's very hard to say something about unanimity and finality of the verdicts. You know, in Argentina, we face several obstacles and resistances due to our tradition. We are civil law tradition, but we must say that Argentina took a very important first step among three topics that are very, very hard to assimilate in a civil law environment. First, a general verdict. Second, the finality of the verdict. Just from the start, every Argentinian bill stated that the verdict must be general, it provides no reasons, cannot be a verdict with interrogatories or questions. That's a very brave initial decision. And the second one is to remove from the prosecutors the power to appeal. That's another big deal. But the most important obstacle was the decision rule, because Argentina could not adopt the unanimity rule from the start. So now the path towards unanimity, and that it is the core of my paper, is to link it to finality. Because Argentina started with the province of Neuquén. We have Carla here, was responsible for introducing the jury in Neuquén, and it all ends up in the Supreme Court when a defendant was convicted to life imprisonment with 8 votes. Because Neuquén allows a decision rule of 8-4, still now, up to date. And so this issue was discussed in the Supreme Court. Then in Buenos Aires province, the largest province in Argentina, and for the first time, Buenos Aires says, okay, in cases of capital punishment, to convict a person, we need a unanimous verdict. And for the other crimes, 10 votes are enough to convict. Okay, it was another step. And then in a very impressive road that is not linear, we must say, many provinces just like Chaco, Mendoza, Entre Rios, Catamarca, the city of Buenos Aires, now adopt the full unanimity rule to convict or to acquit. And so, but what the wonderful notice is that it worked. It still works, because many people were so reluctant to say, this is not going to happen. This is just a Yankee thing. This is for Americans. Yes, they said that. This is for the movies. But in Argentina, that it's going to be impossible. And when Professor Diamond posed me a question about this paper saying, okay, this reluctance towards unanimity rule was because of fear of hung juries for the economic cost of retrying persons. And I was so shocked by the question, because the answer is clearly is no. The answer to that, and I can't find a citation or a quote for that, is because from my experience in Argentina, people said unanimity among 12 people, that's impossible. It's not impossible. I remember one senator saying, I cannot, agree with my wife. So you are asking 12 people to be, unanimous on a conviction or an acquittal. So, but fortunately, the experience in these provinces worked, and worked very well, because the hung jury rate is only 3 or 4%. And the rates of unanimous verdicts is up to 96 or 95%, just like in every common law country. So, so little by little, now the unanimity rule is being accepted in Argentina. And that leads to, but of course, in the 2, 3 or 4 years from the beginning of the experience in trial by jury in Buenos Aires, the prosecutors began to challenge the finality of the verdict and said, this is impossible, this is unfair. There are many acquittals that are unfair. This is injustice. And so we need the power to appeal the not guilty verdicts. said. So all these cases came to the higher courts, the appeal courts, and the state Supreme Courts, and this is another really great surprise to us. The jurisprudence in Argentina have been very, very, very positive towards trial by jury, and now and that's why my paper I don't want to talk much about these progressive steps, but first I must say that even though double jeopardy is a guarantee in the United States, in the rest of the world, in Argentina and in the civil law countries, double jeopardy is another, we have another conception, a very different conception. So when does the trial end? When the Supreme Court rules that the case is over. And that can happen after maybe in Argentina, 14, 20 years. And so this is a real shock. And because of this, we have some very important rulings. And fortunately, last year, we have a very important ruling in the province of Buenos Aires that for the first time in our jurisprudence says the not guilty verdict is absolutely linked to the double jeopardy clause. Because before that, no higher court, no state Supreme Court was willingly to accept that the prosecutor has no power to appeal. So, but they ratified this provision first, saying that the jury is very different from a bench trial because the jury is the people. So the sovereignty of the people is the main argument for at least to accept the constitutionality of the provision that says you have no power to appeal a not guilty verdict. But that's okay. That's part of the reasoning. But the main important feature to as a cultural break is to accept the double jeopardy clause, just like in America is accepted. And so because our own federal Supreme Court we used to look at the Supreme Court of the United States and have quoted many times the ruling of Green. And for the first time, the state Supreme Court of the province of Buenos Aires, in a very famous case called Pittman, where a teenager was allegedly raped by 3 young men, was the verdict issued that the verdict was not guilty, a unanimous not guilty verdict, and the private prosecutor appealed, not the prosecutor, the private prosecutor, and a section of a higher court of appeals in Buenos Aires says, okay, you have the right to a new trial. And so this case went to the Supreme Court, and the Supreme Court, I think the most important case up to now in Argentina, says no. We are going to reinstate the not guilty verdict because this decision of a higher court violates the double jeopardy clause. And after a verdict, a verdict of the people says not guilty, that the case is over. And because in our constitutional system, the jury has the final say. So that's why the title of my paper is Unanimity and Finality. It's both sides of the same coin, because in our experience of expanding the jury in Argentina, many people misread the American or the English tradition, saying no. They thought that unanimity was only to convict. They said no, but in America, with one vote dissenting, you have to acquit. No, that's not true. And in many cases, we have to, remove this mistake and said when they understood that that unanimity was also for acquittals, okay, then the argument against unanimity and the argument in favor of finality began to settle. So, in my opinion now, I think that the case of Argentina can be very inspiring for any other countries of rather, here we are people from Uruguay, from Brazil, from Chile, also from Argentina, and from Mexico. And if this system works in a country like Argentina, it can work perfectly. Absolutely, I'm completely, so thank you so much.
And for the last presentation in this panel, Sam Gross, oh, there he is. Yes. And who I just learned a little while ago was a co-editor on Rick Lempert's, co-author on Rick Lempert's evidence text, and as well, a professor emeritus at the University of Michigan. And also the founding director of the
National Register of Exonerations.
National Register of Exonerations. And so he will talk about deference to juries.
Well, I'm going to talk about a few things, but including deference to juries. But I will say first, I'm actually the founding editor of the National Register of Exonerations, which tells you that this was a project that was founded by academics. I also want to say first, before I say anything else, Valerie, Sherry, everybody, wonderful conference, right? Everybody? Convictions of innocent criminal defendants, that's not supposed to happen. Obviously, the main goal of trials, one of the main goals of trials is accuracy, and the particular sort of error that you really don't want is convicting innocent people. But it does happen. And then the question is, okay, what can you do about it, and how does that play out in the context of jury trials? Sherry and Mallory got in touch with me to contribute to this, and I think pretty much the first thing I said is, yes, something about exoneration. So that's a version of the homepage of the registry when we were founded 12 years ago. At that time, we had 897 exonerations. This is a couple of days ago. We now have, 3,679. By the way, this website is a new one as of about a month ago. It's a lot more user-friendly than the one before. It's not as elegant as it will be in a few months, perhaps. That's more exonerations than anybody has ever collected for any other purpose. But it's still really a pretty tiny number. And for that reason, for a lot of others, the first thing I said is, I'm not going to be able to say anything about the relative accuracy of jury systems or non-jury systems or trials in the United States or anyplace else. We just do not have that sort of information. I can talk around the edges of that. And what I can say around the edges of that is important, but some of it's off to the side for most of the things you've been talking about here so far. So we'll start with this. Oh, that's probably that one. Okay, so the context of jury trials in the United States. We know about exonerations in the United States because, well, for a number of reasons, but I'll start with this. You see I have two columns here, felony convictions and exonerations. But there are about 1 million felony convictions a year in the United States. There are about 1.2 million people in prison who are convicted of felonies in the United States as I stand here. We find out about something on the order of 150 to 200 exonerations. You know, like 2/10,000 of a percent, no, 2/100ths of a percent. So obviously, the rate of false convictions is much greater than that. A decent conservative estimate now is 1% or more of felony convictions. That's like 10,000 cases a year. We find out about a tiny percentage of them. One of the first things, maybe the most important thing that I tried to do when we started the registry and had a significant number of cases and we're talking to people who work on false convictions is trying to disabuse people who were on exonerations and false convictions of a lot of notions people had of what we know and what we don't know. And my basic
message was, we don't know. It's almost all we don't know. And that applies to most of the questions that you'd want to hear about here now. But I can tell you a couple of things that are very conspicuous here. And one really important one, probably the most important one, is identified by that poorly drawn red line there. 94%, somebody's already mentioned it, I think a couple of people, that 94 or so % of convictions in the United States are by guilty pleas. Almost 70% of exonerations we know of are by follow jury trials. That does not mean that jury trials are more likely to produce errors than guilty pleas. There was a time when people believed that guilty pleas meant you were guilty, period. 30, 40 years ago, there were judges who would say, well, how frequent are false convictions in the United States? Well, obviously not very frequent, because 95% of people convicted plead guilty, and we know they're all guilty. Well, they're not all guilty, because, you know, that 24% of exonerations of people who pled guilty is a tiny underrepresentation of those who happen. The process by which they get there is really important, because if you plead guilty, the chances of being exonerated are hugely reduced. First, they're reduced because your punishments can be lighter. These people convicted of felonies in the United States, by the way, get punishments that are vastly greater than you get in other industrial democracies. The people who get exonerated are plurality, 40-some%, were convicted of homicide. Then most of the rest are convicted of other serious violent crimes and so forth. And then you drop down to nonviolent crimes, and the rate of exoneration gets really low. But included within that, there's a group of 173 drug defendants in Harris County, that's Houston in Texas, who pled guilty and were then exonerated because we happened to find out, because of the peculiarity of the way drug testing went on in that county, that drug tests, after they pled guilty, revealed that the substances they were convicted of holding were not illegal drugs at all. In fact, it wasn't just those 173. Those people got exonerated. There were about another 150 so who were in the same status but couldn't be located anymore, because it was years later, this wasn't, and they couldn't be found. So that group, probably about 300 that we know about, all pled guilty to possessing drugs when they didn't and knew it. Why did they? As far as we can tell, for the great majority, it was something like this. The typical case would be somebody who had a prior drug conviction. So he had a drug record for possessing marijuana or possessing cocaine or something like that. As a result, bail was set at some high number for somebody like that, perhaps $5,000, which meant they couldn't make bail. And they had a choice: wait in jail to go to trial in 6 months or 10 months, or possibly longer in use at the time. And if you're convicted, and by the way, there was a drug test that said you were guilty, you might get 6 months in jail to a year. That was in Houston at the time. Or take a deal now and go home today or next week. And then your criminal record will go from 1 drug conviction to 2 drug convictions. And guess what? They take a deal and go home. And these are the ones we know about, because some version of that probably happens in misdemeanors and low-level felonies in the United States at the rate of several hundred a day. And you never hear anything about it. The cases we think about when we talk about false convictions are primarily murder cases, and then rapes, and then miscellany of other cases, usually other big cases. Misdemeanors we almost never. By the way, I said we have about 1 million felony convictions in the United States a year. We have a rough estimate of the number of misdemeanor convictions we have, and it's 4 million or more a year. So in that case, so that's not the only reason people who plead guilty might be innocent. The big reason, the most common one, is you can get 3 years, but if you go to trial, you might get 20. Or you can get 3 years, you go to trial, you might get 20 to life. And choices like that are common in the United States. Defendants face them in Chicago every week, if not every day. And a lot of them say, I'm going to take my 3 years, especially people who have criminal records already, because that disadvantages them at trial and increases the risk of very strong, punitive convictions. Why am I telling you all this? The United States is not a model of criminal justice to emulate for many reasons, of which the most important is what I started with, which is the extreme punitiveness. But if you're starting out with a system where you have choices and are instituting a jury system, the first thing I'd say if you want to avoid convictions of innocent people is, what about the cases that don't go to trial? What happens to them? What are you going to do with the case? Are you going to have a jury system in which every case goes to trial? The American system is run on the premise that fewer than 10% of felonies will go to trial and that effectively no misdemeanors will go to trial. Misdemeanor trials are a fraction of a percent. I don't know what fraction. Felonies up to 5% is high. What about the cases that don't go to trial? Because if that's a great majority of the cases, how do you deal with accuracy in those cases? Because in the United States, the detail, the precision, the cost, the time of jury trials is the reason why there's so few of them. Now, we could spend more on the criminal justice system, but we'd have to spend, I don't know, at least an order of magnitude more, and maybe 2 orders of magnitude more to get to the point where most people could have jury trials, because a lot of the jury trials that people have are pretty bad already. Or, a lot of the jury trials have serious flaws in it. Okay, that's the first major point. Second, what else is it? A few other points, but also important. Jury bias. This is an interesting one. Innocent people who are convicted blame lots of people for their convictions, starting with police, prosecutors, witnesses, the real perpetrator, judges. They almost never blame jurors. And sometimes they probably want to. Right? I'll give you an example. This is a case of a guy by the name of Charles Ulysses. He was convicted of 3 rapes in Massachusetts, in Boston, in 1986. Mr. Charles had a strong Caribbean accent. If you're familiar with it, you know that's a hard accent to mistake. All 3 witnesses, all 3 victims, all 3 women who were raped, described the assailant as having an American accent. Mr. Charles had gold teeth, front gold teeth, conspicuous gold teeth. He had dreadlocks. Neither of those facts were mentioned by the 3 women who identified him. We don't know how the cops got the identification. We have our suspicions because the same cops also concealed the existence of a sperm sample which could have been analyzed for his blood type, which would have exonerated him before he was ever convicted. So we suspect misconduct in getting identifications as well. But that's not my question. You have here 3 witnesses who identified somebody who they said had an American accent as the defendant who had a strong Caribbean accent, who never mentioned dreadlocks or extremely conspicuous gold teeth, and they convicted him. We don't know that he had an all-white jury, but he probably did. And there are other cases like that I mentioned where we know he had all-white juries. Bias in juries is a really big problem, and the most common is pro-prosecution bias. The number of ways you run into this. If you're a defense attorney, you sort of live by it and die by it. But I don't know what to say about it, except that in jury composition, having a jury that's representative with respect to the culture and background of the defendant in the criminal case is really important and may reduce errors. Evidence at trial. Well, there's lots of things to say about that, but I'm going to mention one part, just one part. One of the biggest causes of wrongful convictions in the United States that we can identify, of the ones that result in exonerations, is misconduct by police and prosecutors. And the most common type of misconduct is concealing exculpatory evidence. Now, there are 2 parts to that. One is because of the structure of jury trials, concealing evidence that might help the defendant from the defense at trial is uniquely destructive because the trial, how much time do I have, Sue?
2 minutes.
The trial is conceived of as a unique opportunity to present evidence, and if you miss it then, it's very hard to ever recapture. It happens a lot. It could be cured in the United States or any place else. I won't bother you with details, but it is a problem that could just be cured. In any system where you still have the possibility of constructing it to operate well, making sure that the judge knows in advance of trial every item of evidence in the prosecutor's trial, and if there's anything that's not disclosed to the defense, the judge knows why, and there's a record of that, would have saved a lot of people's lives in the United States. And second, last, review for factual error. People have talked about this already before, but the review of jury decisions in the United States in criminal and civil cases alike is very limited, and supposedly it's a legal review. But what happens if after the fact you discover that you have made a mistake and that somebody who shouldn't have been convicted is in prison and might be there for the rest of her life? Well, all states have some version of allowing you to reopen that case, and have that be reconsidered. But it's discretionary, it's not an ordinary appeal. And because of the way we regard jury trials, there is I would say, a sort of glorification of finality of verdicts, which of course is important. There is a real, we've just been talking about finality and the importance of it, but in this context can be extremely destructive. The number of cases in which you have somebody who's convicted and then the case starts falling apart. 2 or 3 of the witnesses, essential witnesses, recant and say, what we testified to wasn't true. Goes up to the court and the court says, yeah, that wouldn't have made any difference at trial. We don't have to reconsider this case. And then you find out that there was another suspect who was never investigated, who might well have done it. And it goes back 5 years later, and they say once again, no, we don't have to have a hearing on this. And then, 20 years after the case first should have been reopened to reconsider all the evidence, you get absolute killer evidence. The real person who did it is apprehended and confessed, and there's physical evidence or a DNA test or something. And then the person is finally released. The number of cases where people were exonerated but should have been reopened 15 or 20 years earlier is dozens that I could lay my hands on, and probably hundreds among those 3,600. And the number of cases like that, which nobody will ever hear about, is anybody's guess. So if you can have the opportunity to set up a system where respecting finality and taking verdicts seriously, you still have the modesty, the systemic modesty to say, okay, but now there's new evidence of innocence that we didn't hear about before. Take it seriously. This is one of those cases we do have to redo. Among the cases who were that we know where people were eventually proven to be innocent, that would have saved literally thousands of years of imprisonment. Okay, that's it.
So we are ready for some questions, but I just want to hear Sam and Andreas talk about finality, just a little bit, with each other. Sam, can you hear?
I'm sorry, I missed what you said. I just felt.
Yeah, I said, I just wanted to hear, I think everybody would like to hear, you and Andreas talk a little bit about finality.
Okay. Well, I just, that'll be Andreas first, because I just finished speaking.
Well, at least in Argentina, in the first guilty verdict was overturned after 6 years of experience. So the higher court of appeal said, okay, we need to give time to this beginning of trial by jury. We cannot start by, overturning all the mistakes that could have been probably done. And so, in my opinion, I think that the higher court of appeals in Argentina, were acting just like here, and they had a great deference towards a guilty verdict. And of course, when the prosecutors began to challenge the not guilty verdicts, they protected that provision and said, no, you have no right whatsoever to appeal that. So I think that now, in Argentina at least, many people are saying that you can overturn a guilty verdict, and that's important recourse to the law in cases of wrongful convictions. We have no record whatsoever up to now of a wrongful conviction, but this case that was overturned was of a young woman, 18 years old, who allegedly killed his baby with this baby syndrome, yes. And the judge made a terrible mistake but not incorporating the lesser included offense of manslaughter. And so the jury was faced only with, murder in the first degree and not guilty. And the jury says unanimously murder. And the higher court of appeal said, no, this is a very strong mistake. And so in the end, they acquitted the girl. So I think that's our, our experience with finality right now. But the courts are showing great deference to the decisions of the jury.
I thought you would say something different. I thought you would talk about double jeopardy and the fact that there's a difference in a wrongful conviction versus a mistaken acquittal. Maybe not.
So finality is a basic rule in litigation, at least in the United States. For example, in a civil case, if you go to trial in a civil case and you win a judgment for $1 million because of a product defect, right? And then afterwards, the defendant, who's been obliged to pay you $1,000, comes up with rock solid, uncontested evidence that that could not have happened. There is no possible remedy. There's nothing. There's nothing. There's no way. There's nowhere to file anything for that. So you start with some types of judgments. We just don't care after. Once the judgment's over, we just don't care about the facts. In criminal cases where the state is punishing someone and the punishment continues, which means imprisonment, or some people would say death even after death, but imprisonment in any event. Then there is an instinct that you should stop the bleeding because the state is responsible for it. If I had to say what to do with this from scratch, I would say that should not be part of the usual criminal system. That should be a different system that deals with it. But the experience of trying to modify that system that I'm aware of within the common law and common law jurisdictions, for example, in particular, the Criminal Case Review Commission in Great Britain have worked very badly. The Criminal Case Review Commission now, I think, has a waiting period of 7 years before they will look at a file or something like that. I mean, I'm making up numbers, but I'm not. It's in that range. It's just not functioning, and so I don't know what it would be, but something that says this is different, and here we want if we have strong evidence that the factual ground truth that we thought was there isn't there, we should modify it. And what happens in the United States is we have a set of rules that judges pretend to apply, of which the most common one is, if this evidence had been known at trial, would it have made a difference to the jury? Which they apply mendaciously. They lie. They say, oh no, that wouldn't have made a difference to the jury, but I don't have any doubt that they don't believe that.
Well, yeah, the study. We'll go on from there. Questions, yeah.
Yeah, just comment on this. I heard Andrea saying something, at least what I found most interesting, somewhat different, in that what I found interesting, and correct me if I'm wrong about your argument, is that it was absolutely crucial to bring double jeopardy about, was you had 12 people who agreed on an acquittal. And that was enough guarantee that it was right, that you were going to link that to double jeopardy and finality, and together they made a persuasive case for deviating from the old prior system where prosecutors could appeal. The other thing with respect to what Sam is saying is I have this feeling, you read the case, that there's finality and there is finality. And between that is kind of priorities. And so a lot of the appeals in criminal cases, criminals will throw everything to see what sticks. Every kind of evidentiary error, some of which are more serious than others, but none of them arises to the point where you say any reasonable person would say not that the jury could have acquitted, but the jury would have acquitted. In the kinds of at least most horrible cases, even where the jury got it wrong, particularly when new evidence comes out, like if there was exonerated DNA, the jury would have acquitted. And for that one, I don't think we want finality, we want justice.
So I don't know what I didn't mean to raise my hand. I'm just thinking that habeas, no, I'm just thinking that like.
Raise your hand, I'm gonna move on.
Well, habeas is a civil equitable claim, right? Isn't that the idea, that it's a civil claim that someone who is currently incarcerated is bringing, sounding in equity, saying, take me out of prison? It's an injunction of some sort against the state to say, let me out of here. That is a different system, right? You're saying that we don't have it in the context of civil claims, and that makes some sense because it's not ongoing. This is like I'm not sure where I'm going with this, but I think this idea of it being sounding in equity is actually an important distinction.
The procedures in the United States are all conceptually something like habeas. They're called habeas in some states and a dozen other things in other states. But it's how they're applied that matters.
Are they statutorily defined in how they should be applied, or is this judge-made law of equity?
You're an American lawyer, you know this. There are 50 states, and more important, there are 300.
Okay, gentlemen, I'll let you do this later.
There's no single American system.
We only have a few more minutes before the next, and I do want to ask the group to consider what you heard about Brazil and what your reaction is to both speakers talked about reforms, and the question is, which one if any, would you like to see? Yeah.
Yeah, so I found the Brazilian, the fact that they don't deliberate to be fascinating and mind-blowing. I'm still trying to wrap my head around how to think about that, because I've read all of this research about how deliberations are good and they lead to better kind of consideration of the evidence and more thorough kind of weighing and sifting and combing, and so we like deliberations, especially when the jury is diverse. But I imagine a lot of times during deliberations, juries either can talk other jurors into guilt or talk them into acquittal, and I don't know the rates, but I imagine a lot of jurors are pushed to guilt as opposed to pushed to acquittal, at least a unanimous acquittal. And so I was just wondering, in an ideal world, what would you do? Would you want jurors not to deliberate, or do you think deliberations on the whole are a net positive?
Can I jump right in on that?
Yeah, that is John.
So I agree that it was fascinating to think about, and there's a procedure called nominal group technique, which is not used very often, but imagine you're on a jury and everyone's at a computer console. You interact in a highly structured way. Nobody actually knows who's typing at any time. You're responding to different comments, and there is a kind of deliberation happening that is entirely private, but you're sharing perspectives. And so I mean, part of why I'm fascinated is what lies between the Brazilian extreme and the face-to-face deliberation, which I know and love. And the answer is actually all kinds of interesting things that are technologically easier than ever now.
Jessica.
I was thinking along similar lines. I mean, I'm a deliberation fan. I've written papers about why deliberation is important, but I think you raised an interesting point. I've heard some interesting devil's advocate arguments for, so the jurors are influencing each other and there are asymmetries there and there are power dynamics there too, where that's going to be, white men are going to have more power, women tend to acquiesce more, people of color tend to acquiesce more. That's kind of interesting of this idea of the group without those power dynamics. And I've heard some interesting proposals that are very kind of futuristic and will probably never happen, but I think they have to be added with big numbers, So if you could have hundreds of jurors watch a trial and literally just vote, I feel like I start feeling more confident that that's a good answer even without deliberation. But when you have the combination, I feel like of only 7 jurors and no, deliberation. But there's kind of an interesting devil's advocate argument for no deliberation where you strip some of those power dynamics, which is kind of similar, I think, to what you're saying, where maybe you deliberate, but you don't know who people are or, things like that.
So this is great, and because we're out of time on this, but this part of the discussion can be reopened as we get to the final section and talk about what kind of research needs to be done. So I will turn this over to my
And actually, this is a perfect segue because John Gastel, you are up next, talking about deliberation. As we get the slides up and he makes his way to the front, I will list his titles. He is Distinguished Professor of Communication Arts, Public Policy and Political Science. I think you've added some of those since I last knew you. All at Penn State University. He's known for his work on deliberative democracy, which is, like I say, a perfect segue to our discussion about the critical importance of deliberation. There you go.
Thank you so much. And this is our slide clicker here. Cool. Yeah, anytime a new school or program opens up at Penn State, I immediately apply for a courtesy appointment. Sociometry, I think, is what I'm shooting for now. Still not sure what it is, but I feel like I do that. Seriously, thank you so much for the opportunity to be here. It's so wonderful to see so many familiar and unfamiliar faces. I have to say this is incredibly stimulating. As Valerie said, I'm really a scholar of democracy and deliberation, principally empirical, a little bit philosophical, and I found my way to the jury many years ago, and Valerie and others have welcomed me into the community as the guy who talks about this. It's cool, I'm ready to go. The talk I give will really have one big thing you will remember. If you've already heard it, apologies, but you're going to see slides again. And then a little bit more detail, including new data from Argentina that only a few people in the room have seen. So if you're curious to know more about this, I encourage you to go online to the Jury and Democracy Project. We have our writings there, a book, Jury and Democracy from 2010. Also, Andreas has made sure that some of our writings and some newer writings I've done that are only in Spanish are available through ad hoc and so on. And so you can read some in Spanish. Probably the core idea of our project is that the jury is not just a legal choice. It's a part of the infrastructure of most democratic systems that want to foreground citizen deliberation. Some just haven't gotten there yet. They're experimenting with things like citizens' assemblies and so on, and they kind of forgot the jury, I would like to say. But some started with the jury, and it's even inspired some new deliberative processes. But the core research project in here was really looking at how the experience of serving on a jury that deliberates changes someone. There is this old hypothesis, and you can trace it back to Tocqueville if you wish. I wish all my hypotheses came out of a road trip in a foreign country with my buddy. I don't know why it worked for them. And the participation hypothesis says that there's this variety of democracy called participatory democracy. You can say deliberative democracy is a variant of that. And it really does depend on people having some appetite for this sort of thing. Elite democracy is easy, right? Hey, those people who can bother to vote will vote and we'll just govern them all. Participatory and deliberative democracy, no, people have to really get into it. And the only way that's gonna work, again, is if there's some spark that can be lit. Folks have said that's an untestable proposition because you can't run an experiment. No one can be randomly assigned to deliberate and then see what happens to them. Well, of course, that's exactly what happens. We really do have this amazing situation, and we'll say more about that in a detail. But I do want to stress, if you haven't yet met Powers versus Ohio, it's my favorite Supreme Court case involving a hitman who, as he admitted, shot the wrong person in a panic. That's what really established your right to serve on a jury, not just the right of the defendant to get a diverse jury, but you can't be discriminated against as a prospective juror. Such a fun bit of history. And then the Japanese system premised itself on the idea that our research would be done and prove them correct. Not really, but close. So here's the key to understanding this research. What we're really comparing are just impaneled jurors. So forget about who gets impaneled, just think about, okay, everyone who's on an impaneled jury. They're really being split into two groups by no fault of their own. Those who then get to deliberate and those who don't. Remember, they're all impaneled. So who's the impaneled juror not deliberating? Well, there's a mistrial. Well, they changed their plea to guilty. Oh, they were an alternate. There's actually a bunch of circumstances that can cause an impaneled juror not to get to deliberate. And so with a national sample in a bunch of courthouses scattered around the United States, we look to see whether or not that difference among impaneled jurors was associated with long-term differences in their voting frequency. So we could, as you're going to see here, take these counties scattered here and there. We could find the jurors in the case file, the manila folder in every case except El Paso, go dig out somebody's name, then go across town to the county voter records. This is big data before it was cool, baby. And find that person, and then, God bless me, I was nerdy enough to write code back in C++ that merged these two data files, being able to tell things like Margaret and Maggie were the same person, stuff like that. About 2/3 of our jurors had one exact match in the voter file. We had to throw out lots of jurors who had more than one match. Nothing we can do about that. But there we are, that's our data set. And then what we get to do are fun things like this. So the first two bars there are not from our data, those were established previously, that if you serve in student council for a year in high school, you know, this powerful civic experience, you're about 4% more likely to vote than comparable students. If you take a civics course for a semester, that's a little better than that. That's comparable to reaching a verdict on a criminal jury. It's a little better if you're on a hung jury, mysteriously. And then the civil jury we have down there. A quick footnote is I pulled a couple slides on the civil jury. Valerie Hans, God bless her, was skeptical of my initial conclusion and said if we dig deeper in the civil, we're going to find the civil jury effect that boosts voting, and she was correct. You're welcome to read our article to find out when that happens. But the gist of it is that actually serving on a jury, and a typical jury trial might be a day or two, has about as powerful an impact on your long-term voting behavior as a civics course for a full drudgery of a semester. So if you remember nothing else about the talk, that's the takeaway that keeps getting me invited to these things where I do not belong. So God bless that study. And all the grad students who made it possible traveling around the country asking for stacks of jury trials. But there's a complementary piece of data from our study, and then, as I said, an update in Argentina. The complementary piece comes from not a randomly sampled courthouse. I was at the University of Washington when we dug deep into the jury system in King County, Washington, and the Seattle Municipal Courthouse. Again, this is not your prototypical jury in a sense, in that, yes, weddings are held at the courthouse. This is the jury room up high in Seattle. It's that beautiful. Dale Chihuly's glass art, blown glass art, is hanging in the jury room where you're waiting to go to your, it's amazing. And what this allowed us to do is we have longitudinal data now. Now we could survey all the jurors before they go off to the courtroom, survey them right after their trial as much as we could, and then several months later to look at longitudinal changes. And this slide here is just kind of a tease leads to Argentina to say there are all sorts of things about their jury experience that were also drivers of future engagement, right? It wasn't just getting the chance to deliberate, though that was important, and the details get even more fun with that. But things such as, did they understand the trial? Were they engaged in the trial? How were they treated by the attorneys and the judges? Did the judge say anything afterwards? Almost always the judge would praise the jury when they said anything, but many judges didn't say anything that they could remember. And did they talk about it, process it after the fact with friends? All of these things were accelerators, if you will, of a wider range of civic impacts. In that first study, we were confined just to voting behavior. That was the official records that we merged. In this case, we had survey data that asked them all sorts of fun things. The details are amazing. My favorite of which is that we had in the sample something like 100 and something homemakers, 2 of which were men, the rest were all women. And as a result of their jury experience, they became more engaged in all sorts of public affairs, less engaged in kind of community fundraising, bake sale kind of things. In other words, it wasn't just that being on a jury made you want to be busier, it made you think a little bit differently about where you're putting that time. I love that finding. Finally, to Argentina, in a work that's under review right now, we have a few hundred jurors, and what we're looking at here is there are sort of correlations between 2 things. On the one hand, as I said, their subjective experience, were they satisfied, were they proud of their service, did it exceed their expectations, and then changes in attitudes that they thought, okay, gosh, after I've done this, I guess I do have a more favorable view of the jury system, of the courts, of want to be more engaged in public affairs. As I said with one of my grad students on a different study, you're always looking for the non-finding that saves you. And in this case, it's that 4th column. It wasn't just that everything is correlated with everything. It did not make them more trustworthy of the provincial government. Our jury sample did not become more trustworthy of Congress. They only became more trustworthy of the Supreme Court in a special circumstance, when they were actually a repeat offender. I've done jury service before. When I came back this time, I think I gained a greater appreciation for how so there's fascinating context in which you can get past these general effects, but it really is encouraging to see them replicated in a sense in Argentina most recently. So, conclusions. Jury has a special role in democracy. It really can have a lasting, positive civic impact. There are all sorts of legal reforms. The jury could be introduced. A jury could be changed in some ways. It could go into decline, as we've been discussing. All of these, good and bad, can affect your democratic system. Later, I have another talk, very similar, but with a graduate student, Brooke Hughes. We've looked a little bit more at some of the more complex societal, sort of almost philosophical effects that having the jury system can have, in addition to the more palpable experience of the juror themselves. So thank you so much for the opportunity to share that, and it's so fun being here.
Now you know why he always gets excited. That was great, John, thank you. So next we have a pair of papers on secrecy and whether or not jurors should retain as secrets what they've been up to. So first we'll hear from Jeremy Boulanger-Bonelli, who is from McGill University, and he'll be talking about it. The situation in Canada should be fascinating. As he comes up here, I just want to say that his dissertation, which was completed a few years ago now, was a fantastic kind of world picture of lay judges and their frequency around the world. So take it away.
Thank you very much, and thank you for inviting me. This is a fascinating conference, beautiful setting, great people, so I'm really happy to be here. Thank you, Sherry, for organizing with Valerie. So I've been asked to talk about jury secrecy, which is not a topic I had looked at before, but it was very interesting to delve into that for one particular reason, because there's been some movement around jury secrecy in Canada in the past few years, and yet very little has been written on that topic. And so there's a gap in literature, and it was interesting to kind of try to identify the rules first, because there's a bit of uncertainty around what the rules actually are in Canada, and then try to criticize the rules, because in my opinion, that's my spoiler for the end of the talk, I think we should relax our rules in Canada and make it easier for jurors to disclose information about their experience, while of course retaining some aspect of secrecy. So I'll leave you hanging on that for later. So first of all, I need to give some context, and before describing the rules, a bit of a background in Canadian constitutional law for those who are not familiar. Our constitution is a federal one, and so we separate between the federal government, federal parliament actually, and provincial legislatures. Why is that important in the context of this paper? Because the federal government has jurisdiction over criminal matters generally, and so they have jurisdiction over criminal juries and the rules around secrecy for those types of juries. However, when we come to civil juries, which I also looked at in this paper, well, these civil juries are under the jurisdiction of provinces, and so provincial legislation is going to fix the rules around jury secrecy in that context. So we do need to distinguish criminal matters from civil matters in our context. So if you focus first on the criminal context, there are essentially two rules around jury secrecy. The first one is evidentiary, and the second one is a criminal prohibition. So I'm going to go over these two rules one after the other. The first one is evidentiary, as I said, and it comes from the common law, so court decisions from England, actually, so it's a long-standing rule. And it was confirmed in 2001 by our Supreme Court of Canada in a case called R versus Pan. I'll spare you the factual details of that case, but essentially what the court said is that juror statements about their experience in deliberations are inadmissible in evidence, particularly when people try to overturn a verdict. And so this rule, I think, is going to be known by many people here. It's similar to the rule you have here in the US under the federal rules of evidence. And so essentially that rule prevents juror statements from being admitted into evidence, except in one circumstance, which is when there's proof of outside influence or information which was improperly brought into the deliberations. So in that case, you can bring in information, evidence, and try to overturn the verdict. The origin of that rule, as I said, is an English case from 1785, so it's been long-standing. But the important point here is that the rule does not prevent disclosure. So jurors are free to disclose anything they want about the process under that first rule, but their statements afterwards cannot be used as evidence to try to overturn a verdict. And this is where the second rule comes in, which is very strict, very stringent, and I think differs from the rules applicable in some other countries. That second rule is a criminal prohibition, and it is of statutory origin. It's fairly new, so it's been around since 1972. It is a provision in our criminal code in Canada, which was adopted actually following media reports about a case in Quebec, my home province, where there were reports that jurors had decided a verdict based on political motivations. And so there was outrage, and I think people wanted to hide that kind of reality. And so they decided to adopt a provision in the criminal code to impose a criminal sanction on jurors who disclose information. So that section is now section 649(1)A. And what it does essentially is it takes the same scope as the evidentiary rules. So any statements made by jurors during about information during the deliberations, but any disclosure in that case imposes a criminal sanction on the juror, of course, if they are prosecuted, which doesn't really happen very frequently. And so the consequences are relatively serious. You can have a fine up to a maximum of $5,000, or even prison, a maximum of 2 years, or you could combine both as well if the judge wants to. And so here you have fairly significant sanctions. As I said, they're not applied very frequently. I'm not aware of any case where actually a juror was convicted of that offense. And yet, of course, it has a chilling effect because the judge is going to tell that to the jurors, tell them if you say anything about your experience, you can be in jail for up to 2 years. So of course, that has a big chilling effect on what they will say afterwards. Because the rule is so stringent, there are exceptions. The first one is very similar to the evidentiary rule, and so if you want to prove something about obstructions of justice during the process, you can introduce evidence about deliberations. And a new exception, which is the new development I was mentioning before, in 2022, the federal government responded to requests by jurors to have an exception, making it possible for them to disclose information to their mental health professional, because there was evidence that jurors can suffer mental health issues after particularly gruesome trials, for example. And so now they are able to talk to their mental health professionals, if they are recognized professionals, about their experience in the context of treatment. So it's a narrow exception, but it's still helpful for these jurors. So that's the picture for criminal matters. Now, the picture in civil matters is a bit less clear. The first rule, the evidentiary rule, also applies likely in all provinces. There are some courts across Canada that have confirmed that the evidentiary rules apply. However, it's not all provinces that have confirmed that, so it's unclear if the evidentiary rule applies. However, we can assume that it does apply. Why can we assume that? Because the initial case that established the evidentiary rule, Vase versus de Laval, which I mentioned before, was a civil case, and so of course it would apply in civil matters. And the Supreme Court of Canada also applied the evidentiary rule in a civil case in 1956. It's been a while. It's not an issue that arises very frequently, but still, I think we can assume that the evidentiary part also applies in civil matters. The difference is the penal part. So the criminal sanction we have in criminal matters at the federal level doesn't exist in all provinces in Canada. There's only 3 provinces and the 3 Northern Territories which have adopted similar provisions for civil juries, penalizing essentially the disclosure of information during a civil trial. And so in other provinces which do not impose similar fines or prison, there is no prohibition, and so technically jurors could disclose information. There's no prohibition on that if they participate in a civil trial, although it would be criminalized at the federal level for a criminal trial. And so that's a difference that is interesting to me, because even if we value secrecy very much in Canada, in civil matters, we see that there is an erosion essentially of that rule, and we do not penalize jurors for those disclosures in civil matters. So if I move to the second part, which is a critical analysis of these rules, I think some of you who know about jury secrecy are going to be familiar with the justifications for the rules around jury secrecy, and those are the same in Canada as well. Jury secrecy is said to favor the finality of verdicts, which we were mentioning in a few presentations today. It also prioritizes the free expressions of jurors during deliberation, and also protects them from harassment, censure, and reprisals. So that is nothing new. Those are the justifications for the rule. And there are also risks that have been identified with those rules. First, unfairness to the accused, potentially. And in the US, there's the Peña-Rodriguez case, of course, which I think delved a bit into that issue. And second, there's also an impediment to jury research. A few papers were written on that, saying that jury secrecy, of course, in Canada, doesn't allow us to do research on real juries. We only have mock juries, in contrast to the US, where you can do research on real juries. And to those 2 risks, which are mentioned in the literature, I would add a third one, which is linked to what John was saying earlier, which is the social impact of juries. So of course, juries have an impact on civic engagement, civic education. The work of Valerie as well has confirmed that, and many others. So juries have an impact beyond the judicial process. But when we look at the discourse around jury secrecy in Canada, it's very much focused on the judicial process itself. It doesn't go beyond. However, there's impacts of those rules on the social impacts that the jury can have. And so that's when I come to my proposal. Is it time for reform around jury secrecy? I don't think the rules currently strike an appropriate balance between these justifications and the risks. I think we could achieve the same objectives that the rules currently pursue while relaxing a bit the rules, especially the criminal prohibition, which is very stringent. And so what could we do in terms of reform? We could maintain the evidentiary rule, which I think protects the finality of verdicts and allows jurors to speak openly in deliberations. And we could perhaps retain the criminal prohibition as well, to allow disclosure, but narrow it to allow disclosure of any information except information that would identify other jurors. Because I think that's where secrecy is helpful in order to preserve frank discussions, pre-deliberations. Of course, you don't want your opinions to be identified, but as long as that's preserved, then we could allow disclosure of other information and therefore narrow that criminal exception that we have in Canada, which is very restrictive. So that's my proposal for reform around jury secrecy, to take into account that broader aspect of juries. And I would be interested to know what others think about that, but also what rules you have in your jurisdictions around jury secrecy. Thank you.
That was great. And now we're going to have part 2 of jury secrecy, Daniel Harawa, who is a professor of law at NYU Law School, where he also directs the Federal Appellate Clinic. There you go.
Good afternoon. Sherry, Valerie, I want to thank you again, or echo the thanks for inviting me. I've learned so much today. It's been such a great day, and I really appreciate being here. And one of the problems with being towards the end of the day is a lot of people have already said things that you were going to say, so I'm going to try to figure out kind of how to connect what I was going to present to a lot of things that have been said already, and tell you a little bit about why I am particularly concerned with or interested in jury secrecy. So in addition to kind of teaching evidence in criminal law classes, I direct a federal appellate clinic because I've done post-conviction criminal work for over a decade. And so what that looks like is that you get a big stack of transcripts of a trial and you have to tell the court what went wrong. And the way that you do that is you have to tell the court, well, what would the jury have done differently if a certain error hadn't been made? So what Sam was referencing earlier. And I always found that really interesting, weird, kind of why are we engaging in this guesswork? Because we know what happened throughout trial, but we have no idea what mattered to the jury. We just have to tell a story to the court about what we think probably mattered to the jury, but how are we ever going to know? There's no way to know. And so that's what first got me interested in jury secrecy. And then I think it was Veronica who said we inherited our jury system by colonialism. And I wonder and ask my students, does it make sense for us to just plop over a system from medieval England and use it here, given our unique history, given our unique present realities, given just how different we are today from what it was like in the 1200s in England, and getting students to engage in that kind of thought experiment, they automatically reflexively say, no, of course that doesn't make sense. Why would we ever do that? And so both of those questions lead me to kind of question, think about, wonder whether jury secrecy is actually a good thing or whether there are ways we can play around with it to preserve the values that Jeremy was just talking about, but also think about the risks of jury secrecy and what they pose, particularly to criminal defendants who are literally on trial for their lives. So Jeremy already told you the values of secrecy: finality, protects finality, protects against harassment, allows for the free flow of conversation. But then what about if that free flow of conversation involves racism, right? Like what about if these 12 people are in a room and all they're doing is discussing why we should convict X defendant because he is from this country, or because he is this race, or because he's this religion, this sexual orientation, gender identity, etc., right? What about if secrecy is preventing us from knowing that jurors are relying on bias when they're issuing their decisions? That to me doesn't seem great. Richard already told us about a case, Tanner versus United States, where jurors were literally getting high and drinking during deliberations. And secrecy was more important than kind of remedying those issues. And so the question is like, well, what about if we learn about bias? Does secrecy still stand in that situation? And that led to a 2017 case out of the Supreme Court, Pena-Rodriguez, which dealt with the no impeachment rule, which Jeremy also just referenced briefly. So our no impeachment rule here in the US is codified at Rule 606B of the Federal Rules of Evidence. Every state has a similar version to the no impeachment rule, which essentially says a court cannot receive evidence about what jurors discuss during deliberations, subject to a few limited exceptions, outside influences, etc. And so just based on the plain text of the rule, it wasn't at all clear that if it comes out that a juror had made all kinds of racist statements, a court could ever hear evidence of those racist statements. And so what does that mean for the system? Like, what does it do for our faith in the system if we know that there is no remedy to the notion of jurors being blatantly, obviously racist when reaching their verdict, and yet those criminal convictions still stand because we value finality more than we value, I think, what we would call justice, if we believe justice is not being convicted out of racism. And so the court had to address this question directly in 2017 in Pena-Rodriguez, which Justice Kagan said in oral argument, this was a case of smoking gun racial bias. And these are just some of the comments that the juror made in this case, including that the defendant there was on trial for various sexual assault related crimes. And this one juror who was an ex-law enforcement officer made all kinds of racist statements about quote unquote Mexican men, and then also made racist statements about one of Mr. Pena-Rodriguez's alibi witnesses who he said he didn't believe because he was, I quote, an illegal, even though the witness was a lawful resident. And so the court had to decide, so the Colorado courts in this case, applying the Colorado no impeachment rule, said, yeah, a juror came forward and told us that all of this was said during deliberations, but we have a no impeachment rule in Colorado. And so that means we can't hear any of this evidence. And that Mr. Pena-Rodriguez's conviction still stands, even though we know at least one of his jurors convicted him in part because of Mr. Pena-Rodriguez's race or ethnicity. And so the court had to decide, well, is there going to be an exception to this no impeachment rule, to jury secrecy in the case of juror bias? And in a really important decision, the court said, yes, the Constitution compels an exclusion to the secrecy requirement in the case of racial bias. The court said that this kind of exception is rooted in the Sixth Amendment, but then it also said it might be rooted, or it kind of incorporates 14th Amendment principles, which was the amendment passed after the Civil War, and to grant full citizenship rights to formerly enslaved Africans or Black people in America. And so they said, yeah, given that we have this amendment that tries to eradicate racial prejudice from our society, given this constitutional right we have to a fair trial, there needs to be an exception to no impeachment rules in the case of racial bias. Now, one of the issues that we still haven't really figured out yet is, well, what about other kinds of bias? Because the court said our history of racism in the United States is so singular and unique, the court really harped on that. And so if that's what the court was really focused on, it's not necessarily clear that the rule would also, the exception would also apply to gender bias, anti-LGBTQ bias, et cetera. And the court didn't tell us, well, once this bias comes out, even assuming a court gets to hear it now, what the court has to do when it receives evidence of this bias. So the court set this standard for piercing jury deliberations, for overcoming the jury secrecy, for overcoming no impeachment rules. So the court said that a defendant must present evidence of clear and explicit statements indicating that racial animus was a significant motivating factor in his or her vote to convict. Now that seems great, but you can already probably spot the problems. One, racial bias often isn't expressed in clear and explicit ways. We know it's expressed in coded, kind of masked ways. We also know about implicit biases, and the standard doesn't say anything about that. This significant motivating factor part of the test doesn't really make that much sense, because how would we ever know, right? Assuming a juror expressed clear and explicit racism, why should we have to figure out how it motivated their vote? It seems like once they express it, that's not great. And if we care about the kind of how our jury system operates and whether people perceive it to be fair, it seems like once we know racism expressed, that's a problem. And again, we still don't know what happens once this information comes to light, whether a court has to grant a new trial. But there are also structural barriers to even learning about juror bias in the first place. So one, there are non-disclosure instructions. So juries are told before they go back to deliberate, hey, don't discuss what happened. Don't tell me, don't tell lawyers, don't tell your wife, don't tell your kids. And so if that's what jurors are told, why would we ever believe that they would come forward, even if a juror does make racist statements during deliberations? Then a lot of jurisdictions across the country have no contact rules, meaning that lawyers can't talk to jurors during trial, obviously, but they also can't talk to them in these jurisdictions after trial is over. And so in those jurisdictions, you need to rely on jurors coming forward to tell the lawyer what happened. But again, why would the juror come forward if they were told don't come forward? And then there's just the problem of secrecy itself. We don't know how often this happens. We don't know how big of a problem it is. And so without having our hands kind of wrapped around how big the problem is, it's hard to really know what the best solution is. And so one thing I would love to talk about in the next session, not to hijack it or anything, is what might we do, or what could we do, to Jeremy's point, to preserve the benefits of secrecy, to preserve the frankness, to preserve finality, to preserve or to prevent harassment, but also ensure that we're learning what we need to know to ensure defendants are being convicted based on what they have done and not who they are. So I'll stop there and I look forward to further conversation.
Okay, our last speaker for the day is Juan Ignacio Aquistapase from Universidad de la República, also in Montevideo. When I visited Uruguay last year, I was handed a book on trial by jury in Uruguay and some of the issues that arose. And I said, oh, whoa, who are the authors? Who are the authors? Juan Ignacio, and two of his fellow students. So very impressive. And take it away. You're the last speaker.
Thank you.
Okay.
So, good afternoon. Good afternoon to everybody. I want to thank Valerie for the invitation, so Sherry, and the Northwestern University and the IBF for organizing this event. It is truly an honor for me to be speaking among the leader researchers in the field. I feel like I know some of you already because all your work has guided me through learning about trial by juries and about the functioning of the jury system in general, justice system in general, sorry. So, well, Andres' work among them, who has supported the research about trial by jury in Uruguay unconditionally. And well, this is kind of a teamwork. A lot of things about Uruguay, Diego, my friend and professor, has already said it, so you have to kind of go back. So we have mainly 3 lines of research. The first one is the history of the lay participation models that we have in Uruguay. La Ternera case, for example, that Diego mentioned. This is kind of difficult because we don't have a lot of elements, we don't have the court records, a lot of documents are lost, and I think that some of the cases that we had in Uruguay have very valuable information. And I'm gonna talk about a particular case that has relevant information about what happens after the verdict. That was the subject that was handed to me. The second one is the debate about the reintroduction of the trial by jury in Uruguay. This is where the empirical studies began, and the Argentina's experience. That is, this is kind of see what happens to our neighbors with the trial by jury. The Argentinian experience has a lot of value to us because there are some provinces that have a lot of similitudes in their demographics and culture. So there are two iconic cases in the history of the lay participation models in Uruguay. The first one is el caso de la ternera, that you already talked about, but the second one is the Iliarte Borda case. In this case, the president of Uruguay was shot and killed, and the accused was tried by jury. He was shot right there in the Plaza Matriz. If you go to the Plaza Matriz in Uruguay, that is now a restaurant, but it's pretty much the same. So you can go and see the historic site. And talk about juries, please, because we need valid information. I wanted to mention this case because the jury acquitted the accused. And they were made, they had to say why they were acquitting the accused. And the reason was they understood that the killing was justified because of the political context of the country. But the Supreme Court at the time said, no, you are contradicting the law, and they overruled the jury's verdict. The big difference with La Ternera case is that no one talks about this case. When you talk about trial by jury in Uruguay, no one knows that the only magnicide in Uruguayan's history was trial by jury, and there was a conviction against the people's will. That leads me to think that maybe the conviction, the acquittal of someone that the people had already decided that was guilty bothers more the public than the conviction of someone they think that should be acquitted. That is very interesting. Well, the empirical research. That is the book that we published along Ailén Fernández and Nicolás López. And for kind of knowing where Uruguay stand, we did a series of interviews with qualified informants to know what were the main lines of argumentation around trial by jury in Uruguay. We found all the opinions that we could identify, we separate them in 4 positions. The first one is the one that is most interesting to me because it lacks the people that I'm sorry, I'm kind of nervous and my English is not so good. The first position is that the one that they oppose the trial by jury because of inherent qualities of the jury. They say that people that don't have law formation can decide about, can participate in the decision making. The relative opposition, they oppose the reintroduction of trial by jury in Uruguay, not but because of the system itself, but because of, organized crime, risk of corruption, or lack of resources. The relative supports are the one that said, well, the jury could work, but we are not ready yet. We need to have the the reform of the criminal procedure more advanced. And well, the absolute support is the position that thinks that Uruguay is ready to reintroduce the trial by jury, and they think that it could really benefit Uruguay. We also systematize the opinions about democracy, citizen participation, litigation, and the adversarial system reform process. The four categories that I identified earlier don't necessarily correspond about the position that the qualified information have in this section. For example, the people that oppose the jury sometimes thought that jury could benefit the democracy of Uruguay. And well, in the citizen participation section, almost all the qualified informants agreed that it could be good to have some kind of citizen participation in the Uruguay justice system. In the litigation area, the people that agree that we should reintroduce the trial by jury in Uruguay use it as a point of argumentation because they thought that it could really upgrade the litigation level in Uruguay. But this is more or less the arguments that Uruguay is managing, and those are very similar to the arguments that were used in Argentina like 10 years ago. So maybe we are in a similar path. What Uruguay needs to introduce the trial by jury, I think that the main problem in Uruguay is the lack of quality information. People don't actually know what the trial by jury is about. So our work is kind of directed that way, to generate information about the reform process in Argentina, to kind of educate all the people involved in the decision making of Uruguay in this subject. So that is kind of where Uruguay is at. I hope that I explained myself okay, and I am eager to hear your thoughts about it.
Fantastic. Okay, that's fantastic. So now we have, again, excellent. Everybody kept to their time. I love it. And we have some time for comments and questions. So who'd like to get started? Yes, Nancy.
This is a question for Daniel. I'm giving you a chance to tell us some of your reforms. You left it as this open question and we all want to know.
So one thing, and it was actually Sherry and I talked a little bit about this a few weeks ago, is what would happen if we instructed jurors that if X, Y, and Z happens, you should come forward and report it. Would that help jurors would that help bring to light some of the misconduct that is able to be remedied through the legal system, or would that lead to a culture of snitching and worrying about what people report back, or people reporting things that don't rise to the level, and how does that affect the fairness and frankness of deliberations? And so I don't actually.
I just want to point out that was my husband's suggestion.
Sorry.
And I just want to add that we tell jurors that for social media, we instruct them and say, you can send a note to the judge if you see someone using.
Yeah, and so I find secrecy hard just because it just, to the social science, like it just limits, it's hard to know how big the problem is, so how strong the solution needs to be. I think at a minimum, lawyers should be able to speak with jurors but again, given our legal system, the capacity and how resource intensive juror interviews are, it's hard to know. Or it wouldn't happen in most cases, I think, even if lawyers could talk to jurors freely after the verdict is reached. So I'm punting. But yeah, I find these questions actually really hard because I think there is true value to secrecy. But I also think secrecy may be masking some ugly things that could be happening in the jury. And I think it just masks our ability to understand what works just from principles of evidence law versus like, what are these assumptions that our system rests on that are wrong or misdirected?
Daniel, I took from your critique of Pena-Rodriguez in your paper anyway, that you thought the framing of it as this extremely clear statement, this overt statement with a clear link to motivation for the verdict needed to be softened. So is that a reform that you would suggest?
I definitely think the standard needs to be reformed, and I think there are various, I mean, you could do an objective observer, like would an objective observer hearing this statement believe this to reflect bias or something like that? But I don't think that even if we fix the standard, it doesn't fix the barriers to just getting the information to be able to raise the claim in the first place. And so those are the two things that I struggle with kind of together in that decision.
Jeremy, since you also spoke about secrecy, do you have any thoughts on this?
No, but I think that's right. It's a difficult question. Also because if you open just a little door, then you get into essentially lawyers and potentially other jurors who are going to try to open that door even more. And as you said, they're going to perhaps disclose things that they shouldn't disclose, or lawyers are going to try to make a trial of the deliberations of the jury, and then we enter into another problem, I think. So I think courts have been very reluctant and legislatures to open that door because they don't want to open the door too much, essentially.
Yeah, okay. John.
Yeah, two thoughts about research. The happy little picture I portrayed, of course, is describing the central tendency of a normal curve. In the course of our research, there was one jury trial where after the trial, more than one juror said this was terrible. We had to, try to get a juror removed who was saying horrendous things. And so I think it would be super interesting to look at those cases where, juries had to talk to the judge during the trial. So if doing that can cause something to change, but it can't after, that's really interesting. I understand why that would be the case, but I think it's an interesting research perspective. The second one is, 3 times now it's come up, some variation on, well, the question is whether it would have changed the jury's mind if, or would this have if, and it just feels like such a great opportunity, at least a research opportunity, maybe more in the long term, to run AI simulations and to work in that question into the simulation. What would have happened differently given, here's the whole transcript, everything of the trial, now introduce this evidence at this point, and run 1,000 simulations, and then start looking at the distributions and patterns. Then start comparing that with what judges said juries would do, and you could look for systematic bias in their reasoning relative to a whole, suite of different simulation models.
John. Fascinating. Diego and then Richard.
I understand that bias is a very important issue, but I also have this simple question, elemental, that, all of us are biased. It's not possible to have an unbiased jury. I think so. So my question should be, what type of bias should we consider as invalidating what the jury says? Because I don't know one person in the world that has no bias.
Yeah, and this really goes to your point, Daniel, where you were talking about, you were emphasizing this distinctiveness of racial bias, racial and ethnic bias, and how the courts really tried to cabin it. If you think about extending it to gender bias, the likelihood of absolutely outrageous things to be said about men or women by men or women on the jury, I'm sure every jury would be eligible for its verdict to be overturned. But anyway, I don't know if you have a comment on that. But
Or even if the juror said, I don't like this guy because he's a Bulls fan, And so I'm gonna convict, like, that doesn't,
That's fair.
like, that. That wouldn't make me feel better about the jury system, right? But I don't think that would be bias that would be remediated, at least under current law. And so, you're right, I think it's hard to draw lines around what kind of bias would be captured versus what's not.
Richard.
I kind of want to follow up on that. That was Justice Alito's point in his dissent of Pena Rodriguez, where he talked about this idea of sports teams. And what I wanted to bring up is this type of irrational decision making, because both of you brought up the original case that gave rise, at least formally speaking, to the jury no impeachment rule, Vase v. Delaval. But what we recall there is that case didn't involve bias. It involved a game of chance, a flipping of the coin, an irrational form of decision making. And there seems to be at least some distinction between an irrational form of decision making and one that is invidious in some sense. And we're trying to, I think in this conversation, we're trying to identify where that line is. And I'm curious because what you just said with respect to the Bulls comment, you said that might make you feel better, but that is equally as irrational as flipping a coin, as basing it in racism. So how are we troubled by the fact that it was racism, or are we troubled by the fact that it was irrational?
Don't you think Pena Rodriguez says it was because it was racism?
Absolutely, but as we're talking, absolutely,
yeah.
but as we're talking about extending these principles, as we're talking about other forms, of course, of invidious bias to others groups, but when we're talking about getting rid of secrecy, which I understand is at least in part your proposal, do we start going after the irrational?
Yeah, do you have a?
Yeah, I would.
Did you want to respond?
Because it seemed like with your Bulls comment, that's just what it seemed like you were.
I mean, I think that's I think the more irrational the jury system reveals itself to be, the more it calls out for just bigger changes to the system as it is, right? I don't think, even though I could argue that racism is irrational, I don't think they were drawing rationality lines around racism in the opinion. I think it was kind of along the invidious. And I think invidious discrimination maybe just is different, and maybe that's a line, a more sensible kind of plausible line to kind of tether to the constitutional right. Because yeah, we don't have a right to a rational jury, just an impartial one. And so I think those are different things.
Okay, Sonia, and then Rick, and Mary, and Veronica.
I'm wondering how relative definition of what racism is.
Can you speak up?
I'm wondering how relative our definition of what racism is. Under the current administration, I think there's going to be change of what is perceived to be racism, right? And how is that going to affect the jury deliberation room? And when you think about regulating that in terms of who is going to report what if racism becomes formalized and it's a part of what's expected? If you think about the jury of the peers, a certain proportion of American peers are racist.
Okay, I'm not gonna make you respond.
No, but I will. I mean, I think that's right. I think in a lot of ways, U.S. culture is in a race to the bottom. But I think the more we kind of liberalize the use of really offensive language, the less it feels so offensive that it requires this really kind of extraordinary exception to this long-held rule, right? And so if it now is acceptable to say all of these things because we're no longer woke, and so we can say things that we didn't say before, then I do think that changes what is explicit or overt bias. And I think that's right. I think kind of those terms aren't necessarily culturally loaded. And as culture devolves, the standard just becomes higher and harder to meet.
Rick, you're next on the list.
One thing we know about jury deliberations is there's a strong force to unanimity. Surely some of those people who are in the minority in earlier votes are not voting rationally. And yet in the long run, through the deliberative process, the verdict comes out that reflects the majority, which is presumably rational view, particularly if it's been a strong majority on the first ballot. So I wonder how much of this problem is sort of taken care of by the deliberative process, so that the rational people, the irrational people, in the end, just go along. Now, we do have anecdotal evidence, of course, about people who are irrational, withdraw from deliberations hung the jury. They don't prevail. And often those are not retried if it's a very small minority. So I'm just throwing it out. Suppose with this horrible racist person, the 11 other people had said, no, this guy's not guilty. Would that person even have hung the jury after events? Or would he just say, okay, if you 11 want to let a Mexican free, go ahead. But I think we have to build in, not just looking at individuals, but look at the whole process.
Yeah, you know, it reminds me of your book, Nancy, and the chapter on deliberation and the exchange of reasons as a kind of promotion of bringing citizens along into becoming jurors.
And to safeguard, because it's not supposed to be just a free-form deliberation, it's supposed to be, you're giving reasons.
Yeah. Mary?
Just a comment that I think this isn't a group that would suggest that jury decision-making is irrational regularly, since we know from data that the strength of the evidence is a great predictor of the final verdict. And what we're talking about is more, I don't want to say margins in deference to Sam's point about how often wrongful convictions happen, but we are talking about extreme weirdo cases that arise, to me, in the sense. And I actually think John's point about trying to study and learn more about when jurors become so frustrated mid-deliberation that they reach out for help is a really interesting insight into the problem. But I saw you wince, so I would like to.
I guess my wince is the flip side of kind of deliberations, right? So you could say that 11 jurors in Peña Rodriguez did not express any racial bias, presumably looked at the evidence and said, I think he's guilty beyond a reasonable doubt. And maybe those people also convinced the really racist guy to say, hey, we understand that you think he's guilty because he's a Mexican, but look at all this evidence. And he's like, yeah, you're right. I'm gonna put that out of my mind, I'm gonna look at the evidence, and I think he's guilty. Should that assuage us of the problem of the super biased juror? And maybe it should, so I don't know. So one of the examples I've looked at was a woman who started deliberations said, I think this guy is more likely to be guilty because he's from El Salvador, and Salvadorans are more likely to be murderers. But then she's like, they interviewed her, she's like, I only said that once in the beginning. Then they talked to me about, they said you can't do that. And then I looked at the evidence. And then I thought he was just guilty on the merits. And the judge said, yeah, he doesn't get a new trial because that's what juries are supposed to do. And does that, I mean, maybe that should give us confidence. I don't know that it does.
It doesn't give me confidence. It's getting back to what everyone's been agonizing over, yourself included, which is a cost benefit of you can't have both. You can't have a rigorous review of verdicts without this, door opening that Jeremy's talking about, and still maintain secrecy. And so it's a little like I am with the peremptory, which this about, like, sure, it's racist, but it's worse the other way. That I don't like being in that space, but I end up kind of in that space.
Okay, Veronica, Paula, and Jessica.
Oh my God, I have so many thoughts.
There's a whole nother hour.
But I do want to say a few things. Because as we're talking, and again, apologize, I'm not a jury expert here, but we're talking about juries, their composition, and how it's being implemented in some of Latin American countries, and the impact that it may have, which and a little bit of this is influenced by your talk, John. A lot of what I've been thinking in the last few hours is what is it for victims and also defendants? Like, is there any research, and I know this is more a question for probably the US scholars, on how juries may impact victims. These came also when, I think it was Maria, when she was talking about how in Argentina there's this province where they're using, creating juries with an indigenous component, depending on if it has to be, 50% indigenous if the victim or the defendant is one race. Anyway, how does that impact how both the victim and the defendant feel about the outcome? And this relates to the issue of procedural justice. And kind of relates to what, do we care about accuracy, the outcome itself, or do we care about how people, parties in the process feel about the process itself, even defendants? And also because it's, we know in Latin America, we have research on this, that plea bargains tend to be, defendants tend to feel coerced into taking, which mimics the research you guys have done in the US. And I wish, because I was a part of this survey project where we asked defendants a bunch of questions, and I wish I had asked them about, were you convicted by a jury trial or not? We did not include that question. I wish I had, but I know they felt coerced into accepting pleas. And I wonder, well, we cannot turn the clock, but this is a possibility, especially for those of you guys in the region that are implementing these new reforms or are thinking about implementing these reforms, about what the impact may be for both defendants and victims in terms of procedural justice. Maybe not so much, the outcome itself, but we want people to feel that they were heard, that the process was just, blah, blah, blah. And last but not least, the issue of secrecy and juries and all of these things. Also, me coming from Mexico, I wonder how to think of a jury system in settings where the rule of law is weak. We have huge corruption, countries like Mexico, where juries could be threatened and taken. This is just coming from a very Mexican experience. But how can we think about this? And this also relates to the topic that we discussed briefly on inquisitorial culture, and how can we translate this to different settings, and that may be not great for also procedural justice reasons, but rule of law in general. Anyway, a bunch of ideas there. I don't know for whom is the question, but it's
So you did ask about the impact of the intercultural or indigenous jury. Sidonie, do you have any thoughts on this, or any information about how the juries were received?
I think in Neuquén and also Rio Negro and Chacos in intercultural, the indigenous juror and the intercultural juror, they understood that the possibility of a white criollo juror deciding a case against a person from a community with a big distance in terms of social and cultural and economic situation between these communities. It's like they were trying to solve the problem of hierarchy between these communities. So it was like a guarantee for the accused to be judged by the peers, or at least a half of the peers. They were thinking more on the accused than on the victim, of course.
Okay, yeah, thank you.
Professor, can I just complement about, because in Brazil we already had also indigenous jury. Actually, even before the Argentina make the indigenous jury, we had one in 2015 that it was all the 7 jurors were also from the same community, from the same, all of the 7. And the accused, of course, it was indigenous also, and the victim it was. And what they said after these communities, these indigenous people, they said that they thought that it was a very harsh jury. They didn't like, they said that it was a very aggressive thing to these white people.
These were
this
surveys
form,
to defendants?
Yeah, the form in general, because everyone was from this indigenous society, and they said it was too much for them, they didn't like. So, they said this white people form of deciding, they didn't like. but it was acquittal, even though it was acquittal, but they didn't die.
Totally fascinating. We are squeezed a little bit on this, but let me ask Paula and Jessica to get in. We'd like to squeeze in your comments just before our break.
I'll pass.
Okay, Jessica.
Okay, I'll try to be quick. This was actually going back to when we were talking about secrecy and Daniel's responses and the idea that maybe deliberation will take care of this and maybe it's rare. I don't know, I feel like this kind of gets back to the issue of the composition of the jury. I mean, I think that it's a kind of rosy view to think that there's just gonna be one token racist and then 11 people who are all fighting this. I think you know, Sam Summers' work on mock juries shows that if you have an all-white jury, which we know in many, many jurisdictions, even when these jurisdictions have a lot of racial diversity, they end up with whitewashed juries. And he had amazing data showing that when race was brought up on even just having one other person of color on the jury, it got shut down, it got challenged, it got discussed. But when it was an all-white jury, not once did it get shut down, not once was it challenged. And I think Daniel had a great point that one person saying this, especially at the beginning, all of that evidence review can get filtered through that and have a lot of insidious impact. I mean, we know there's decades of racial disparities in the criminal justice system at every level. And I guess I'll just wrap up quickly. I was gonna rant more, but and it's easy for me because I'm not a lawyer, I'm not in the legal system. I'm saying do this big change, you guys. I don't have to deal with that. But I think that I find this conference really inspirational because I forget who it was who said a lot of radical changes are happening in other countries. And I think we are very afraid of the slippery slope of, well, if we make this change here, then we're gonna have to do this big thing and everything's gonna fall apart. And I just wanted to say, I think it would be nice if we could be a little brave with some of these, like a lot of the other countries we've seen.
Actually, that is a great way to introduce our last session, which will be on the future. And maybe there's some radical change coming. So happily, we have a 15-minute break. There's some amazing desserts outside. And some come back in here in 15 minutes. And 45 minutes of
desserts already happened.
As you munch, keep in mind there's a reception at the end.
And then they choose to quit.
While he was convicted, this was something that right here pointed out in the decision. He remember he was some charges. He was not convicted of all of them, right? Which actually further complicates this notion that he was convicted on the basis of for praise. I'm not trying to get smoking gun. But
in some sense, right?
I was gonna ask you.
Provided that
Yes, right. And then you had I go to Northwest 6 and I work in 6.
Well, they talk a lot about
Yeah, well, you're in the JD PhD.
Which is like a on
Wow.
Not with question.
All of Eastern Oklahoma
That's a good one.
You found each other. Doesn't take you long.
About 8 years ago. I murdered
that was the right hand, like legally speaking, but she always like had it. She's the type that if you wouldn't know what to do, like.
Okay, folks, okay, let's get going here on our final session of the day. So this is our final session of the day. Sherry and I have changed mics so we can wander around without having to hold the mics in our hands, so that's a big plus. But it's the final session, but I think in a way it could be the most exciting session. Because what we decided to do was reserve the last, 30, 40 minutes or so for us to have a general discussion about the future, about what we collectively or perhaps individually or in small groups might do in support of discussions and debate over trial by jury, research over trial by jury, reform of jury systems. In particular, as we were going through the day, you know, many people mentioned the kinds of things they might like to see in terms of research. I think Diego started off, for example, saying, I'd really like to survey people in Uruguay about their support or their understanding. Yeah, we vote for that. We're very much in favor of that. But also throughout the day, as people were talking about particular reforms or wondering about the impact of things like victim impact statements or private prosecutors, there was a lot of discussion about how in some ways we don't really know what the impact is of things like that. So the floor is open for general discussion.
And you also have Q&A, the little Q&A thing is.
Great. Excellent. I'll go check that in just a moment. And I'll let Sherry kind of moderate and I'll go check the Q&A.
Okay, fine. There are a number of things that are kind of in the works and other things that are not understood and other things where there are differences in different countries where they've highlighted, at least from my point of view, some questions that would be worth trying to answer. I'll just mention one that I was thinking of as we were talking about private prosecution. There are various levels and roles of private prosecution. We saw two different models in Canada and in Argentina. And there were some things that weren't discussed, like it's the extent to which the victims get to weigh in on decisions about plea offers or decisions about sentencing. And I think we need to understand more about some of those intermediate kinds of roles. There is a big complaint often in the United States from victims about not being kept informed about what's going on. So that's kind of the other extreme of non-victim participation. The interesting contrast with the common law jurisdictions that emphasize mostly the defendant's rights with less attention to victims is something that I think, it's reasonable to look at and understand better, but we don't have much data. The new data that has come in from Argentina is really some of the only jury reaction data, and it would be nice to know more from other places. So that's one that I would put on the list. It's a little complicated, but. Second one, of course, is all the different kinds of characteristics that were highlighted as potential weaknesses in the Brazilian system, right? Of jury size and the decision rule and non-deliberation. Am I not coming?
Apparently not.
Oh, I'm hooked up, but apparently, oh, okay.
Oh, yeah, it's turned off.
Oh, that's because I didn't turn it on. Thank you. Thank you. I put it in my pocket. Okay. And the virtues of non-deliberation, I suppose. I mean, just understanding better non-deliberation. On the secrecy idea, I have to confess, I'm not a big fan, but I think one of the problems is that I think that there's more ambiguity to what jurors say in terms of interpreting it as bias. And so I think an interesting thing would be to look at. We've done that a little bit, Mary and I, on our Arizona project, and we know a little bit how ambiguous some of that is. Like when a juror says, well, yeah, but men are like that. They don't indicate when they're in pain. I have 3 brothers, so I know. And what do you do with that? So I think that those are some examples. What else?
Can I make a pitch? So I think in a lot of different reform conversations, I feel like, at least in the literature I've read, we haven't found a good way to capture the perspectives of criminal defendants and how they view reforms as whether being good or bad. And so, for example, the Arizona peremptory discussion, like we know what judges and lawyers think, but I think it'd be really interesting to see like what the actual people who are on trial think about.
That's a great idea.
And you could imagine doing the same thing for all kinds of different jury reforms, about people who have to sit before the jury, what do they think about X reform or Y reform? And I think that perspective is just often missing from the conversation, so that's, I think, would be really interesting.
Yeah, I'm reminded of the work of Tom Tyler and others looking at litigants' views about the procedural justice of their hearings. But I'm actually giving a talk tomorrow on the issue of juries and procedural justice, and I have to look hard. I really couldn't find much on litigants' views specifically about juries. So I think, Sam, you said they never blame juries, and I immediately thought about Donald Trump. And last conviction, his 34 felony conviction, and yeah, he definitely, I mean, he blamed them before they made the decision.
That's what we call the exception that proves the rule.
So right, you're so
Well,
right.
he just blamed everybody.
That's true, yeah. But juries definitely were not an exception, they were definitely in there. But I like your idea of paying attention to all of the parties, not simply the individuals or the legal actors.
Yeah, I think it's such a good idea. Jessica and I did a study where we looked at judges and lawyers' reactions to choices of forms, trials versus mediation, blah, blah, blah. And I got an email from somebody saying, well, did you survey the parties? And we didn't.
Yeah, so Mary Rose.
I feel like I sit in a world where the planet is warming and I kind of don't know what to do about it. And then I also analogously feel I sit here and know that trials are really disappearing, apropos of the data from Arizona, you know, even after the pandemic, just getting them back up to where they should be is hard. And I'm reminded that just, you know, how costly trials are and have become, so that, you know, as we talk about procedural fairness and perceptions of the experience and all of that, it strikes me that we do probably have to get serious about how to cut back procedures and be quicker. I know Paula thought a lot about that in the past, about how could you make trials more efficient, more summary, more whatever. And I don't know that you can, because parties would hate that, but it's really about grappling with that or losing them, is how I'm feeling, you know? And for all the reasons that we care about jurors participating, the fact that we don't give them that venue, and the statistics are bad, you know, just in the last 5 years, it's less likely that someone says they've served. I'm just very, very worried.
Yeah, so Richard Jolly, you have anything to say about summary jury trial?
I think that's kind of the point. I think that we're balancing full-blown trials with trying to curb some of these procedures that we think are valuable, and we have to kind of make a decision about what we think is more valuable, a trial that goes on for 6 days or an actual jury trial that lasts a day. And I think that's a policy decision that we have to really grapple with. And maybe the policy decision is, like summary jury trials, giving the parties the choice.
You know, I'm reminded of the introduction of jury trials in Korea, South Korea, where they made a point of having every jury trial last 1 day. I mean, it was just an agreement. They actually distributed a little brochure to all of the juries, all of the jurors, that the parties had actually contributed to, and it gave kind of the major arguments on both sides, had the law, it had, here's the kind of evidence you're gonna see, and the evidence was taken orally, so there were witnesses and there were opening statements, closing arguments, and legal instructions. And sometimes it would be a very long day, but the jurors all deliberated until they reached a verdict, and they made sure to do that by the end of the day. It was quite an interesting kind of forcing it into a manageable chunk, so that they would not be introducing a new system that put too many burdens on especially the people who are gonna serve. And it reminds me a little bit, Andres, of the comment you made about when you introduce a new system, you might want to be especially careful in some of the features, some of the cases that go forward initially, so as not to jeopardize the entire experiment. I think Mauricio, then John, then Rick.
I have 2 points. One point is related to the last discussion. I would say first that in Latin America we will take 1 day just to say hello. But anyway, I understand the Koreans. No, but the point is that this phenomenon of disappearing of the trial is not only here, it's everywhere. And in Latin America, the plea bargaining and the functional equivalents are playing a big role too. And even in Europe, Germany, land without plea bargaining is no longer a land without plea bargaining. So it's a general context that I think it's a very important issue to understand the role of the jury trials now. So I don't know if you remember, Valerie, when you were in Chile, we both participated in a conference, there's a guy that was making a point with that changing, I think, the meaning of what was happening, but I think we should, if we want to protect the jury, we need to protect the trials in a way. And the second point to me has been very interesting in the discussion, because I'm not coming from this jury trial community. I mean, I sympathize with jury trials, but that has not been my focus of research. But I believe that in many presentations, the common point is that we now have much more evidence about some phenomena that we did not have any evidence 200 years ago or 100 years ago, for instance, wrongful convictions. We know much more about wrongful convictions than we used to know before. And we know that are more frequent, and the causes and factors that contribute to that. Or maybe we know much more about racism that we understand it 20 years ago. And maybe we are understanding the problem of less diversity in jury trials and why women had been underrepresented, so on and so forth. And probably those new challenges require to think out of the box in terms of solutions. And I think, for instance, the Argentinian solution, the parity, it's remarkable in a way that they impose something that is not in the records of the old jury systems. And it seems that it's working pretty well. I mean, the point is similar to yours. I mean, maybe we need to think a little bit out of the box in terms of solution, that maybe for the sake of discussion, even questioning the sanctity of some principles, or being maybe more flexible in terms of how we can keep them working with these new things. I mean, it's clearly that the old protection, again, wrongful convictions are not working everywhere. So the old protections are not enough. We need to increase or improve those protections, not turning down the old ones, but finding out new ways. So that's have been very, I mean, I don't have any answer about that, but this point to me has been very interesting in terms of the discussion during the day.
Thank you. Okay, John.
Just a quick empirical comment on the duration of a jury trial. We assumed going into our national study that dosage mattered, how long the trial was, how long the deliberation was, and the severity of the charges, presumably. None of that was true.
It doesn't.
Yeah,
That one passed.
the only thing that mattered was the complexity of the deliberative case, meaning how many charges were against the defendant. Taking into account number of charges related to severity, that was interesting. That enhanced the voting effect.
So because they had to deliberate, or is that the thought that?
It's more choices, and it's a more complex deliberative task. That's how we interpret it. But the point is, duration is not the key to the civic impact.
So we can maintain the democracy enhancing aspects of the jury without having the downfall of 2-week trials.
You know, there's a lot of redundancy in trials. I mean, if you sat through them, and one of the things that happens in civil trials in some places is they limit the number of experts that you can have. And I think that there may be some room for being a little more economical about length of trial, not a summary jury trial, but you know, other aspects of it.
Rick, I think you were next.
Yeah, this actually follows directly on what Sherry said. It actually proceeded in my own mind, but it seems to me we're throwing out ideas for research. A really good research topic would be a serious investigation of how much sludge there is in jury trials. How long do they last? How much is due to the judges, you know, leaving for another courtroom or leaving for something else, to early, late starts, early stops? Because it might be if we could concentrate down, you know, not the 10% that are the outliers, but the 90% of the relatively less complicated cases, to really giving the evidence to the jury, instructing them, charging them, having some stuff appear off stage like voir dire or something of that sort, or done electronically, that we're not doomed to having, you know, too much time taken by juries. We're doomed to, because we don't know what to do. So, you know, again, anybody with graduate students or money or something, this would be a great topic for research.
Well, the one thing we got out of COVID is that there does seem a movement toward having remote voir dire. That is certainly more efficient.
Washington State, according to the judges, continues to do it. They think, their view is, although we can't ever seem to get the demographic information from them, that they believe that it is a more diverse veneer of people actually showing up to be questioned. And so they have stuck with it. I mean, and people like it. You know, they like the idea of saying, yeah, sure, I'll just go on Zoom. I'll see if I'm going to be chosen for this particular jury. If not, it's kind of a modest amount of energy and activity. And then if they are, then they go to the courthouse and have a full jury trial. So that's
class and age biases in that system.
You do it the right
Well,
way.
you do it for sure.
Yeah.
But this is one that the lawyers seem to like as well as the judges.
Yeah, absolutely. So I have Sam and Rodrigo.
Well, I was gonna say a couple of things, but time, how much time things take. juries may take time, but what really takes time is lawyers. And the question is what you can do about this. And in criminal cases in the United States, it may not be very much unless we had a major restructuring, and there are two reasons. The first is the Constitution, which is interpreted, which has, this clause about self-incrimination and various other things, which are interpreted, I think correctly, as meaning the defense doesn't have to do anything or say what they're going to do until after the prosecution has finished its case, and certainly not until the day of trial. If you didn't, and second, and more important than that, this is a system which is starved for resources. And the most important place where it's starved, if you talk about accuracy, is probably police investigations, and then next after that, prosecutions, and third after that, close following the criminal defense attorneys, because all the initial investigation is done by the police and prosecutors. And having it done in a particular adversarial context in the United States makes that often very less optimal than it could be. But when you get to cases that might go to trial, in most places in the United States, certainly in most urban courts, it's very hard to minimize the jury time because nobody knows what's going to go to trial until the trial is started. And as a practical matter, you don't know what's going to go to trial until after that, because quite a few cases plead while the jury's being selected, after the jury's been selected, after opening statements. But after the jury's been selected is a big time for a lot of pleads. So the result of all this is that in a system in which neither side, neither big city prosecutors nor big city public defenders who carry most of the load have the resources to prepare well, they show up on Monday morning with 5 cases and one of them may go to trial that weekend and others won't. And if you didn't have that, if you knew which cases were going to go to trial a month in advance, even in the context of the constitutional structure we have, you can imagine a judge saying, here's how we're going to do it, and here are the 5 hours of testimony, plus or minus 2 hours you're going to present to the jury, and here are how we will deal with objections in advance. Of course, some can't be, but a lot can be. But that's not the reality that we have in a system where to do anything close to the trials, we're talking about an increase in the number of lawyers by a factor of 2, 5, 10, 20, nothing small. How to deal with that? I just don't know. I mean, summary judgment sounds like a great idea, but I hear my defense attorney friends, my defense attorney past saying, okay, what am I giving up?
Yeah, for sure.
What would you think about a deadline for settlement or plea?
So I can think of a lot of things that would work in an atmosphere of trust. And that trust means institutional trust. Because at the moment, a lot of the calls are made by institutional adversaries, which are defense attorneys, typically public defenders. But in a case, in a county where it works well, and the unit is counties. People should, I think everybody should know that. The unit is not states, it's counties, about 3,000 of them, literally. Of which about 500 or so really matter because they occupy almost all the population, maybe less.
The one we're visiting tomorrow.
Exactly, the big one, very big one. If for a long time, Albert Alshore, you might remember, who was a great opponent of plea bargaining, would point to Philadelphia as an example of how you could avoid plea bargaining by having judge trials, because there was an understanding between the defense bar, and you know what's happened to that. That doesn't, they would have judges that everybody agreed that these would be fair judges, and if you go to those judges, you can get trials, and as a result, Philadelphia for a period of time had about 3 times as many bench trials as jury trials, and the total trial rate was up to what, I don't know, what was it, 20% or something like that? Huge number for America. That was gone till 25 years ago. There's nothing like that. Sure, Philadelphia is at least as bad as the average major American jury. It just fell apart because that's not an institution you can maintain.
We have some questions from
That's it.
chat.
Yeah, so just before we take your comment or question, Rodrigo, Patty Chirco from the Administrative Office of the Courts in Washington State.
Oh.
Is that right? AOCWSCCR. Anybody? Anyway, Pierce County. Washington State. Some anecdotal evidence she can share is that in Pierce County, where we are currently collecting post-pilot data for a project during which we increased juror pay from $10 to $100 a day, judges report seeing jurors deliberating longer. Get your money's worth, right? The reasons behind this change, she says, juror behavior is not clear. It could be due to a wide range of factors.
Washington State.
All right, Washington State. Thank you very much, Patty. And the other comment that we had was from Analia Reyes, who is an Argentine scholar whose specialty is studying sexual assault cases and gender issues in the Argentine courts. And she actually had a comment to you, Daniel, about a possible solution. She likes the idea of jury instruction, a jury instruction that imposes an obligation to warn a judge about bias in the deliberation room. How do you think that would work?
That was 2 weeks ago.
I think it's better maybe than not. I think there could be issues with that too, right? I think it requires a crisp definition of bias because you don't want jurors running back and saying.
Yeah.
And then I think there might be types of bias that jurors potentially could consider, depending on the facts of a particular case. So how to carve out those situations would be really hard. But I think on balance, it'd be a good thing, but I think it might be hard to implement.
Yeah,
At the same time.
like you were saying, your spouse was concerned about jurors becoming, alter snitches or something, right? Isn't that what you were saying?
No, he was suggesting that it would be a.
Oh, it would be a good idea.
Good idea,
Oh.
a good idea.
Okay, that's all the questions for now. So over to you, Rodrigo.
Yeah, we were talking about the length, discussing that, and I think in Brazil it happens just like it says, because in Brazil, of course, we don't have plea bargain, what year deliberation, but most of the juries, and last year it happened 20,000 jury trials in all over the country. This 20,000, the majority of these, like, I don't know, 99%, it was it beginning one day and ending the same day, They have a rule for that. You have only 5 witnesses for each side that you can choose. Of course, if you have a more complex case, you can choose perhaps more, but normally you have the maximum amount of 5 witnesses for each side, and you have a time also for you have the closing arguments. It's 1 hour and a half for the prosecutor, 1 hour and a half for the defense, and after the rebut, 1 hour for accusation and 1 hour for the defense. So all of this happens in the same day. It's possible to happen, of course, but we don't have what year deliberation. It's how it happened, like almost 20,000 cases in Brazil last year.
I have a question for you. The description of the procedure you mentioned akin to a grand jury, that the judge does a finding in advance as to whether this case should go to jury trial. But my understanding is also there is the judge does a summary and there gives a document so that the jury gets, the jurors each get that input, which also.
It's a problem
Is
that
that
we
in
have there.
1 day?
Yeah, it's another critic that we have, because this summarized opinion about the judge, this decision that he's saying that there is substantial evidence to go to the jury, this is delivered to the jurors in the beginning, when they sat and they say that they are going to judge and they are accepted, they received in their hands so they can read about. And of course, it's not a good decision because a decision against the defendant, but he can read. And sometimes this decision, it's very, I don't know, how can I say, but it's very heavy for he doesn't make only the standard necessary to go to the judge. He say, oh, of course it was him, and he didn't act in self-defense. And you know, the defendant is saying, no, it was a self-defense. So the juror will read, okay, the judge said it was not a self-defense. So how can I say it's a self-defense?
What is the conviction rate?
Yeah, that's a good
Sorry?
question. Conviction
What is
rate.
the conviction rate?
A conviction rate, it wasn't that, it's 70% almost, 70% around.
70% is what we have.
Yeah, but, yeah, if Brazil has like all these guarantees that you have here, you know, I was really happy. I would be really happy because it's very hard to you know, to be a lead counsel there in Brazil, but because we don't have anything of these guarantees that you have. But it happens in all one day, and we have a lot of issues about that, as I said, like the architecture and everything that normally the judge, he's against the defendant also. And you have to, I have a lot of videos, and I can show someday or send it to you, that how the judge reacts about the defendant and everything. It's very hard to be a lawyer there.
Okay, Nancy and Daniel.
So building, Daniel wants to see more about the defendant's perspective. I want to see more from the juror's perspective. And we have, like, National Center for State Courts had a series of webinars, you know, sort of from the juror's perspective. And other reports have shown how much jurors hate waiting time, you know, that's their main complaint. And I wonder if we can think, and the post-verdict interview, which I almost spoke about at this conference, you know, that is an effort by judges to elicit jurors' response to improve, we hope, the experience for jurors, for future jurors. And I wonder if we can have more ideas on how we seek out jurors' perspectives and how we try and address the problems that they experience. Certainly the amount that we pay jurors, I don't know how to fix that problem. That's one of the complaints though. And it interferes with who gets to serve because people can't afford to serve. But I wonder if
Nancy, could you say something more about what you would want to ask jurors? Because almost every court system I know about has some kind of exit interview system. So is it that we're not learning what those results are, or is it that you have questions that you would particularly like to see?
it's not so much the questions. I want judges to meet with jurors afterwards, and it's not it's not codified anywhere. You know, again, we're going back to that discretion and that variation. So some judges do it, jurors really like it. Some jurors get questionnaires from jurors, they actually make use of them, most do not. But it's more what can we encourage on a larger scale so that it's not just the isolated. And that's so particular what we ask them, though I do want to know their complaints because I think courts can actually address some of these complaints if they knew what they were.
One of the things that our Argentina project asked jurors in this new system was, what could the judge and the attorneys have done better to make like the next jury trial a more improved experience for jurors? And we got amazing candid responses from them about some of the things that they disliked and some of the ways that the attorneys, especially the attorneys, could have improved their presentation.
Absolutely.
Yeah. We've got Daniel and Paula and Veronica.
Just another research question. This is far beyond my capabilities, so I'm just throwing it out there. The idea of summary jury trials made me queasy, but I thought it would be really interesting. So RAND released a public defense workload study about how many hours a public defender should spend, kind of given how complicated the case is on that case. And so I think it'd be really interesting to think about how long a jury trial should be for particular charges and protecting due process or protecting the defendant's rights in the meantime. Because I mean, it seems, and again, beyond me, But it seems to me if we can figure out how, through whatever, how long somebody should spend on a case, there also must be a way to replicate a study to figure out how long a case should actually take. And so as we're thinking about whether we need to make jury trials more efficient and how to do that, I think having an idea of what we're aiming for would be really interesting.
One of the issues that I've been dealing with a lot lately, and it really goes to a lot of what you've talked about and actually all day about just like the legitimacy, public legitimacy, institutional legitimacy that comes from jury verdicts. And that whole nexus between public trust and confidence and the experience of being a juror. One of the most alarming pieces that I've been picking up is that at least for judges and lawyers, at least in the US system that regularly do jury trials, are strongly in agreement that jury trials are essential to at least, the American justice system, the US justice system. Like in the high 90s of agreement rates on those. We had asked some questions from those of you who are familiar with our State of the States survey that happy to send the links to anybody. I've been replicating those questions with jurors in California for another project that I've been working on. And I have been absolutely horrified of the jurors' responses are in the 60s, which is really different from some of the public opinion questions that were being done when I first started working in this field and 20 and 30 years ago. That there's a real softening of public understanding about what juries are and what role they have. That is probably really closely tied to a lot of our sort of civics education and how do we talk to the public about what our justice system is actually supposed to be doing. And so there's not like a research question there, but I think there's like lots of opportunities for exploring that nexus about how do people actually understand what the justice system is and what it's supposed to be doing, and how do juries fit into that context?
Yeah, I don't know, I mean, the research question might be why? What are all the factors that have led to the decline? Yeah, that is disturbing. Veronica and then Jessica, you might actually get the last comment, so.
Oh, that's pressure, if anyone has a good one. Veronica is next.
I guess I have two wish lists. Like on the one hand, I would like to see more, and it's not really a research question, but it's like something that I see lacking in Latin America in general is more research produced to provide evidence for policy makers. So that we can get to a point where we have more evidence-based policy making. I hear this as a common complaint in the US, we need more policy-based, evidence-based policy making, but in Latin America, we're just like in not even diapers. There are very few attempts to do that, and I know part of it is resources, but I would love to see more, because there's so many cool natural experiments with the Argentinian case, you have all these variation in provinces, there's so many cool things that could happen for, in terms of institutional design and how to improve things, because there are gonna be mistakes in the process, but how, if research design could incorporate, more of this in the future, that would be cool. I guess in the US side, what I would love to see is more of this type of conversation between American scholars and the US as a case with other countries in the world. Since I started a while ago as a graduate student, I don't remember, so that's how old I am. I've seen a huge difference in how it was first like American is exceptional, we cannot really do comparative research, like, whatever you're doing there, like, we cannot compare to the US. And I've always thought it's a missed opportunity for not only Americans, but the rest of the world, like, there's this cross-learning that can happen, and so it's a way to also say thank you for organizing this, because I think we need more comparative conversations where the US is also seen as a case. I don't know if you thought about this explicitly as you were doing this, but this is really what's happening. Like, we are talking about the US as a case, and this is not something I would have seen when I was a graduate student 10, 15 years ago. So probably more like 15 years ago. Again, I don't remember. But anyway, thank you. So more of this.
Okay, Jessica.
Honestly, does anyone else have? I don't want to give the vibe that I always am the last word. It's a little bit of a selfish question, but I was curious. I'm really fascinated by the thing that has been coming up about how judges will often say, well, that wouldn't have mattered in a jury trial, be it a certain piece of evidence or whatever. And I was testifying in a case last year, and part of my testimony was supposed to be about how a sort of a new frontier of junk science might have affected the jury, and the judge wouldn't let me testify about it. And she kind of put the attorneys on the spot and said, have you ever heard of anyone testifying about how something would have impacted a jury? And of course, they didn't have anything at the moment. That she seemed to be under the impression that that was just inappropriate and not, but it seems like, you mentioned simulation studies that could be done. It would be so easy to run mock juror experiments of what you can quantify how much of an impact a piece of evidence would have on a jury or not. And so we're starting about thinking to do this, but I was kind of curious, just having you all in the room, if other people have, experience with that kind of, research being presented to judges. I'd assumed there would have been eyewitness or false confession evidence stuff, but
The example I was thinking of is Dan Kahan taking up the Supreme Court's claim about, no reasonable jury could have viewed that videotape. And then going out and collecting data to show, yes, they would. So that's one example.
Well, but a systematic research program on harmless error would be really nice
So
to
good.
see.
So good. Yeah, well, let's just kind of wrap this up and go to our reception. Let me just say first that when Sherry and I were planning this, I think we had an idea about what this group of people might do, and I don't know, from my perspective, it has been absolutely phenomenal. It has been so exciting to hear not only all the individual speeches, but also the interaction and reactions to the presentation. So thank you all for doing that. Sherry.
Well, I would just echo what Valerie said. There was only one negative thing that happened today, and that is the sun didn't come out. Everything else was just spot on and wonderful. Let me just say that for those of you who are, while we're all together, for those of you who are going tomorrow to the court, we do have a federal jury trial, a bank robbery that's going on at the federal court. At the state court, I'm sure there'll be a bunch of, actually the county court to be careful. There will be many things to be seen. We will leave at 9:15. There will be a bus at the entrance where you came in the building today. And that is where you need to be, because otherwise you won't be on the bus. Not even at the back of the bus. So I do have a list. I don't have all of the check marks on it. So if you haven't checked this list, I would really appreciate it if you do it, so I know what to expect. Directions to the reception. We are going to march through, and I will take you to the reception because I always say that the Bar Foundation is the key card way, and I have the key card.
Thank you all.
Dan Kahan and Don Brady.
Huh? Yes.
I saw Don just a little while ago. Dan and I need to.
Yeah, no, I love their work.
Yeah.
also just taking up that.
Some of those cases, like
They were very pleased when they came up with this.
one year.
I don't know if it works in the 2x2 kind of thing, but it's such a useful. I'm a sociologist, so it's.
Oh, the 2x2.
Yeah.
So,